All right, Ms. Rivers, are you ready? Let's see where we have an echo. Me. All right, let's get on the record in State versus Poole. It's 23 SC 190102. It is Monday, the 26th of August, and we were hoping to start at 8:30, but everyone's running a little bit late, so we can have our charge conference. Mr. Miller, good morning.
Good morning.
Your client is not here. Is he okay having you proceed with the charge conference only, not bringing jurors in, but just working through the charge in his absence?
Yes, Your Honor.
All right, then let's do that. We've got both prosecutors here. And I disseminated the draft charge last week sometime, so everyone's had a chance to look through it. What I'm going to do is jump to the areas where I have questions, and if I move past an area where you've got a question, let me know, and we'll go back to it and figure out what to do with that area. So I will remove the defendant's choice not to testify. It sounds like we'll be hearing from Mr. Poole this morning. He told all of us outside the presence of the jury that he plans to testify. So assuming he does this morning, then I'll remove the charge that you see at the bottom of page 4. That was it. That was the only thing I had as a, let's see how the trial unfolds since the time of the distribution of the draft charge. So Mr. Rao or Mr. Abate, anything in the jury charge you want out, or anything I omitted that you want in?
Not it.
All right, let me turn to you, Mr. Miller. Same question.
Yes, Your Honor. We would request credibility of witnesses, 1.31.10.
All right, if you will look at what's on the screen now, tell me what is missing from that language, which is a synthesis of the different credibility, the different relevant credibility of witness charges.
I didn't see it on
Pardon me?
I didn't see credibility.
Oh, okay. It's bottom of page 3, top of page 4.
We ask for lesser offense 1.60.11.
And what's the lesser offense that you think should be included?
The lesser offense would be vehicular homicide.
So that's in there. This actually counts 3 and 4 of the indictment, and page 7, bottom, page 8, top, includes vehicular homicide. That's the language for that.
My understanding, I'm bringing up 1.60.11, but it informs the jury that they can choose to go with either the felony murder charge, or they are able to find him, if so, guilty on only the lesser offenses. And it's not a one and done.
Okay. Good morning, Deputy Gordon.
Also, one seat, sorry about that.
That's okay. We're good. So I will tell the jury, if you look at the bottom of page 8, that your client may be found guilty of some, all, or none of the charges. And I don't know that, I don't know that vehicular homicide is a lesser included of felony murder, but even if it is, and it would thereby merge if your client was found guilty of all those things, one, you're free to argue, I assume you'll be arguing not guilty for all, but you're certainly free to argue that it would be guilty only as to vehicular homicide. And I will be supporting that argument, not in terms of what the facts show, but in telling the jurors that they may find the defendant guilty of some, all, or none of the charges. I don't think this is a case where they have to consider vehicular homicide first before they can consider felony murder, because it's not malice murder. In fact, the felony murder charge would be a finding of guilty almost by operation of law if they found, and only if they found, that number one, your client was driving, which I think is the only issue this jury is going to be working through. If your client was driving, suspect they'll find him guilty of everything. If he's not driving, not guilty of everything. But only if they find that your client committed fleeing or attempting to elude do they even get to the felony murder. So I agree with you in one part that a jury could find someone guilty only of vehicular homicide. But two, I don't think we have a situation here where one charge needs to be considered before the other, with the caveat that felony murder makes no sense unless and until a jury were to find your client guilty of fleeing or attempting to elude.
And that was all that I saw.
Okay. Then again, I will remove the language about a defendant not testifying, and you all will get a hard copy of the final version. And if something comes up during closings and you think, wait, there's another charge you ought to give, we can talk one last time about the jury charge. But mostly I wanted you to know what I'll be telling the jury so you can reference it should you choose to during your closings. Mr. Abati, anything from the state? I don't know that all our jurors are here and it's not 9 yet. We got a few minutes, but anything we need to talk about in advance of bringing the jury in?
No, and as I was just looking back through the charge, the only one I was thinking that may not be necessary at this point would be knowledge. I think, as Your Honor just referenced, the only real issue that the jurors will face will be whether who was driving at this point. And so I don't have a problem leaving it in. Obviously, I just want to ensure that it's particularly fit with the fact pattern that we're facing here.
Right. It doesn't, I think you're right. It's not one where I didn't know what the white powdered substance was, or I didn't know it was in the trunk of the car or something like that. It sounds like everyone knew car was going too fast. It's just a question of who was behind the wheel. And that's the issue before the jury. Your thoughts, Mr. Miller, about that?
I think once we hear from Mr. Poole, that it'll change everyone's mind versus that knowledge component.
Okay, well, why don't you tell me how you think that would be? He the way the facts are, he can be not liable in any way if he was in the back of the car because he wasn't driving the car. So if his testimony is going to be, I was asleep or passed out in the back seat, we don't need knowledge. He wasn't the driver. Knowledge would apply, I guess, if someone was driving but had functionally blacked out and couldn't tell how fast he was going, didn't really know where he was driving. So if that's what his testimony is going to be, is I was driving, but I was kind of blacked out, then we should probably leave it in. But if the testimony is going to be I wasn't the driver, then knowledge really, he's not liable for anything that happened if he wasn't behind the wheel. I'll tell you what, I'm going to leave it for now, but I'm going to highlight it. And if Mr. Poole's testimony is I was not the driver, I'm going to remove knowledge. If his testimony was I was the driver, but I blacked out, I'll leave it in. Okay. Anything else, Mr. Bate?
I guess my last issue, and I apologize, I didn't bring this up earlier, was a reference to Mr. Minor. There was a question that was answered to me about probation as it relates to Mr. Minor and mentoring him from Mr. Patrick, also known as Scooby. The reason I guess the state would be concerned with, and with the follow-up, it was, please, let's not talk about his criminal history in any way. And the issue is he doesn't have a criminal history.
He was a first offender probationer.
He had a diversion for marijuana back in 2018.
Okay.
Other than that, he had no history at all.
So my thought would be then that no one in closing argument or in questioning Mr. Poole explores anything about Mr. Minor's arrest record or anything like that, and we leave it as is, rather than, I don't know if you're saying I should give a charge telling the jury disregard anything about Mr. Minor's criminal history. I think if no one brings it up, it's sort of let the sleeping dog lie, but I'll hear, what remedy are you seeking?
Now that you say it out loud in public, curative instruction would not be necessary as long as it's not brought up because it's bad, that can be considered a bad character of the victim, which is not relevant under the case law at all, unless there's an issue where usually when it comes in, it says release to self-defense, and this is not an issue where that is involved. So
right, and we're not impeaching him with a conviction if it wasn't a conviction.
Right. Okay.
All right, Mr. Miller, your thoughts about any future reference to Mr. Minor's arrest for charges for, I guess, some marijuana offense?
It actually wasn't marijuana, Your Honor. It was theft of property, 2 counts, as well as unlawful possession of a gun. He was also charged with a robbery as well.
Do you have proof of any conviction of Mr. Minor?
I have the,
As in, you've got a certified copy of a conviction of Mr. Minor?
I have a certified copy of the we have a certified copy of the case, Your Honor, from Memphis, Tennessee, but it was one that he was put on a diversion program for and was still actively in that diversion at the time of this accident.
Does he have a conviction?
I mean, technically, no, because the way that diversion works is your case is not officially closed out.
I know how diversion works, right? So he doesn't have a conviction, so I am directing you not to refer to that situation anymore, either through questions you ask Mr. Poole or anything you say in your closing. Now, if you can dredge up a certified copy of a conviction, not a diversionary disposition or a first offender, I guess we can revisit that. You'd have to tender it so it's in front of the jury. The only thing the jury has heard, probably inappropriately, was that Mr. Minor was on diversionary probation, much like first offender probation. I understand it wasn't first offender, but it was diversion. So my direction is that we leave that alone and don't revisit it. The state is not asking for a curative instruction if they change their mind. And curative instruction is sort of the wrong thing. I wouldn't say anyone did anything wrong. It would just be that they shouldn't consider that little blurb that came from Mr. Patrick when he was testifying. But that's going to be the status quo unless the state asks for some type of instruction from me or the defense produces a certified copy of a conviction. Anything else, Mr. Abate?
Yeah, I got it.
All right, Mr. Miller, anything before we bring the jurors in?
Yes, Your Honor, we were giving a picture Friday. It looks like it's a screenshot of a car crash from 2019, which Mr. Poole was involved in. One, we weren't given it until Friday, but two, is not relevant. So I would request some court instruction to make sure that that is not brought up. It has no relevance for this, and we would argue that it is improper character evidence.
Okay, how are we doing with jurors?
Just one.
Okay, all right, the usual?
No.
Okay, someone different?
Yes, someone different.
Okay, all right. Mr. Abate, what's the photo about and how are you planning on using it?
For impeachment purposes, Your Honor, I think it was clear as it came out through the testimony of Dr. Connolly as related to the defendant's prior medical history and history as it relates to, I think he said car accidents or car crashes and traumatic brain injuries from the past. Part of the evaluation was asking about all of those topical areas to which the defendant did not disclose or answer the negative, making it impeachment evidence as it relates to answers in which he gave to Dr. Connolly, which led to his eventual conclusion as it relates to his medical diagnosis. So I think it's impeachment evidence. I did get the photograph after I was given the photograph to myself by the family. It was not in the state's possession. It was actually given to me by Tamika Martin, who had taken a screenshot of Mr. Poole's Facebook post where he is posting about the car crash from October of 2019.
So it's actually a Poole posting, his own posting that someone obtained. You got it Friday and handed it over as soon as you got it. Okay. What's your response to that, Mr. Miller?
Your Honor, there was no testimony, or in order to impeach Mr. or Dr. Connolly on that photo, I believe there would need to be some testimony or some kind of indication that he had a brain injury at that time. And given the testimony of Dr. Connolly and his evaluation of the medical records that were in this case, there is nothing to show that there was any brain injury at that time from that accident. Simply because you have an accident doesn't mean you have brain injury. That's not the...
Well, you're playing a little fast and loose with Dr. Connolly. I mean, his testimony was being a 15 on the Glasgow doesn't mean you didn't have a brain injury. And if you're, I don't know anything about the accident, but if you're going more than about 5 miles an hour, I think he's going to tell you, Dr. Connolly, all that soft tissue in the brain, the brain is going to strike against some part of the skull, and there could well be a brain injury. So I think it's going to depend on how your direct exam goes. But I think it is fair for the state to ask Mr. Poole, should he choose to testify, if there were other incidents in his life where he could have had a brain injury. And if he says, well, I don't want to talk about it in front of him, he's going to answer however he answers, but he opens and closes doors based on his answers. But I don't see how it is irrelevant. It is later disclosure, but it was disclosed to you as soon as the state got it. And since we're dealing with information concerning, hold on one second. Ma'am, are you here for the plea and arraignment calendar?
No, that's...
No, okay. We have a calendar going on at the same time, and it got moved to another courtroom. So if you had court today, you don't, so you're welcome to stay. But if you have court today, you're supposed to be in 7E rather than 8D. Great. I don't know if this young lady was... Great. You should go to courtroom 7E as in Edward. So one floor down. So, I think that I don't understand why.
Under that logic, Your Honor, the state would be opening the door up for that accident to come in. I still don't see the relevance of a 2019 car crash. And what it's going to show, or the prejudicial value, is if he got into a car crash back in 2019, he got into a car crash in 2021. It's kind of the same thing that they did with Jadrian Tate, where it was, if he was driving fast while they were going to the Airbnb, then he is a person that drives fast. This is a backdoor tactic that they've been using throughout the trial to get inadmissible evidence in front of the jury. Strongly object to that picture coming through.
All right, not just a minor objection. One, there was nothing inadmissible about the video that got in through Jadrian Tate. Your client said what he said. But Mr. Miller makes a good point. What's the relevance of an accident that occurred before this one? I thought there was going to be information that after the 2021 accident, there was some potential head trauma to Mr. Poole that he didn't disclose to Dr. Connolly, making Connolly's diagnosis a little problematic because he was attributing whatever conditions that he was able to recognize through a 45-minute Zoom interaction solely to the April 21 accident. And if there had been a 22 or a 23 accident, or playing football and got his head rung by a linebacker, that those are things that could have caused amnesia or any of the other things that Dr. Connolly described. But the amnesia wouldn't have been caused by something that occurred before the accident in this case.
But there also, Dr. Connolly also described several other, I guess, indicators of traumatic brain injuries and the effects that traumatic brain injuries have on individuals. The point of, I guess, referencing his history prior to and after the accident is to show that what really was to impeach or discredit Dr. Connolly, in the sense that he is saying that the traumatic brain injury that he allegedly has diagnosed Mr. Poole to have as a result of this accident on April 9th, 2021. And the point of it is we don't know that because the defendant didn't disclose all of his injuries. I know of an accident that occurred in 2019. I also know of an accident that he had after 2021.
Okay.
He was smart enough not to post about the car accident that he had following the April 9th of 2021 incident. But the point is that Dr. Connolly specifically has found that the traumatic brain injury it relates to what occurred on April 9th. And we don't know that's the case because he didn't disclose the things that happened before or after. And more importantly, Dr. Connolly's diagnosis was 3 years after the incident. So he has absolutely no idea if the traumatic brain injury originated with this 2019 incident, 2021 incident, or the one that happened after the 2021 incident.
Sure, or if one aggravated another. Okay, do you intend to argue in any way during your closing that Mr. Poole must have been driving here because he gets in accidents all the time?
No, I have absolutely no intention of arguing anything that relates to he has the propensity, he committed he was driving and caused a rollover accident in 2021 or 2019, so he must have done it in 2021. It merely as it relates to discredit the defendant's, I guess, statements that he made to Dr. Connolly as it relates to Dr. Connolly's diagnosis. Because the point of Dr. Connolly's testimony, I believe, is either to say that Mr. Poole never made the statements to Mr. Clark, and that that Trooper Clark is lying, or if the statements were made, it's because he was doing it because he wasn't in the right state of mind and wasn't coherent and didn't know what he was saying.
Okay. Mr. Miller, anything you want to add?
Nothing additional, Your Honor.
Okay. All right. Mr. Abate, provided that you keep your argument cabined to evidence of other accidents go to either. That's okay. I didn't realize you two were talking. I didn't look up. Evidence of other accidents goes to either Mr. Poole's credibility in his interactions with Dr. Connolly or the validity of Dr. Connolly's conclusions. I'll allow that in, provided that photo isn't unduly inflammatory. I appreciate it's taken from Mr. Poole's Facebook feed, so he posted it, but if there's blood everywhere and this and that, that's not where we need to be going. I haven't seen the picture. Thank you. Okay. So under those circumstances, I'll allow that in over objection, but it's important that you stay within that lane, so to speak. It sounds like you intend to. How are we doing with jurors? Everyone's here. All right. Ms. Hill, you are on the Zoom. Did you or did someone you know have court today?
Yes.
Okay. That calendar is on a different Zoom. I'm going to send you that Zoom information through the little chat, okay?
Okay.
It's being held by a different judge in a different courtroom.
All right.
Hold on one sec. Yeah, someone's on this Zoom and I'm going to just send her to the other Zoom.
Okay, I sent them an email as well.
Okay.
They can't come through this board.
No.
Okay, thank
It's
you.
not, is it the same Zoom link, as on Friday, or is it different?
Are you talking about today's?
Yes.
I'll give you today's, but we have multiple today because I was supposed to have court today and we had to move that to a different judge. But let me help Ms. Hill here first. Okay. All right, Ms. Hill, you should have in the chat the Zoom link for the calendar you're trying to get to.
Okay.
All right, once Ms. Rivers comes back, we'll bring everyone in. Pardon me? Okay.
The 30th, Last Friday,
Pardon me?
very kind. Last Friday.
I don't know when we're doing it again.
Oh,
Yeah, we didn't do it and Deidre reset it. I just don't know when she reset it for.
yeah, very kind.
Today? Well, we've got a 1 o'clock that's supposed to go all day, all afternoon. Yeah, and we'll see where we are. All right, Ms. Rivers, you ready? Mr. Bate, ready for the jurors?
Yes, sir.
Mr. Miller?
Yes, we're ready.
All right, let's bring them in, please. Mr. Rao, you need the link for today's?
Yes, sir.
Okay,
That I do too.
okay,
Me as well.
okay, everyone. Let me see what I can find.
All right, for the jurors.
Thank you, Deputy Gordon. Good morning, ladies and gentlemen. Welcome back. Happy Monday. Appreciate everyone being here on time. We started at 8:30 and took care of a bunch of stuff and are ready to go. Everyone else can be seated. As you hopefully remember, we were in the midst of the defense presentation. Mr. Miller had been calling witnesses, and he told us he had one witness left. Mr. Miller, if you'd call your next witness, please.
It's trying to defense will call Mr. Kenneth Poole for stand.
Mr. Poole, come on up.
What's it, we got the record right here? As well, affirm that the testimony you reveal truth or truth. Truth of God. State this right now, bro.
My name is Kenneth Poole, Kenneth. Last name Poole, Poole.
I'm sorry. Yara, did you send the link for today?
It's on its way.
Excuse me, Judge.
Pardon me?
Say unmute. Oh,
Yeah, hit stay muted. Thank you. All right, Mr. Miller, when you're ready.
I need the link to share.
Well, I'll send it. Can you start your questions?
Poole, what do you do for a living?
I'm a barber.
And how long have you been a barber?
I've been a barber for like 6, 7, 8 years.
Where are you from?
I'm from Memphis, Tennessee.
Do you live in Atlanta?
No, sir.
Where do you stay?
I stay in Memphis, Tennessee.
Do you know a Devin Jones?
Yes, sir.
All right. How did you know Mr. Jones?
It originated, we met each other off Facebook back in 2019. I ain't really meet him until 2020. Like this when I actually seen him in person.
And, Mr. Minor, do you know Mr. Minor?
Yes, sir. The same exact way. 2019. Like we build it's like us young barbers. All those young barbers try to stick together. So with that being said, we met each other on Facebook in 2019, and we originally met in 2020.
When did you begin, or did you begin working with Mr. Jones?
Yes, sir.
And when was that?
Early 2020, we was working at my sister's shop. It's called K-Doll.
And how long were you all working together at K-Law?
I probably want to say it was right when the pandemic started. So not probably like 4 or 5 months. I had left and took off to Scuba Shop.
Okay, and is that in the game?
Yes, sir.
You began working at in the game, who all was there?
It was 8 barbers, 4 on each side. So started off on the right side. I want to say it was Scooby, Zero, House, me. On the opposite side, it was Brandy, Spud, DT, and Jay Jones.
All right, at what point did Mr. Jones join in the game, Barbara?
Probably a couple months after Dentarius left because he actually took the chair where Dentarius was working it.
All right, was that chair near yours?
No, sir, it was on the opposite side.
The way you all were cutting your hair, your chair would have been opposite of where Mr. Jones' chair was.
I want to say I was all at the end on the right side. If when you first walk in the shop, I'm all at the end on the right side. And Mr. Jones, he originally took Dentarius' spot, so Dentarius was the second chair on the left hand side.
Mr. Going to this incident, the day before you all left to come to Atlanta, how late were you working?
I was working late until like ladies probably like 12:30. I had to make sure I cut all of my clients who had booked for that weekend. I had to make sure I have gas money and spending money.
Right, so if you were going out of town, was it uncommon for you to work late, the day before?
No, sir. Like I say, I have to make sure I have to cut my Memphis clientele before the week before, because they still need a haircut during the weekend.
So you're at the shop till about 12:30 a.m. the day prior. That the day that you all left for Atlanta, what time did you have to be up?
Say around about 10:30, 11 o'clock. I had to cut one client before he actually went to work.
Hold on 1 second, see what that is. Sorry about that. Someone wasn't muted. Back to you, Mr. Miller.
How do you know that you had to cut that client's head before you left for Atlanta?
Like I say, once again, he had to go to work at a certain time, so I made sure I cut him before he actually went to work.
After you cut that client's hair, that morning, what did you do next?
Made sure I ran past the house, made sure I got all my bags packed, made sure I had everything in pocket, made sure I called out, made sure everybody was in pocket.
When you say in pocket, what do you
Like on time, like ready to go, because we was on a strictly schedule.
why was that schedule so strict?
Because like I said, I had clients to cut in Atlanta at a certain time. I was trying to make it that time limit.
You all, what time were you all supposed to meet to leave for Atlanta?
Everybody from the shop was supposed to meet up like around 2 o'clock, one or 2 o'clock, something like that. Scooby House them end up leaving first because I always say, y'all young folks can't never be on time. So with that being said, me, Brandy, EJ, Rob, we was finna take off. We was at the gas station filling up.
This gas station, is it in Memphis, Tennessee, or where?
It's in Memphis, Tennessee, right by the highway.
So you did not say Mr. Jones' name. Was Mr. Jones originally there when you all got to the gas station?
No, sir, Mr. Jones, the day before, Mr. Jones said he was gonna get a rental car. So I called him early that morning to make sure he was getting a rental car. He was like, he was at the airport trying to get a rental car. He couldn't get a rental car at the time. He called me back, like, as soon as we finna pull off, he called me, was like, asking me, can you ride with me? No problem. Just meet me at the gas station.
Did he eventually get to that gas station?
Yes, sir.
And what did you do next?
Made sure like once everybody was out the store, we took off.
Right, who was in the car with you when you all left for Atlanta?
It was just me and Mr. Jones, me and Devil.
And how many cars were you all taking in your care?
It was like I said, it was only my car, and it was a brand that had rented the car.
In the car with Brandon?
Brandy, EJ, and Rob, and she had a little monkey. So Ice is the name of the monkey.
A monkey?
Yes, sir.
Like an actual monkey?
An actual monkey. It's a tiny monkey.
Ice?
Ice. That's her name.
One of those like finger monkeys that you had with her?
When you say finger, it was a small monkey. It wasn't that small though. It was a small monkey for sure.
It's not like a stuffed animal. It's like actually something that could be on your shoulder and
Actually, if the monkey was here, it'd jump from my shoulder, your shoulder, to everybody's shoulder, like an actual monkey.
okay.
Now, on the way to Atlanta, did you all stop?
On the way to Atlanta, yes, sir, we had to stop. Like we always stop in Alabama to make sure we get gas for sure.
All right, so did you fill up when you got to Atlanta? I mean, did you fill up in Alabama?
Yes, sir.
And how long is that drive from Memphis, Tennessee to Atlanta?
Say 5.5 hours.
Got to Atlanta, do you know approximately what time it was?
I want to say around 9:30ish.
And your memory regarding this, what is your memory from these events, the day prior, the day of y'all leaving? What is your memory based off of?
Like I say, when I first started in Atlanta, my cousin, I had to cut my cousin her Instagram, pictures, stuff like that, things like that.
All right, and those pictures are timestamped.
Yes, sir.
When you got to Atlanta, you said you stopped at your cousin's house, correct?
Yes, sir.
All right, what did you do at your cousin's house?
I had to cut my little cousin and her fiance. It took me like 35 minutes at the most, just off the top, because my little cousin, he just got to line up. It didn't take me no time. I'm used to cutting his hair. It's like if I'm used to cutting a person's hair, it don't take me no time. But somebody new, I try to give them a time base. I try to give them act like their haircut the most important thing for sure.
So you could actually cut two people's hair in 35 minutes.
Yes, sir. It just depends on the type of haircut they get. Like I say, my little cousin, hairline front, hairline in the front, back. They don't take not even 8 to 10 minutes. Her fiance, he's low hair. No, not crack a joke or anything. He barely has hair. So it didn't take me a long time. I just knocked them down, take them up.
What you said is you had some other clientele in Atlanta. Who else did you have to cut? Who else's hair did you have to cut when you got to Atlanta?
The original plan was to cut Kivo Money's hair. Yeah, he's an artist based out in, he's from Memphis, Tennessee, but he just had moved to Atlanta at the time. I had to cut him and his chef hair.
All right, when you say an artist, is he a hip hop artist?
Yes, sir.
Okay. And so your original plan was to come to Atlanta and cut Kivo Money's hair first, correct?
Yes, sir.
Why did those plans change?
Like just away from Memphis to Atlanta, my cousin was like closer than Kivo Money's Airbnb. So I stopped. It wouldn't make no sense of me going to Kivo Money, then going all the way back to my cousin's house.
The cousin that you're talking about, is this the cousin that testified earlier today? I mean, earlier in this trial?
Yes, sir.
It's her Adriana.
Adriana Lewis is her name.
Lewis.
Yes, sir.
And she testified earlier that she stayed in Cobb County. You remember that's where you cut, your cousin's head at?
I wouldn't be for sure because I'm not for sure with Atlanta like that. I use GPS.
Okay, now, when you got to, when you leave from cutting your cousin's hair, and your cousin's fiance's hair, what did you do next?
After we left, then that's when we had went to Kivo Money's Airbnb to go cut. Well, I had to go cut Kivo Money's hair. And the shelf, I lined them up. Like I said, they probably like take no more than 45 minutes at the most. Devil had roll with me. Cause like I said, he was in the car with me the whole time.
Was he riding in the passenger seat at that time?
Yes, sir.
At any point during that journey, did he leave the passenger seat?
No, sir.
When you all get to, Kivo Money's, to cut hair, how long did it take you to cut, his hair as well as the chef's hair?
Like I said, 40, no longer than 45 minutes.
All right, now why did it take longer, there to cut two heads instead of at your cousin's?
Cause like I originally stated, I'm used to cutting my cousin and her fiance hair. Kivo Money, he's a hip hop artist. Like one mess up, they can ruin my whole career. Like he can get on the internet and ruin my whole career. So with that being said, I have to make sure I take my time with him for sure. As far as the shelf, I've been cutting the shelf. The shelf didn't take me no long time. This how I originally got that play. Well, when I say that play, this how I originally got Kivo Money as being my client because he was the shelf for Kivo Money. So he was like, I got a barber that's coming, they can come down here to Atlanta and cut your hair.
Do you know approximately what time that you cut Kivo Money's hair and the chef's hair?
Probably at the like 11:30, 12 o'clock at the latest.
And after you cut his hair, what did you all do?
I was packing up my stuff. That's when Devo had said, he asked Kivo Money, can we go attend a listening party with him? Kivo Money said it was fine as long as we had our own transportation.
Well, go to that listening party.
Yes, sir.
Okay, so at this point, you've been up the night before until 12:30 cutting hair. And you got up that morning, cut hair again, and then made a 6-hour drive to Atlanta, correct?
Yes, sir.
Make sure I'm getting everything right. You got to Atlanta, it's after the 6-hour drive, and you cut two people's hair here, and then cut an additional two people since you've been in Atlanta. Is that correct?
Yes, sir.
And now you all are going to a listening party. Is that also correct?
Yes, sir.
You said that is roughly about 11:30, 12 a.m. at this point.
Yes, sir.
How long were you all at that listening party?
I don't want to say no longer than 45 minutes because I know for sure the album probably was like 38 minutes. And I can remember him had talking with his manager that was doing like, I want to say like photos with fans, signing with fans, stuff like that. So sorry. You want me to repeat what I said? Okay. Yeah, no, I was done. Yeah.
Okay, and so you said you remember him playing the entire album as well as taking photos with fans, correct?
Yes, sir.
All right. What did you all do next?
When we left there, they had stopped at the store.
Who was that?
Kivo Money now. Him and his entourage. We followed them to a store. They grabbed a couple things at the store. I just told Chef B that I was gonna get back with him when I got back to Memphis.
All right, the store that they stopped at, what kind of store was that?
It was like a gas station.
Was it a gas station or was it like a gas
It
station?
was a gas station.
All right. What was the purpose of them stopping at the gas station?
Like I said, they was grabbing items from the store, like if I'm not mistaken, ice, things like that. I couldn't really tell what they was grabbing. I just know I told Chef B I was gonna get over him when I get back to Memphis.
Okay. Did you get gas while you were at that gas station?
No, sir, because I was probably at a half a tank. Like I just recently got gas in Alabama, so I still had some gas in my car for sure.
So you all left the gas station and where did you go?
Left the gas station. We was on the way to Scuba Airbnb.
I'm showing you. It's already been marked as defendant's exhibit 19. Actually, let's go here. After you went to, after you left the gas station, where were you all going?
We had to go to the Airbnb where Scooby house, Brandon, where everybody was at.
At this point, it's, well after, 1 AM, correct?
Yes, sir.
And what do you remember happening next?
That's when Devin had called DT trying to see the location. It ended up getting the location through, I want to say, show your location. We pulled up. Once we pulled up to the Airbnb, we were trying to see like where actually that was it. DT, when we pulled up, then Terry was hanging out the window showing us where they was it.
It was he was already at the Airbnb at that point.
Yes, sir.
All right, I'm showing you what's been marked as Defendant's Exhibit 19. There's also another video on Defendant's Exhibit 19. We're going to call Defendant's Exhibit 19B. Have you seen the contents of Defendant's Exhibit 19B?
Yes, sir.
Do they accurately reflect the events that occurred when you all got to the Airbnb that morning?
Yes, sir.
Any changes or alterations?
No, sir.
At this time, defense will move to enter Defendant's Exhibit 19B.
Any objection to 19B?
I guess no, I'm not sure what 19B exactly is, but
Well, let me ask a couple questions. So, Mr. Miller, we admitted 19, which was the thumb drive. I think you previewed back then, hey, there's a second video on there. 19 is we've been calling it, but I think I'll call it 19A going forward. We learned through Ms. Jefferson, that was the video of what was going on at the lounge.
Correct.
Okay, and so that's 19A. Are there only 2 videos on 19? And so now you're trying to tender the second video, which Mr. Poole has described as a video of what was happening at the Airbnb.
That's correct.
Okay, and he's authenticated it and laid a foundation for it. So I'll allow it in.
I have no idea.
Okay, it's in.
All right, Mr. Poole, can you see 19B?
Yes, sir.
All right, what are we seeing before I hit play? What do we see in 19B?
All right. Oh, we see DT hanging out the window.
All right, now looking at 19B. The second video, is this taken from inside of the Airbnb?
Yes, sir.
And who all is at the Airbnb at that point?
Me, Devin, DT, Scooby, Brandy, House, Spud, Jay Jones.
And looking at 19B, was this prior to you all going out again that night or that morning?
Yes, sir. They was getting Scooby up. As you can see in the video, Scooby looked like he just getting up. He like he was tired. They was just getting Scooby and House up at the time.
All right, now also looking at 19B, you tell the jury, what are these dashes at the top of this video?
This.
Right here.
I'm trying to see on the bottom of the screen. There's either Facebook or Instagram. This Devil Live story.
That his live story or his video that he posted?
No, that's not live at all. This is story.
Story.
Yes, sir.
So how does stories work?
Or this story, you can just upload something to your, you go on Facebook and Instagram, just upload something to your story. It could be recent, it could be old.
Now, do those dashes indicate other videos that were posted?
Yes, sir.
The video that we saw in the very beginning of the trial, would that have been before this video was shot or after?
Yes, sir. That video was they showed earlier during the trial. It was just me and Devil in the car. That was right after the Kivo Money. It was either before or right after the Kivo Money listening party.
All right, and going back to that video. What is it? Going back to State's Exhibit 143, we see a portion of the video right here. What is that, Sean?
The artist I was just telling y'all about, Kivo Money.
That at the event that you all, the listening party,
Yes, sir.
in that very next video that we see, what are we seeing in that video?
Me and Devin in the car at the listening party.
At the point that you all had left the listening party, who all was in the car with you?
Just me and Devil.
Know where DT was at that time?
They was waiting on me and Devo to come from the listening party, so I guess he was at the Airbnb.
Now, once you all got to the Airbnb, we saw where Mr. Minor was hanging out the window. What happened next?
Once he was hanging out the window, that's how we know where the Airbnb was. He came down and got us up. Once he got us up, by the time we walked in the door, Scooby and House, that was up. We was ready to go.
You know where you all were going at that point?
No, sir. Like the big talk was they just were trying to do something because they were just trying to kick it. Everybody at once was just trying to kick it.
Have you eaten at this point?
No, sir.
You get to that Airbnb, where do you all eventually go?
To a bar, a lounge, some type of lounge. The closest thing that we seen that had something look like it was something going on.
And you know where this bar or lounge is in Atlanta?
No, sir.
Do you know approximately what time you all got there?
I'd say 2:10, something like that.
How do you know that it was around 2:10?
Like I said, we called my Instagram. When we first got there, DT had my phone. He was recording everybody that was there at the time, and he made sure he tagged everyone. So I just went back to Instagram, looked at the timestamps.
I'm showing you the 19. Our defense exhibit 19, what's the first thing that?
So this is, we're gonna call it 19A now, since you've called the other one 19B, just for record's sake. It was admitted through Ms. Jefferson, but this is 19A. Thank you.
Defense exhibit 19A, what is the first thing that you see?
See, the interiors. It was on my Instagram. Like I recall, he had my phone. He grabbed my phone and just recorded everyone.
All right, now, the wording down here is a little unclear, but what exactly is that wording that you see?
Like I recall, it's everyone who was there that night. He tagged everyone.
When you say tag, there's a way to show, I guess, what's a tag?
Tag, just say for instance, if I'm recording you on your friend on Facebook, Instagram, @Stephen Miller, it's gonna tag you. So with that being said, it's gonna notify you on your phone or your account, and also on my account.
All right, so the tag is going to notify that person that they were tagged in the video, but on your phone, it's also going to show that that person is tagged at that time, correct?
Yes, on your phone, they'll say Mr. Poole tagged you.
All right, I'm showing you defense exhibit 21. You recognize defense exhibit 21.
Yes, sir.
Were you the one that took those screenshots that were in defense exhibit 21?
Yes, sir.
Or have they been changed often in any way?
No, sir.
They accurately reflect the tags and the time that those tags were taken for that video.
Yes, sir.
At this time, defense will move to enter defense exhibit 21 into evidence.
Any objection to defense 21?
How many pages is defense exhibit
I don't know, you have not been shown defense 21?
3 pages that I was shown earlier.
How many pages is it, Mr. Poole? That the document you got in front of you?
Just everyone.
No,
4.
4 pages. All right, no objection. I'm gonna give you a stapler. Do you mind stapling it? Or I can do it for you if that's easier. I just want to keep it all together.
Please. Thank you.
That's cool. If you look at that screen, what are you seeing from Defense Exhibit 21?
If you can pay attention, it's at April 9th, 2021. You mentioned Scooby World 901 in your story.
Could you circle on your screen, where Scooby was mentioned in that story?
How do this?
So tap the screen once and then see the little circle. Oh,
Right.
nope. Try again. Tap the screen again. All right. See, there's a circle in the lower left-hand corner that has what looks like a pencil in it. Tap that. Now it should work. So there we go.
Now, what time does it say that, Scooby was mentioned in that story?
2:05 a.m.
On another page from that exhibit, it says, what's the person, well, first off, for Scooby's handle or IG name, what was Scooby's or Mr. Patrick's IG name?
I think Scooby World 901.
That's what was tagged at, 2:05 a.m.
Yes, sir.
Showing you another page from Defense Exhibit, 21. Whose IG, is that at the top?
That's Brandy's Jefferson.
All right, and what was her IG name?
Brandy J. I can't even tell the last part. I can't even tell the last part. Oh, it's X. Oh, I don't know what she was trying to say or what she was trying to spell. But I know for sure it's Brandy, because at the top where it say hardest female barber, I actually gave her the name.
And where it's the April 9th, what time is it that it shows, that you tagged Brandy?
You want me to circle it? Let me say April 9th, 2021, 2:05 a.m.
All right, there's another page. Whose IG is this that we're looking at?
DT IG.
And, what was his IG name?
DT the Chopper, 1907.
And what time did you tag him in that video?
It's April 9th, 2021. He actually tagged himself. 2:05 for the time, a.m.
And finally, whose IG page is this? Or whose IG name is Young Risk Guy?
His IG name is Eclipse. That's EJ Eric Harrington.
What time was he tagged in that?
Same time, April 9th, 2021 at 2:05. Want me to circle it out?
Now, what happened while you all, were at the restaurant. What happened next?
When we first walked in, I can remember me ordering food because, like I stated earlier, I haven't ate all day. Made sure I ate some food. We was just really kicking it, smoking. I can't recall us drinking at that spot at all. Not to my knowledge. We smoking for sure though. Um, Probably was there 45 minutes. That's when house was like, they started putting tickets on cars, so everybody started leaving out. At that time, I gave Nati my keys, tell him go get the car.
And what happened next?
So I had went to the front where the food place was at, where the food area was at. Waited on my food. Last person I seen outside the bar or grill, wherever it was, lounge. Last person I seen was Brandy. I was like, sis, wait on me, please.
You call her, was it sis?
Yeah, that's my sister.
You refer to Brandon as your sister?
Yes, sir.
All right. And what happened next?
We waited. The food didn't take that much longer when she waited with me. So as soon as I got my food, I started eating. Like while we was walking out the club, man, I was eating on my food. Walked out the club, seen Scuba outside. He wanted some of the wings. Me and him was joking. I was like, nah, you can't get none. He still got some anyway. But us three finished my plate of wings for sure before I had got in the back seat of the car.
So outside the bar, grill, lounge, restaurant, we don't know what it was exactly.
Yes, sir.
It was you, Brandy, and Scooby, correct?
Yes, sir.
To your knowledge, where had Mr. Minor and Mr. Jones gone?
They had went to go get my car.
Your knowledge, where did Mr. Corey Williams go?
He had Corey, House. I can't call him Corey. House was the first one actually went out the building because he's the first one who noticed the ticket. So he was going to get the truck.
The truck he was getting, was it his truck?
No, so it was Scooby truck.
And the car that Mr. Minor was getting, was it his car?
No, sir, it was my car.
That unusual.
No, sir. Like I stated earlier, in the game bar shop was family or like we was a family for sure. Like we probably treated each other more than likely than I blow it for sure because we with each other 24/7 all day.
You said 24/7. Going back to the barbershop, what were the hours for the barbershop?
The barbershop what made in the game so special. First barbershop in Memphis, Tennessee, that was 24 hours. Like it don't matter what time. Like as long as you had a client, everybody had keys. So as long as you had a client, you could come in the barbershop 4 o'clock in the morning, 5 o'clock, whatever time you felt like it, as long as you had a client. Because it was a 24-hour barbershop.
It wasn't unusual, like you stated before, for you to be at the barbershop until 12:30 a.m.
No, sir. Like sometimes we get done cutting hair. Like I say, we a family. We just kicking it. So sometimes we'll just be at the barbershop just kicking it, chilling, talking about next plan.
When you all going back to the restaurant, bar, grill, lounge, when you all leave outside, and you and Scooby are out there talking with Randy, what happens next?
My car pulled up. I jumped in the back seat, right behind DT.
And where was DT located in that car?
Driver's side,
Where was Mr. Jones at the time?
passenger side.
What all was in your car?
I had book bags, duffel bags. Devil had his bags. I had clippers, ring lights, just all types of stuff. My personal belongings that I had because it was my car, so I had some personal belongings in the trunk.
Where were all the book bags and duffel bags located?
In the back seat towards the passenger side. Like I know for sure I was laying on a duffel bag. My head was laying on a duffel bag while my body was on top of my butt was on the seat.
Now, before we get to there, Mr. Harrington, EJ, testified that he was about to get into that car. Did he also have some things in the car as well?
Yes, sir. He had his slipper case.
And had you all, had you had a chance to drop off any of your bags or duffel bags or anything?
No, sir, because when we first made it to Atlanta, I had stopped in my cousin's house, Kilo Money, listening party, Scuba Airbnb, strictly to the lounge.
Where were you supposed to stay that morning?
Anytime I come to Atlanta, I go to my cousin's house. But that night, I was gonna actually stay with DT, Brandon. Like, I was gonna stay with them.
So where they were going to stay?
No, sir. Like EJ, Rob had an Airbnb, so I guess we were finna go there. It was gonna be me, DT, EJ, Rob, and Devo. We was gonna stay at their Airbnb.
Now, you said that you, ate your wings. Did you finish your wings before you got into the backseat of the car?
Yes, sir.
And, at this time, said that, all this stuff was in the backseat of the car, correct?
Yes, sir. That's the reason EJ couldn't get in.
All right, so how were you able to lay down? And if we could, Your Honor, can I ask him to step down for demonstrative?
Okay.
We'll say that could Mr. Poole step down?
Mr. Poole, make sure you speak up if he's asking you questions while you're out there, just so Ms. Rivers can hear you.
All right, we'll say that this is.
Can you take the screen share down before you do that? Thank you.
All right, we'll say that this is the backseat of the car. This is the driver's side that you got in, and, the backseat of the passenger. Did you show the jury how you were laying down in the car?
Foot legs on top. Stretched out as far as it could be. I'm laying on the legs.
Don't fall. This is a rolling chairs bad plan. So
On top of the door, one foot laying down, one on top of the base, my head laying on top of the base, my bottom on top of my seat. So with one said,
So duffel bags, book bags are all right here on the right side of the car behind, Mr. Jones, correct?
yes, that's like the pillow, feel like a pillow to it.
All right, you sit down. As soon as you got in that car, what did you do next?
Just went to sleep because I was up from 12:30 that night or the morning before. I've been up all day. I was the original driver from all that day. So that's my reason of letting DT drive my car because he's not like, it's not the first time he drove my car.
Was Mr. Minor also more familiar with Atlanta at that time?
At that time, I say he was more familiar than me and Devo for sure because he just moved. He been staying here for like he was staying here for a couple months for sure. I can't directly tell how many months he was staying, but he was here for sure because like I stated, that's how Devo ended up working in the game because he actually took his spot.
So when Mr. Minor left in the game to come to Atlanta, that's when Mr. Jones started working in the game.
Not directly. It's like I want to say, soon as he left, that's when Devo came. It was probably a month or two later. That's when Devo had ended up coming.
What is the next thing you remember happening?
Me being in the hospital.
Tell me this. When you left, You lay down on all the luggage, the book bags, duffel bags, and everything else. Did Mr. Minor tell you where you all were about to go next?
Can't really remember if he just told us the directly spot, but I feel like it was comfortable. Like it didn't really matter because he was driving the car. So with that being said, like it's not his first time driving my car. I feel like he familiar with the line of streets. I felt like I was in good hands for sure.
Okay. Now, I want to address something. When you stepped down, we saw you were kind of holding your arm. You had a sling since you've been here. What is the purpose of that sling?
The purpose of the sling is I done dislocated my shoulder a couple times, and like since the accident, I never had full recovery from the accident. So with that being said, like I never had proper, yeah, if you want to say training, I never had the proper, cause it's like
Never got the medical attention?
yes, that's what I'm trying. I never got the proper medical attention. Yes, sir.
This year alone, how many times, or because of that, does your shoulder often, pop out of place?
Yes, sir. Like I can be the smallest thing. One time it popped out of place for me running around the car. Another time me walking my dog. Another time is like I say, I don't have insurance at all. So I have a matter of fact, Zero, he's a personal trainer. So he go to the gym. I try to work with him for sure. Cause I don't have to pay him now. That's my brother. So with that being said, I dislocated at the gym before, like just doing simple scratch.
You're alone, once your shoulder is dislocated, what do you have to do?
Somebody rushed me to the emergency room. Once they rushed me to the emergency room, they put me to sleep. Once they put me to sleep, I be sleep for like they say is probably 10 minutes. Be sleep for 10 minutes, wake up with a sling on my arm. The sling y'all seen, I got it from the emergency room.
This year alone, how often have you had to make that trip to the ER?
I'm gonna object to relevance at this point.
Your Honor, it is, the jury seen him in here with the sling before. I believe it's relevant for them to know the reason why he has that sling.
Okay, well, you've covered it. Next question.
So you're sustaining that objection?
At this point, it has become more cumulative than relevant. So yes, sir.
Now, going back to that morning, stated the last thing you remember was going to sleep in the car, correct?
Yes, sir.
What is the very next thing you remember?
Me hearing my grandmother's voice.
Where did you hear your grandmother's voice at?
The hospital.
In the video, that we saw, it shows you, yelling. Do you remember any of that happening?
No, sir, not at all.
Do you remember any part of the chase occurring?
No, sir.
When you woke up in the emergency room, were you able to see?
No, sir. I couldn't see for, I'd say 4 or 5 days for sure.
All right, what was done because you could not see?
What you mean by that question?
What was the emergency room doing, because you could not see?
They'll come in. My mom told me, my grandma was telling me, like anybody who come see me, they was telling me the nurse would come in probably 3 times a day just to drop eye drops. It wasn't just specific eye drops. It was like some type of, I just know they were putting something in my eyes. I couldn't say if it wasn't just eye drops though. It wasn't no regular eye drops at all, period.
And your cousin, Ms. Lewis, testified that she got to the hospital shortly after you arrived. Do you remember or have any recollection of her being at the hospital?
No, sir, not as soon as it happened. No, sir.
While you were at the hospital, do you remember, a trooper coming to the hospital
Anytime or when?
at any point?
Yes, so I remember one time just when he came in and told me that I had to turn myself in, and I asked him for what. Like he didn't even let me talk at all, period. So the nurse had ended up telling him he had to leave because she seen like me asking him like what I have to turn myself in. Like it was all new to me, Mr. Miller.
So, once you learned that, what did you do next?
The nurse, like I stated, the nurse stayed in the room for me for a couple more minutes. After she left, I contacted my mom and told her the situation.
At that point, did you have any clue why you needed to turn yourself in?
No, sir, because like I stated, he never told me what I had a warrant for or anything. He just told me I had to turn myself in.
Once the nurse, there, you said you called your mom next,
Yes, ma'am. I mean, yes, sir.
and then what did you all do after that?
I guess that's when my mom had contacted you, and you had tried to see if it was any warrants in the system. It wasn't at all, period. Like you checked multiple times.
Now, before you left the hospital, did you check with me again to see if you had any warrants?
Yes, sir.
And did you learn of any warrants at that point?
No, sir, not at all.
Because of that, what did you do?
Felt like it was safe for me to go back to Memphis so I can get the proper treatment that I needed because, like I stated at first, I don't have insurance. So with that being said, it's only so long a hospital will let you stay. Felt like it was good enough for me to go back to Memphis. And you gave me the say so, said it wasn't no ones at all, not even just you. My auntie, she know someone who worked for the U.S. Marshals. Like they,
You're saying?
I'll direct you on it. So, while you were in, Memphis, did you begin to get some type of care for your injuries?
yes, I was going to a regional one for physical therapy. Well, not really. It wasn't physical therapy at all, period. It was just maintaining, like, concerning my bones, orthopedic doctor. Just going to see the orthopedic doctor.
To your understanding, what is needed in order for you to get the function back that you had with that shoulder?
Every time I go to the emergency room, they tell me I have to have surgery. I'm thinking the first couple times it popped out of place, I'm thinking, oh, it's popped back in place. I'm gonna be good. But after so long, it keep on popping out of place. They keep on telling me I have to have a surgery. Surgery costs money. Like from Grady Hospital, I probably got a bill $800,000. I don't have that type of money at all.
And then when did you're back in Memphis at this point, when did you finally learn that, there were warrants for your arrest?
I was in the game, got picked up by U.S. Marshal, like they busting barbershop, saying I was wanted for murder. Like I was so confused because I didn't kill no one, I didn't shoot no one, I was confused.
And tell me this, you were back at work at that point?
Um, Trying to get back to work because, like I stated, that was my only source of income. I had a child, I got a soon to be fiance, I got a family to take care of. It's like if I don't move, don't none move.
So before you were telling us that you were able to cut hair, two heads in about 35 to 45 minutes. At that point, how long was it taking you to cut hair?
It was very, very simple. Like an hour and a half. My mom made then it was got to the point where I only cut one or two heads a day. Cause my mom made sure she stayed on top of me, made sure I went at the barber shop.
And we stated before that you are now, quite often wearing that sling. Are you able to cut hair with that sling on?
Yes, sir. We just did a back to school for all the kids going back to school. Like, actually, I dislocated my shoulder a week before that event actually happened. Like, ever since I became a barber, I always like most barbers be saying, we don't want to cut kids hair free, but it got to a point where I got a passion of cutting hair, Mr. Miller. So with that being said, it got to a point where I wasn't always good at cutting hair. So when I actually got good at cutting hair, anytime, especially if I do with kids, I'm cutting their hair for free, Mr. Miller, for sure.
All right, now, Mr. Poole, you, at this point, I say that you didn't know that you had warrants, that you were at the barber shop, getting a haircut. Eventually, do they bring you back to Atlanta?
Yes, sir. After a month, I was in 201 Poplar for some time. So,
Before you keep going into that, when, this case all happened back in 2021,
yes, sir.
there is an alleged statement that Trooper Clark is saying that you made in this case. When did you learn of that alleged statement being made?
Back when Discovery was given to us, probably like February, March.
Of this year, correct?
Yes, sir. That's when you called me and asked me.
Well, before I go into that discussion, and let's not, but when you learned of that, did you, have any clue that there was an alleged statement in this case?
No, sir, not at all.
And before, I called you about that, had you had any clue that a trooper alleged that they had came to visit you the day of the accident?
No, sir.
Now, after you learned about that statement, you went to see, or you visited Dr. Conley afterwards, correct?
Yes, sir.
And when we talk about the symptoms or the condition that you were in after the accident, we know about the physical condition that you had with your shoulder, and your gait as well. But with your head mentally, what was going on? Were you starting to have headaches during that time period?
Yes, sir. A lot of headaches. Couldn't sleep very well. Ringing the ears for sure. At the time, like still to this day, heavy lightning. Like when I'm in the barber shop, I can't even turn my ring light to the max because heavy light mess with my eyes.
Now, prior to this collision that you were involved in, had you ever had those symptoms before?
No, sir.
There was an accident that occurred in 2019 that you were involved in. Do you remember that collision?
Yes, sir.
After that collision, did you have any of these symptoms that you had after the 2021 accident?
No, sir. With that collision, I actually went back to work the same day. Like it was a fender. It was a fender bender. There's no airbag deployed, no nothing. So I didn't have a scratch or a mark on my face. Thanks to God.
Now, going back to when you woke up in the hospital, uh, did you have any clue what happened?
Not at the moment.
When did you learn, that Mr. Minor and Mr. Jones had passed?
I can't remember the exact when, but my mom was the first person that told me about it.
And when you woke up, what was your, initial, what was your thought on where they were?
My mom, before before she told me, she was asking me. She had asked me. I actually thought they ran, like thought they left me.
Thought that they had just left you in Atlanta, correct?
Yes, sir.
And, the last memory that you had that morning is going to sleep in the backseat of your car, correct?
I'm gonna object to leading.
Sustained.
When did you get your barbering tools back?
My sister recovered some of my stuff, some of Devin's stuff, and DT stuff.
All right, and, did that include the duffel bags and the book bags that were in your car?
Yes, sir.
No further questions.
All right, ladies and gentlemen, we're going to take our morning break. And when we get back, we'll see if there's any cross-examination of Mr. Poole. Don't talk about the case during the break. No outside research. And we'll get you back out here probably less than 10 minutes unless you tell Deputy Gordon you need more time. We're making good progress here. Thank you.
All right, so the jurors.
Mr. Abate, anything before we break?
There you go.
Mr. Miller?
No, yeah.
Okay, Mr. Poole, you can step on down and we'll get you back up here after the break. Thank you. Leave that right there. Mr. Miller will decide what to do with that. Witness stand, please. Once he gets up here, let's bring the jurors in.
All right, so the jurors. Do the president's accounting for.
Thank you, Deputy Gordon. Everyone else should be seated. All right, Mr. Poole, you can take a seat, please. Mr. Abate, when you're ready for cross-examination.
You good? You need any water or anything?
Can I get some water, please? I'll check it out, just in case if I need it.
Good morning, Mr. Poole.
Good morning.
We haven't met before. I'm out of body. The attorney for the state, okay? Just a few questions for you. I want to start off with showing you what's been marked as State's Exhibit 171, okay? You recognize State's 171?
Yes,
And how do you recognize State's Exhibit 171?
that was an accident I had back in the current date. I uploaded on Facebook November, but the current date I can remember it was October,
Okay,
Halloween to be exact.
of 2019.
Yes, sir.
And does that picture fairly and accurately depict how your vehicle looked after your car crash in 2019?
Yes, sir.
This time out of the state would tender what's been marked as State Exhibit 171 into evidence.
Mr. Miller, other than what we've already discussed and you've made a record of and preserved, do you have any objections to the admission of States 171?
Other than improper character evidence as well as relevance, Your Honor, no other objections.
Okay. 171 is admitted.
And we're looking at 171 on the screen. Is that your car after the car accident?
Yes, sir.
And you characterized that when you were talking about it with Mr. Miller on direct. You said that was just a fender bender, right?
Yes, sir.
That's what you would consider just a fender bender?
Yes, sir.
That car total?
No, sir.
You could drive that car after your accident where it was in the, I guess, the fence and over the poles.
I couldn't drive it because of the accident, but it wasn't total because after that picture, I still had the car to this day.
Okay, but you got a new car. You got a Infiniti Q50S, correct?
My Q50, yes, sir.
Okay, the white vehicle, right?
I have a question.
So you don't get to ask him questions. Sorry.
Okay, so sorry. Go on, Mr. Abate.
So you got looks like, and at least in November of 2020, you had the white Infiniti Q50, correct?
You say it again?
Sometime after the accident, the photograph in front of you shows that you said, now I have the Q50. See that in 171?
Yes, sir.
And so you had your white Q50 at least in November of 2020, correct?
Yes, sir. I got it. I know when I got it because I actually got it for my birthday. So yes, sir.
Okay, and can you tell the jurors what is Grand Theft Auto? video game.
Objection, relevance?
Relevance is, well, let me ask a better question. Did you play Grand Theft Auto a lot?
Same objection, Your Honor.
What's the relevance of whether? I understand there's some verbiage in that photo, but that photo is for the limited purpose we discussed. Okay.
Now, how old are you again, sir?
I just turned 26
Okay.
yesterday, Saturday.
This weekend?
Yes, sir.
Okay, and you are from Memphis, correct?
Yes, sir.
And prior to April 21st of 2020, excuse me, April 9th of 2021, you didn't live in Atlanta, right?
Never lived in Atlanta.
Okay, you had come to Atlanta multiple times to cut hair and do hair shows and other things, correct?
I probably want to say before the accident, can't tell them like I can say like 2 times that was documented for sure.
Okay, and you had been to Atlanta pretty recently for the All-Star game in March of 2021, correct?
Yes, sir. Me and Devin rode together.
What?
I said Devin, he was with me. Yes, sir.
And so was Detarius or DT, correct?
He didn't drive down here with me, but Devin, he rode down here with me.
Okay. Y'all hung out with DT, correct?
Yes, sir.
And you said you've been working as a barber for how long?
6, 7, 8 years at the most.
Okay. And now let's talk about, I guess, what time did you say that you left? Would have been April 8th of 2021 again.
Probably want to say we supposed to left earlier, but no later than it. Probably like 2:30, 3:30, no later than 4 o'clock.
Okay. And I apologize, I'm having a little trouble hearing you, so if you wouldn't mind speaking up.
Want me to say it again?
I think you
Oh.
said no later than 12:30, correct?
No, I didn't.
Or what-
I said no later. I said we supposed to left earlier. It was either 2, 2:30, 3, 3:30, no later than 4 o'clock p.m.
And it was just you and Devin in your car, correct?
Yes, sir.
Okay. And everyone else either rode with Scooby or Brandy, correct?
I couldn't tell who was in Scooby car because he took off ahead. He took off before us, but I know for sure Brandy, it was Brandy, EJ, and Rob.
Okay, Brandy, EJ, and Rob, right?
Yes, and Ice, the monkey.
And you said when you got to Atlanta, you and Devin went straight to your cousin's house, correct?
Yes, sir.
And you don't remember where exactly she lived, right?
No, so I'm not familiar with Atlanta. So if I told you anything, I'll just be mixing me up.
Okay. And after you cut hair at your cousin's house, you said, did you cut her hair and her fiance's, right?
No, sir. I said I cut my little cousin her and her fiance.
Okay, so you cut 2 people's hair, right?
Yes, sir.
And you then went to an Airbnb, you said Kivo Montelistana?
Yes, sir.
Okay, and you cut his hair and a friend of his, right?
Yes, sir. It was actually his chef, so yes, sir.
Okay. And after that, you said you went to Kivo Money's listening party?
Yes, sir.
Okay, and you know, where did that happen?
The listening party?
Correct.
I couldn't tell because I was following behind. Keep our money.
Okay. Where was Kivo Money's Airbnb?
I can't tell you off directly because I just got the location and I just drove to the location. It wasn't far from his Airbnb wasn't far from the listening party though.
Okay. Was it far from the Airbnb that you eventually ended up going to where you saw Scooby and Brandy and DT?
If I can remember, it wasn't far, but it wasn't close either.
Okay. But you don't recall, right?
I said it wasn't far and it wasn't close either. That's what I said.
Okay, So I guess my question is if it's not far and it's not close, do you remember where it was though? General area.
It wasn't far, it wasn't close. That's what I said, Mr. Abate.
Okay, so when I'm just gonna follow up. If it's not far and it's not close,
Objection asked and answered.
I haven't finished the question.
Finish your question.
If it's not far and it's not close, you're not familiar with Atlanta, you didn't know where Kivo Money, where his listening party was. Do you have any idea where the Airbnb was?
Like I stated the first time, Mr. Abate, it wasn't far, it wasn't close. Well, I stated the first time.
So your answer is wasn't far, it wasn't close.
He's
Yes, sir.
answered it now.
So, how long did you stay at the, wasn't far, wasn't close,
Airbnb,
location for, the Kivo Money, listening party?
you said how long did I stay at Kiva Money listening party?
That's correct.
Probably wanna say 40, 45 minutes at that.
And, how long did it take you to get to, the listening party to, Scooby's Airbnb?
Not that long, probably 20, 25 minutes, 30 minutes. I can't really directly tell your time, but it, like I say, it wasn't far, it wasn't close.
Okay. And, while at, Kivo Money's listening party, did you, smoke, drink, things of that nature?
Yes, sir, I smoked. As far as drinking, I wasn't a big drinker at all, period. I probably had a shot at that. Me and Devil had a shot at that. But as far as like big time drinking, not at all.
Now, you said you went to, I guess the Airbnb that, Scooby was staying at, right?
Yes, sir.
And, you said everybody that you had named earlier, was there, correct?
Yes, sir.
And, do you remember how long you guys hung out at the Airbnb before you left?
At the Airbnb, we wasn't there long at all. Cause like I stated to Mr. Miller, when I got there, like on our way to the Airbnb, DT, Brandy, they were trying to wake Scooby up. He was finna go to sleep, but he was quick to be woke up. But Scooby, he took him a little minute. So by the time we actually came into the Airbnb, Scooby was, as you can see on the video, he was up.
Okay, and, you guys immediately went, sounds like pretty close in time, straight to wherever you ended up at the lounge, where you had some wings later on, correct?
Yes, sir.
Okay, and, you kind of talked to the jurors a little bit about earlier, it was state's exhibit, or excuse me, defense exhibits, I guess 21, it's the 4-page exhibit, right?
Yes, sir.
And when you said you let DT, I guess, use your phone to create a video, correct?
Yes, sir. As it shows on the video, DT got my phone and it shows my Instagram name.
Okay, and, in, I guess, the defense exhibits 21, the pages where, I guess, people's names were mentioned, in a story, right?
Yes, sir.
And you talked about, their names being mentioned in the story, I think around 2:05 a.m., correct?
Yes, sir.
And, you guys, everybody was, at the lounge that you, left Scooby's apartment with, correct?
As I can remember.
Okay, so it was more than 4 people, correct?
Yes, sir. House didn't have an Instagram, so he couldn't be tagged. Couple guys didn't have an Instagram,
Okay.
so they
Devo
can't.
had an Instagram, right?
Yes, sir.
He's not tagged in these photos, correct?
I don't know why Mr. Miller don't have it because I actually gave it to Mr. Miller.
Okay, but in the exhibits that we have here, Devo is not tagged in these photos, right?
His name not showing, no, sir.
And, you said young wrist, God, that was EJ, correct?
Yes, sir.
And then DT, the chopper, is DT or Devin,
No, it's Denterius Minor.
correct?
Yes, sir.
Then the hottest female, I think it's Barber.
Brandy Jefferson.
And Scooby World 1901, that's Mr. Patrick.
Yes, sir.
Got it. And you, earlier in that evening, well, first let me ask you this. When you are posting stories or tagging people on stories, you're posting videos, correct?
What you mean? So, elaborate on what you're trying to get me to say.
I'm asking you. You ask questions and tell me what to do. I'm
Yes, sir.
asking you.
So sorry.
You post a story. Are you posting a video?
Yes, sir. You can post a video, you can post a picture. It's whatever you consider
Okay.
a story.
Video, picture. You can post just about anything, correct?
Yes, sir.
But in these instances you described, that we talked about in the state's exhibit, defense exhibit, I keep doing that, 21, you posted videos, correct?
I'm gonna post the video. DT, Mr. Minor posted the video, as you can see on the video.
Wow.
It came from my Instagram, but who had the phone was Mr. Minor.
Right. So in the video, you see Mr. Minor taking the video, correct?
Yes, sir.
And that brings me to the next question. So when you post videos, pictures, whatever you wanna post, you can post videos from taken earlier in the evening, correct?
No, so that video is accurate.
So I'm asking you a question though. My question is when you post a video in a story, it's not a video, it doesn't have to be a video you just took, correct?
If I post a video, just say, for instance, I'm gonna call you Mr. Abate. If I tag you, it has to be right then at that moment.
Okay, let me ask you this. So let's say you had your phone on you right now, okay?
Yes, sir.
And you took the phone out and you recorded me right
Yes, sir.
now. And you put your phone back in your pocket, all right?
All right.
And then tonight, after court or whatever, you pull your phone back out. You follow me?
Yes, sir.
And you have an Instagram handle, what's it called?
My Instagram name, Chopping Like a Fool KP. Chopping Like a Fool KP.
Okay, so you could pull out your phone, go to your Instagram, Chopping Like a Fool KP, right?
Yes, sir.
And remember that video that you took of me right now at 10:57 a.m. in court?
Yes, sir.
You could post that on your story and tag me if you were friends at 11:02 p.m., correct?
I could. Yes, sir.
Now, up until you got to, I guess, Scooby's Airbnb, you weren't with any of the people you cut hair with in Memphis other than Devo, correct?
Yes, sir.
And I guess y'all left Kiva Money's listening party, you said, and you went to the Airbnb, right?
After we left Keep On Money listening party, we went to Scuba Airbnb. Yes, sir.
Right. And Kiva Money and them, they didn't go, right?
Then go to Scuba Airbnb?
Correct.
I wouldn't see why they would have went. But no, sir.
Now, I want to show you. It's the last page of Defense Exhibit 21. Oh, at the top it says Scooby World 901. Okay.
Yes, sir.
Right. And I want you to look where it says. Do you see where it says April 8th, 2021?
Yes, sir.
And can you tell the jurors what time to say that you mentioned in your story Scooby World 901?
It's a 10:33 p.m.
10:33 p.m.
Yes, sir.
So you posted something, a story, whether it be a video or a picture that mentioned Scooby in it, correct?
Yes, sir. They mentioned Scooby, and it could be far as me taking a video of someone else. Scooby, post Scooby. Look at this. It's not necessarily Scooby in the video.
Right. So you can post the video, tag somebody, but they're not necessarily in it, and it's not necessary at the time that you're with them, correct?
Yes, sir. But on April 9th, 2021, it don't make sense for DT. As you can see on the video, DT was recording it, and everybody timestamp say 2:05 a.m. it don't say that for on no one else's account. Like on April, like Scooby, it just say April the 8th on Scooby page, but everybody else, it say April 9th, 205.
Okay. So, I got you, and if I don't have this on the digital format, but you would agree, Scooby World 901 is mentioned in the same story that you circled at 2:05 AM, that the other four people, in this exhibit, Defense Exhibit 21 are mentioned, correct?
Yes, sir.
Objection, that's a mischaracterization.
So that's not a valid objection. You can on redirect unmischaracterize if you think it was mischaracterized.
Anything is confusing, by all means, you can say, I don't understand.
I got a question. I was trying to ask you a question. You told me I can ask you no questions.
You tell me if you're confused, my question doesn't make sense, I'll rephrase it.
Okay.
So my question is Scooby is tagged at 2:05 AM in a story, whether it be a picture or video, from your account, correct?
Yes, sir.
And just like everybody else, correct?
Yes, sir.
And then if you go above, at April 9th, 2021 at 2:05 AM, Scooby is also tagged in a story on your account at 10:33 PM, correct?
Yes, sir.
That's all. That's not confusing, is it?
How you were trying to put it was, but I get you.
Why are you still confused?
No, I get you.
Now, you said that you guys go to the lounge and you heard, as Mr. Miller asked you, the testimony of the people you were with on Friday, correct? You heard from.
I don't
EJ
understand that question. Explain in a better way, please.
On Friday afternoon, so a couple days from today,
Yes, sir.
you heard the testimony of EJ, House, Mr. Phipps, all of those people, right?
Yes, sir. I was sitting right there.
And you would agree that y'all stayed at the lounge that you or nobody else seems to remember the name of, not for very long, 10, 15 minutes is the testimony, correct?
That we only stayed at the lounge for 10 or 15 minutes. That what you asking me?
What I'm asking.
No, sir.
Okay. So what is your recollection? How long did you stay at the lounge?
No more than I can say. I can't put a direct time on it. 30 minutes, 35 minutes, 45 minutes, no more than an hour. I know for sure.
Okay. And then House noticed tickets been put on people's cars, right?
Yes, sir.
Okay. Did you get a ticket?
So happily, no, because DT had got my car.
Okay. And you said that you then, or I guess when House saw that, you told DT to go get your car, right?
Yes, sir, because like I stated to Mr. Miller, I ordered some wings when I first got there. I already paid my money for the wings. There's no sense in me letting that money go to waste, so I got to go get my wings while I get DT my keys.
Okay. So you waited for the wings, and because you were waiting for the wings, you gave your keys to DT and said, go get my car, right?
Yes, sir.
Got it. And Devo, it sounds like, went with him, right?
Yes, sir.
And can you tell the jurors, where was your car parked in relation to the lounge?
It wasn't far at all, but it was on the street where everybody else parked.
Well, we weren't there, that's why I'm asking you.
Understood.
Okay. And how long would you say DT and Devo were gone getting your car?
I can't basically put a time stamp on it. It was 3 years ago, Mr. Abate, so I can't just directly tell you that.
Okay. So it sounds like you don't remember, right?
How long did it
How
take
long they
them?
were gone?
How long they was gone? Not off. I can't just tell you, oh, they were gone 10 minutes, that was gone. Can't give you a direct answer on that one, Mr. Abate.
Okay. Now, before we go to the next events, you, I guess it was played during your direct States Exhibit 143. It's the Facebook video, right?
It could have been Facebook, could have been Instagram.
Okay, but it was a video that Mr. Jones filmed, correct?
What the video stated again?
It was a video of you in the car, States Exhibit 143, it was shown to you during direct. Is that a video that Mr. Devin Jones filmed?
You talking about that video after the Keep Up Money listening party? Like it showed Keep Up Money, then it showed me in the car with just me and Devo in the car. Talking about that video?
That's exactly the video I'm talking about.
Yes, sir. I remember that video.
Okay. So now that we've established you remember it, you've obviously seen the video, right?
Yes, sir. That's how I remember it.
And you are wearing your KP necklace, right?
Yes, sir.
And you're driving, right?
Yes, sir.
Okay. Now, you said the next thing you remember after DT and Devo go get your car is you're still waiting for your wings, right?
The wings didn't take that much longer. So with that being said, I seen Brandy, told Brandy, hey, sis, wait on me. She waited on me. Once my wings came out, started eating them inside, like walking outside the lounge. Seen Scooby. Scooby started eating them.
Okay. So I guess so that's a yes. You got your wings while they were getting your car, right?
Yes.
Got it. And you said it wasn't very long. They drove up in your car, right?
Yes, sir.
And it's your testimony that once they drove up, you got in the back seat of your own car, correct?
Yes, sir.
And you said you kind of showed us. Sounds like you got in on the
Driver's side, my head was facing towards the passenger side. My feet was driver's side. It was hanging on the door. One feet was hanging on the door. The other one probably, if I'm not mistaken, was hanging on the floor. But I know for sure this had the direction.
So I'm clear. Your feet would be on the behind the driver's side, the driver seat, correct?
Yes, sir.
And your head would be behind the passenger seat, correct?
Yes, sir.
And then you said there were bags within the back seat, right?
Yes, sir.
And you said something about EJ's bag or clipper case was in your back seat.
I didn't say the back seat. That's probably was in the trunk. Our clippers was probably in the trunk, but bags and stuff was in the car for sure.
Okay. But EJ, he rode with Brandy from Memphis, correct?
Yes, sir.
And you hadn't seen EJ until you got to the Airbnb that Scooby was staying at, correct?
Yes, sir.
And EJ was staying at a different Airbnb, correct?
Different than Scooby?
Correct.
Yes, sir.
And in fact, EJ had booked an Airbnb and like he told us on Friday, had taken money or got money from you, Devo, and whoever else was gonna stay at that Airbnb with EJ, correct?
Yes, sir.
Okay. And prior to Scooby's Airbnb, EJ had already gone to the Airbnb that you and Devo were gonna stay at and unloaded his stuff from Brandy's rental car. Remember that?
Say it again.
EJ, when he got into town, had already unloaded his stuff from Brandy's rental car into the Airbnb that you and Devo and others were gonna stay at, correct?
Yeah, his personal, like his clothes and stuff, but his clippers was in my car.
Okay. So the one thing that was in your car was his clippers.
Yes, sir, because you got to remember, Brandy rented, I know this for a fact, Instagram. She rented a small type of car. So with that being said, it wasn't a lot of room for her stuff, her clippers, her bags. My car was a little bigger than the rental car.
Okay. What did you say about Instagram?
No, if you was gonna ask me like, how do I remember what type of car Brandy had or anything like that? It was a smaller car than my Q50.
Okay, so if I'm clear, you're saying that the car that she was driving, you remember something about it because of Instagram, right? Is that what you're saying?
Yes, sir.
Okay, but we haven't seen anything about Brandy's car or anything during this trial as it relates to Instagram, correct?
Not far. Yes, sir.
Okay. And then you said your car was a little bigger than hers.
Yes, sir.
So let's talk about the size of your car. Your car was a sedan, correct?
Yes, sir.
And it was a compact sedan, right?
What you mean by that?
Was it a big sedan?
It was spacious.
Okay. And when you say it was spacious, what would you compare it to?
It was bigger than a Mustang, like a Mustang, two-door Mustang. It was bigger than this car right here that you showed me that I had a wreck on November. I mean, back in October, it was way bigger than this car for sure. Like this car right here that I had a wreck in, I got a kid. So with that being said, it was hard for me to try to get my kid back and forth about that car when I got the Q50, easy access.
Right. And what's the ease of access? Did it have anything to do with the fact that the car in the States is at 171, the black car is 2 doors, and your Q50,
It's
the
four.
black one was 4 doors, right?
You asked me, you asked me how big, like a demonstration, and I just gave you one.
I'm asking you a different question. So you talked about
Also,
how it was easier to put somebody in the back seat, and I asked you, was that because the first car was 2 doors, and the car that you that was crashed on April 9th of 2021 was 4 doors?
if you trying to say, of course, this car, this Nissan Altima, two-door, yes, it was two-door. The Q50 was four-door, yes, sir.
Got it. All right. And okay, so then you told us on direct when Mr. Miller was asking you some questions that I guess the last thing that you remember is falling asleep, correct?
Yes, sir.
Okay. And you got into the car like you've shown us today, and you immediately went to sleep, right?
Yes, sir. I was up. All the day, so yes, sir.
Okay. But being up all that day, well, you said you got up around 10:30, 11, correct?
Yes, sir. Like I know I said I went to the shop at 10:30, 11.
The question was, what time did you get up? And you answered sometime between 10:30 and 11. Do you remember saying that?
Yes, I thought he was saying what time I went to the shop.
Okay. So I guess I'll ask you now. So we heard you say 10:30, 11 is when you got up. What time do you remember getting up 3 years ago on April 8th of 2021?
Directly time, I can't recall.
Okay. And what time would you typically get up when you had to be at the shop? Now you tell us between 10:30 and 11. What time would you typically wake up?
Like on a regular day basis.
On a day that you got to work at 10:30, 11, what time would you wake up?
It just depends. I'm a barber. I'm self-employed, Mr. Abate. I'm self-employed.
Okay. And being self-employed, if you had an appointment with your, self-employed company that you had to be at a barber shop between 10:30 and 11 a.m., what time would you wake up?
Asked and not answered.
You said what time?
Yes.
I'm gonna give you a demonstration, Mr. Abate. It's been times where I have an appointment at 10 o'clock. I don't probably get up until 11:30. It's times where I have an appointment at 10 o'clock. I get up at 8 o'clock. I can't just give you a simple answer. That's what I'm telling you.
Okay. So you don't know.
I told you I can give you a simple answer.
Excuse me?
I told you I can give you a for sure answer.
Okay. So you're not sure.
I can't give you a for sure answer.
And you said the night before you cut hair till about 12:30?
Yes, sir.
Okay. And like you told us on direct, it wasn't unusual for you to stay up late and hang out at the shop, whether you were cutting hair or you said just kicking it, talking about your next, I think you said spot to open
No.
your next shop, correct?
I said our next business plan. That's what I said, Mr. Abate.
Is that a yes?
State your question again.
My question was, it wasn't unusual what you told us, that whether you were cutting hair or you were up at the barber shop talking about, as you said now, your next business venture, it wasn't unusual for you to be at the shop until 12:30 in the morning, correct?
I wouldn't say every time, like every day, 12, like we up there every day at 12 o'clock. I wouldn't just say that it just varies. Some days later, some days shorter. I'm a barber, Mr. Abate. So with that being said, some days I have 5 clients, some days I have 10 clients, some days I have 20 clients. It just varies.
Okay. So, all right. So So you being at the barber shop till 12:30 the night before was not unusual. How about I ask it that way?
Like that wasn't the first time I ever stayed at the barber shop. That's what you asked me. That wasn't the first time I actually stayed at the barber shop to 12.
My question was it unusual?
Like I'm trying to see when you say unusual, like make it break it down to me, please, Miss Abate.
I don't know how to break it down other than how often do you think that you hung out at the barber shop? You said it was open 24 hours,
Yes, sir.
around 12:30 in the morning.
As I clearly just stated, it's days where I have 2 clients. It's some days where I have 5 clients. It's
So,
some
Mr.
days where
Poole, how often would you be at the barber shop at midnight?
I can't. I'm trying to answer him the best way I can, Mr. I'm trying to answer him the best way I can.
Okay.
That's all. Like I was stating, you asking me, is it the first time I stayed at the barber shop to 12? No, it's not. But I'm saying like it's days where I have 2 clients. Some days where I just get out the barber shop at 8 o'clock. Some days where I have to stay to 10. Some days I have to stay at 11. Some days I have to stay at 12. I just like that's not the first time. That's what if you was asking that question, that's not the first time I ever stayed.
Right, I understand. So being out to 12:30 wasn't something that was highly unusual or something that you didn't do often, correct?
No, sir. I'm for no. Let me say this. You asking me being up at 12:30 is this something unusual? It's like I want to say, but first accident, and still to this day, I'm not late. I'm not a late person. I ain't gonna lie to you, Mr. Miller. Like at that time, I mean, I said Mr. Miller, Mr. Abate. At that time, I'm trying to see the best way to put it. The best exact way to put it. As far as staying at the shop 12:30, there's not like I did it before, but I'm just not. Let's stay up till 5 o'clock in the morning. I'm not that type of guy. I'm trying to get some sleep.
Okay. So anyways, what you remember is that you fell asleep, it sounds like immediately in the car, right?
Yes, sir.
And then you said that the next thing that you remember is waking up in a hospital because you hear, I think you said your mother's or your grandmother's voice. I couldn't hear you.
I said my grandmother's.
Got it. And so it's your testimony that you don't remember or you going 95 miles an hour didn't wake you up, right?
No, sir.
Going over 100 miles an hour didn't wake you up.
My son is about to. I was sleepy. So if you know how you put a baby in the car and you just drive around, like, of course, a baby gonna wake up while you driving around. You said I can ask you a question. My bad, Abate. But this is just a demonstration. I was just saying.
By all means, keep going. You're not asking me questions. Are you done?
Yes, sir.
Okay. And so going 110 miles an hour because you're like a baby, that helps you sleep, right?
Yes, sir.
Okay. And then you get to 130 miles an hour. And because I guess being in the back seat of a car on top of luggage helps you sleep, correct?
Yes, sir.
Okay. And you slept after the police or the trooper went license sirens, correct? You didn't hear that, right?
To my state of knowledge, I can't recall.
You were asleep, right?
That's why I said I can't recall.
Okay. And because you were asleep, you didn't hear anything that was going on in the car after the trooper attempted to initiate a traffic stop, correct?
I just answered the question, Mr. Abate. I said, obviously, I can't recall.
Okay. And was there any noise going on inside of the car? You remember that?
We radio, loud music, probably. Like when I first got in the car, I heard loud music for sure.
Okay. And the radio stayed on throughout the entire ride of the car?
I can't tell you that, Mr. Abate, because I was asleep.
Right. And you were asleep when the car was going in and out of traffic, correct? You didn't feel the car going from lane to lane, correct?
I can't ask you a question, so no, sir.
Okay. And you were asleep when the car, you said, collided with the concrete wall off of the Lennox Road exit, correct?
Can't recall.
Can't recall if you were asleep.
Can't recall nothing about the accident during that time.
Okay, and I guess, is that because you were asleep?
Yes, sir.
And you don't, and you said when you went to sleep, you don't remember changing positions from what you described and what you showed this jury here today with your feet at the driver's side of the back part of the car, the back passenger compartment, and your head at the passenger side door in the back, correct?
I know for sure my upper body didn't change at all because it's like it's a car mistake. How often can a person turn in the backseat of a car? Like mid car, like I'm just asking. You said I can't ask you a question, but is it okay if I ask you that question?
How about it?
Huh?
Yeah, go ahead.
How often can a person in the backseat like change from this side to this side?
Well, that's what I'm asking you. Do you remember changing positions from what you described to this jury when you got in this car? Do you remember changing positions at all?
No, sir. If I'm one strange sleepwalker, if I did.
Okay. And you said the next thing you remembered was hearing your grandmother's voice. When was that?
I can't recall because I couldn't see her. I couldn't see her at all, period. I heard her voice for sure.
Okay. And after is it your testimony you don't recall any of the troopers who arrived after your car hit the concrete wall? You don't remember any of the troopers?
During the whole process or like directly after the car accident?
Directly after the car accident. Do you recall after your car hit the concrete wall interacting with any of the troopers on scene?
No, I don't recall. The hospital reports don't recall any trooper coming directly after my accident. So no, sir.
Okay, let me be more clear. While you were at the Lennox Road, on Lennox Road, where your car is on fire at one point, it's put out by the troopers, okay? Are we on the same page?
Yes, sir.
Do you recall seeing, hearing, talking to, interacting with them being around you, any of the troopers being around you on the scene of the collision with your vehicle in the concrete wall?
Today, as we speak, no, sir, I can't tell you. No, sir, I can't recall.
Today, as we speak, do you remember on another day when we haven't spoken?
No, sir.
Okay. And do you remember interacting with or the members of the Atlanta Fire Department pulling you out of the front compartment of your vehicle? Do you remember that?
No, sir. Like I said, when I first received Discovery, the video was in Discovery, right?
So you don't get to ask him questions. Is you
Well,
just talk about your
No, sir. No,
experience.
sir. The video was in Discovery. That was my first time. Actually, like it was all new to me.
Okay, so my question is, do you recall that night or that early morning, members of the Atlanta Fire Department interacting with you and pulling you out of the front compartment of your vehicle?
Driver's side or passenger side?
Well, I'm asking, do you recall?
I was asked. You said front part. I was just trying to see front driver's side or passenger side.
This is gonna go a lot faster if you just listen to the question and answer.
Yes, sir.
But my question, regardless of what side it is, I asked you, do you remember that night interacting with members of the Atlanta Fire Department who pulled you out of your vehicle?
As I stated, firstly, it was all new to me. When I got Discovery, it was all new to me. I don't recall that night, but when I seen the Discovery, that's when I was like, "Whoa!"
So the short answer is no, correct?
No, it was the answer I just gave you.
Okay. And do you remember interacting with any paramedics on the scene of on April 9th of 2021 on Lennox Road? Do you have a recollection of that?
Mr. Abate, we're gonna move faster. I don't recall anyone. until I seen Discovery.
So you've seen the discovery, right?
Yes, sir.
Okay. The documents related to this case, right?
Yes, sir.
And so you told us on direct that you don't recall making any statements to Trooper Clark that early morning once you got to Grady on April 9th of 2021, correct?
I don't see how I could made any statements. Is like last week we showed a picture of me in the hospital, and that was a couple hours. I don't understand how I can make any statement when the position I was in.
Okay. You don't, so that's a no. You
I don't understand. I don't know how I can make any statement in the position I was in, Miss Abate.
Okay, so I understand that part of your answer, but
That's my answer, Miss Abate. Like my bad if I interrupt you. I'm so sorry, but like I don't see how I can make any statement when I have a mask over my face, neck brace, chemical burns in my eyes. I just don't see how I can make any statement, Miss Abate.
understand how you don't think you could do something. And my question is, do you remember making one?
Like I stated, I don't see how I could have made a statement if I have chemical burns in my eyes, mask over my how else? You said I can ask you a question, but can I ask you one? Can I ask you
Why don't
something?
you ask your next question?
Yeah, so
This is,
you said you looked at the discovery, right?
Yes, sir.
And you saw that in that discovery was your medical records, correct?
I didn't look at every page, but I looked through it for sure.
Okay. So you looked through your medical records, right?
Yes, sir. I
Okay,
looked
and
through it.
in your medical records, medical professionals, whether it be paramedics, doctors, nurses, all said that you were alert, oriented, were able to speak when you arrived at Grady, April 9th of 2021. Did you read that?
No, sir.
Okay, so you didn't read that anywhere in the medical records.
I didn't see it.
Okay, and you talked about your interaction with Trooper Clark on April 17th of 2021 in Brady. You remember talking about that on direct?
Yes, sir.
And he told you that there was a warrant for your arrest, correct?
Yes, sir. And I also asked them, like, like for what? I didn't. It was lost. What's the warrant consist of? He never gave me any more information.
So it's your testimony that when you asked what's it for, he just looked at you with a blank stare.
He told me, "Don't talk." Solely, he said, "I already know." I was like, "What do you know?" Then that's when the nurse had told him to exit out the room.
Okay. All right. So you remember that part?
Yes, sir.
Okay. And he told you before he gave you a blank stare or didn't answer your question that you needed to turn yourself in once you were discharged from Grady, correct?
Yes, sir. I asked the nurse about that process. She was like, if I really had any warrants, it'll be outside my hospital door, handcuffed to the bed. Oh, the state trooper would have told her personally before y'all discharge him, call us so we come pick him up.
Okay. But my question is what he told you. He told you had a warrant and to turn yourself in upon discharge, correct?
Yes, sir. But I asked him what the warrant was for.
Okay. And you didn't do that, right?
The reason me not doing it because
The question was did you or did you not do that?
Can I do?
so answer his question.
It's gotta be yes or no.
No, you can always explain your answer.
Okay,
You're free to
okay.
do that, but he did
Okay.
ask you a question.
I did not do that. You wanna know why? Because I have got in contact with my lawyer, and my lawyer stated not even just on the 7th, like not even just the day I got discharged from the hospital. The soon as I found out, Mr. Miller, please check and see if I have any warrants. He calling down to the sheriffs, calling down to 40 County, period. No warrants popped up. So if a person tell you to turn yourself in and no one's showing, I never been in no predicament like this. I'm not a criminal, Mr. Abate.
Okay. And so you said Mr. Miller did a whole lot of things, but you didn't turn yourself in to Fulton County after you discharged yourself, correct?
So you've asked that before, and he answered it, and then he gave an explanation.
Got it. And you talked about what Mr. Miller did, but you never called Fulton County, Trooper Clark, or anyone with Georgia State Patrol after you were discharged from Grady in, I think it was April 27th to 26th, correct?
I thought that was what my lawyer was for.
But my question was, did you do that?
That's what I'm saying. I thought that was what my lawyer, that's what I'm paying Mr. Miller for. Like,
So remember, you answer the question, yes or no, whatever your answer is, and then you're free to explain. So did you call? No, I didn't, because that's what my lawyer is for. Or yes, I did.
no, I didn't, because that was my lawyers for.
Got it. And you left Grady and you went back to Memphis, correct?
Yes, sir.
Okay, and you said once you got back to Memphis, it sounds like you were able to attempt to start to work again, correct?
Attempt to start working. Yes, sir. After probably, I want to say, first, like when I first got back to Memphis, no, I wasn't working at all, period.
Okay.
Still in the wheelchair. Like, it got to the point, like, as I could speak about my insurance, it got to the point where no physical therapy at all, period. I had to teach myself how to walk in my mama's living room, like walking out the chair. Like, I had to teach myself how to walk. So with that being said, it's like I stated earlier, I'm self-employed, Miss Abate. No insurance, no nothing. I have a kid. I had a kid. I have a fiance. So with that being said, how do I supposed to provide for them if I'm just sitting at the house? At least I know I can't cut her like I wanted to, but I can do 1 or 2 heads for sure.
And so I guess my question was, is you did those 1 or 2 heads pretty quickly, or you attempted to once you got back to Memphis, correct?
Like I stated earlier, when I first got back to Memphis, no, sir. Probably the first month I was in Memphis, no, sir. I wasn't cutting it off.
Okay. But you started cutting hair 1 to 2 heads prior to being arrested, correct?
Yes, sir.
Okay. And you were arrested in June, I think it was June 11th of 2021, right?
Yes, sir.
Okay. So roughly 2 months after your car hit that concrete wall, correct?
Yes, sir.
Okay. And it's your testimony within those 2 months, you taught yourself how to walk again without any help of medical professionals, right? That's what you just said?
Yes, sir.
Got it. And you were arrested at the barbershop by members of Memphis Police and the U.S. Marshals, right?
The U.S. Marshals came in with big guns, talking about I had a warrant for murder. They transitioned me off to Memphis Police, I think in a parking lot of the barbershop. So yes, sir.
Okay. And it's your testimony. That's when on that day is when you learned you were wanted, that you had warrants, any of that nature, correct?
Yes, sir.
And we talked a little bit, or you talked a little bit about your medical treatment. Remember that on direct after?
What about my medical treatment?
What you remember talking about your medical treatment after you were discharged from Grady Hospital on direct? You were talking about that?
I'm asking you, what about my medical? Like, what?
The question is,
Yes.
do you remember
Yes, sir.
testifying about
Yes,
it?
sir. Yes, sir.
And do you remember, yes, the question that was asked on direct about, that was, I guess, the first time you received a diagnosis and treatment was when you saw Dr. Connolly, correct?
Diagnosis of what?
After you saw Dr. Connolly, or when did you see Dr. Connolly? How about that?
When did I see Dr. Conley? I want to say it was earlier this year for sure.
Okay.
After I received after I received the discovery, it was supposed to be, we supposed to got discovery back in December. We didn't receive it until January. I mean, yeah, January. So probably like March, April.
So would it be fair to say you saw Dr. Connolly around sometime in April of this year, 2024, correct?
It's fair to say. Yes, sir.
Okay. And when you saw Dr. Connolly, you told him you didn't remember what happened on April 9th, 2021, correct?
About the car crash? Yes, sir.
Okay. And did he, in his questions, he asked you about whether you had been in any other car accidents before or after April of 2021, correct?
He asked me, have I been in a serious accident where I had to be admitted to the hospital? Yes, sir.
And you told him no, right?
Yes, sir. Never been in a serious car accident where I had to be admitted to the hospital.
Because
Besides April 9th.
right, because the accident you had in you said October of 2019 was a fender bender, right?
I called it a fender bender because it wasn't no damage to the motor, no damage to the transmission. It was just basically the outside of the car. And I got out that car and went straight to work the same day. That's why I call it a fender bender.
Okay, and that was an instance where you were driving and the car rolled, right?
I was driving the car road.
You were driving that car and the car rolled, flipped over at least once, correct?
This right here?
Yes.
No, not at all.
Okay.
It didn't flip at all. I don't know where you get that information from. That car, it hit a curve and hit the gate. It didn't flip at all though.
So
I said that's what you read my caption. I said on GTA, you just run through the gate, right? That's what my question. This what my caption say.
my question is,
You asked me did the car roll, and I said no.
so did you caption that when I'm playing Grand Theft Auto, my car always goes through the gate and keeps on rolling, correct? Is that what you posted?
Wait to me what my comment said again.
When I'm playing Grand Theft Auto, my
When I'm
car
playing Grand Theft Auto.
goes through the gate and I keep on rolling. Is that what you posted on November 1st, 2019?
Yes, sir.
So your testimony that your car didn't roll into that gate in October of 2019.
When you explain to me your definition of rolling.
I don't have any further questions.
Okay.
What?
Mr. Miller, do you have any redirect?
Yes, Your Honor. Mr. Poole, rolling, the word rolling, you would agree could have several different meanings.
Yeah, that's why I asked me somebody to explain.
The definition that you meant on that caption, was it to continue going forward?
Yes, sir.
Now, that night on April the 9th, at about when you all left that lounge area, Mr. Abate went through, you don't remember this, you don't remember that. The very last memory that you have from that night is what?
Last very memory is like when I actually came to my senses, I didn't even I was lost. Instagram really helped me out remember everything, like putting piece to piece.
The last memory that you have is you doing what?
Getting inside the back seat,
And once you got into that back seat, what did you do?
go to sleep.
And you don't have any clue about anything that happened after that, correct?
No, sir.
Are you nervous?
It's not it won't be the fair question. Yes, you know I'm nervous. Nervous as ever. Cause it's like I'm nervous, Mr. Miller. I don't know.
I understand. People, they do different things when they get nervous. When you're nervous, do you tend to smile some?
Sometimes.
All right. In this situation here, you said you're extremely nervous right now, correct?
Yes, sir.
When objected leading, asked and answered, all of those things.
So when your questions ends with correct, when you're on cross, those are good questions. They're problematic on direct.
Nothing further.
Okay. Mr. Bate, anything else?
The sling you talked about, you post a lot on your Instagram, chopping it, you said chopping it like a fool, KP, is that what you said?
It's chopping like a fool, KP.
And in most of those photos, you are cutting hair and you're not wearing a sling, right?
I have a question. What photos you talking about, Miss Abate?
The ones on your Instagram, Mr. Poole,
Mr. Abate, you know, you ever had a dislocated shoulder?
I have.
How long you?
Let's not have a back and forth like that. He is not the person asking questions.
My question was, in the photographs on your Instagram, and the majority of them, you're not wearing your sling, correct?
You can't just ask me that question, Mr. Abate, because my pictures flourish. It's like I got pictures back. I got pictures way back. I got pictures. So I got another. Can I ask you a question? So you telling
No,
me?
don't ask any questions, okay?
You can't answer that, let me ask you more specific.
Okay, yeah. Break it down to me, please, Mr.
After
Abate.
April 1st of 2021, or excuse me, April 9th of 2021. The photographs from then on, you understand? So
Yes,
the date
sir.
of the motor vehicle crash.
Yes, sir.
Until today, okay? And the majority of those photos and videos, you're not in a sling, isn't that correct?
Mr. Abate, the last photo I just took, I was in a sling.
So one out of the rest of the photos, are you in a sling?
No, sir.
Got it.
Okay, ladies and gentlemen, pardon me?
Nothing further.
Oh, I was asking Mr. Miller. He says nothing further. Jurors, if you have questions for Mr. Poole, if you would write them legibly on one side of the card, and get them to Deputy Gordon, please. Thank you. Counsel, I'll see you for a second, please.
Well, bye. How are you? Good weekend?
Mr. Poole, tell the jurors what time you and the others left the lounge. And by lounge, I mean the place where you got wings and then someone was concerned about maybe tickets being issued.
We probably left the bar and grill no later than 2:45. I can't definitely put a date on it, 2:45, anywhere from 2:30 to 2:45.
And then tell the jurors where it was that you all stopped after you left the lounge.
From my knowledge, we didn't make any stop. The accident occurred. They said that chase started at 3:00. So there's no way we could have made any stop.
Was there a plan? Had you, maybe I didn't ask it well, had you and the people in your car said you're gonna make a stop, but you just didn't get there?
The plan was for DT to make a stop, but like I say, we left no later than 2:45. The chase started at 3:00.
Where was DT gonna be stopping?
That I don't know.
Tell the jurors when it was that you made initial contact with Mr. Miller, not what you and he talked about, but when you were describing, you reached out to, referred to him as your attorney about these warrants. When would you have first had contact with Mr. Miller?
Our first time ever having contact with Mr. Miller, probably, like I said, he came in, state trooper came in and told me I had a warrant. The nurse told him he had to end up leaving. So I probably talked with the nurse for a couple minutes. Called my mom. My mom actually the one who contacted Mr. Miller.
Do you know what the date was on the warrants? In other words, when the warrants were sworn out?
No, sir, not at all.
Mr. Miller, do you have any follow-up based on those questions?
Yes, Mr. Poole, are you aware if I know any family members or anyone in your family?
Say it again.
Object to relevance.
He'll ask it again if it's okay. What's the relevance of that, Mr. Miller? Don't tell us who you're related to if you are or you know him, but what's the relevance if his uncle went to school with you?
Right, it sounds like what's being explored is how I was contacted or why I was contacted. And there is a
Okay, but don't go into what there may be. Okay. I'll let you ask the question.
Mr. Poole, are you aware if I know or close friends with anybody in your family?
At the time of me calling or right now?
At the time.
Not at all. Like I said, my mom was the one who made that call.
All right, and since then, have you learned how I am in close ties with your family?
Yeah, so I think you went to school with my auntie. I'm just not sure.
I made that up. I didn't know you went to school with one of his relatives, but okay. Do you have any follow-up, Mr. Abate?
No, I don't.
All right, Mr. Poole, thank you. You can step down, and I don't know if you started that water. If you did, you should take the water with you.
Thank you.
Thanks.
I'm gonna take it in.
Okay, it's all yours. Leave the papers, you leave right there. Thank you. Mr. Miller, call your next witness, please.
Defense rest.
Okay. Mr. Abate, any rebuttal?
There you go.
All right, ladies and gentlemen, then the evidence is closed in this case. You have heard all the testimony and all the exhibits that'll be part of the record in this case have been admitted. We're gonna break for an early lunch because what's up next is closing arguments or summations from the lawyers. And they always like to have a few minutes to get ready, and we would interrupt one of those closings to give you a lunch break anyway. So what we'll do is lunch now. When you get back, we'll start with the closing arguments. Because the state has the burden of proof to try to prove Mr. Poole's guilt beyond a reasonable doubt for one or more of these allegations, the state gets to open and close in closing, meaning you will hear first from either Mr. Rao or Mr. Abate, and that person will sit down. Mr. Miller will give the closing argument he wants to. He's not required to give one, no burden on the defense, but I bet he will. And when Mr. Miller is done, then the state gets the last word. They'll conclude their argument. When that's done, I will give you the jury charge, the law that you must apply to the facts as you find them to be in this case. And then you'll be doing your deliberations back in the jury room. But don't start now. You've got the evidence, you don't have the law yet, and you haven't had the synthesis of the lawyers telling you, here's what was proven or wasn't proven based on the evidence that you've received. You all pulled off a 30-minute lunch last time. I don't know if that left you unhappy or if that's what you'd like to do again, or if you've had a chance to talk about it. You're welcome to go in the jury room and talk about it and just let Deputy Gordon know. We'll sit tight. We have a few things we need to talk about. Just tell him how long you're going to be gone. 30 minutes, 40, an hour. It's up to you. It's your day. And we'll be sure to be back when you say you're going to be back. So talk about it in the jury room. Let Deputy Gordon know before you leave, and we'll resume at the time that you've dictated. Any logistical questions? No, thank you very much.
All right, for
All right, you all can be seated. We'll sit tight to see how long they want for their lunch break. Mr. Bate, will you be using your special screen or just running the PowerPoint and whatnot through the Zoom system?
Through the Zoom system.
Okay. Mr. Miller, you've got the same Zoom Rooms access for whatever you want to present during your closing. Anything else from the state?
No, Your Honor.
Okay. Mr. Miller, anything else before we break for lunch?
No, Your Honor. I would just ask to renew our motion for summary.
Directed verdict? Okay. So for the same reasons as before, I find that this is a case that ought to go to the jury. It's a narrow but important question that the jurors need to decide, and that's who's driving the car. I think that there is evidence that a jury could rely on to find that the state has not proven beyond a reasonable doubt that Mr. Poole was the driver, but there also is evidence that they could rely on to conclude that he was the driver and that the various other elements were proven, the speed, the result of the crash, meaning 2 people died, et cetera. So the case will stay with the jury. What did the jury say about they're going to be back at 12:30? Okay, we should be back a little before 12:30. And as soon as you all get back, if you could start confirming that all the exhibits are in that postal bin, and if there's going to be any issues about what goes out with the jury or what doesn't, just start having those conversations, and we'll finish that up when you're done with your closings. And we will reconvene just before 12:30. Thank you. Mr. Rao, can you come up here for a sec, please? Here are 3 copies of the jury charge, so 2 for you, 1 for Mr. Miller. And here's the proposed verdict form. If you'd give that a look and then get it to Mr. Miller so I can get his thoughts, please.
With respect to knowledge.
I took it out. And I'll talk about that when we get everyone in here. I've kept Dr. Henninger's pencil.
It's a trauma man.
That's my collector's item from this. He'll be back. I give it to him.
Judge, you want this back?
Yes, please. All right, Ms. Rivers, are you ready? Great, let's get back on the record in State versus Poole. Mr. Poole is here with his lawyer. Our prosecutors are here. Couple things to get on the record. One, when I stop talking in just a moment, I'm going to give to Ms. Rivers all 54 cards that were submitted by jurors. Not every question was asked, but this is every question that was written down. And that will be Court's Exhibit 1 in the record for any appellate purposes that might arise. Number 2, I put together a proposed verdict form. Mr. Rao, did you have a chance to look at that?
I did.
Any issues?
No, Your Honor.
And Mr. Miller, I think I saw Mr. Rao share it with you. You okay with the verdict form?
No objection.
Okay, that's what we'll use. Number 3, you all should now have a copy of the final jury charge. It does not include the knowledge element. Based on the way the rest of the defense case played out, I don't think that's a necessary charge. So that's not in there. Everything else we've discussed is in there. And I did remove, as I said I would, the language about a defendant choosing not to testify, because that's not this case. Mr. Rao or Mr. Bate, anything more about the jury charge?
No, Your Honor.
Okay, Mr. Miller, anything else?
No, Your Honor.
Okay, then I think we're ready. Do we have all our jurors? He's going to check. They're all ready. Okay, Mr. Bate, you ready for the jurors to come in?
Yes, Your Honor.
You need anything set up or you're good?
Mr. Rao's gonna do those.
All right, well, then hopefully he's ready. Mr. Miller, are you ready for the jurors?
Yes, Your Honor.
Let's have them come in, please. Oh, thank you for grabbing those. I thought someone had done that. And let me give you. Okay. Mhm. Mr. Miller, there's a photo or something there on the podium. I don't know if that's yours, you can have it. If it's the state's, if you give it back to them. I don't think it's an exhibit that's in.
All right, so good. As you as president of the county for.
Thank you, Deputy Gordon. Everyone else can be seated. Thank you for getting back on time. It is the phase during which the lawyers can now give to you their closing arguments or summations. As I told you at the beginning of the trial, the lawyers are entitled to argue to you what they think you ought to do, but keep in mind that what they say is not evidence. You will be deciding what the evidence is, what the evidence means, et cetera. But there's nothing wrong with you feeling persuaded by what a lawyer says. But this is efforts to persuade you based on the lawyer's processing of what the evidence has been or hasn't been, or conflicts in the evidence. We're going to hear from Mr. Rao initially from the state, and Mr. Miller will have an opportunity to give a closing on behalf of Mr. Poole. And then one of the two prosecutors will get back up for the rebuttal portion of the state's closing. And that will be the end of closing arguments. Mr. Rao, when you're ready.
Good afternoon, everyone. Okay, put it up on that screen as well. I just can't see.
Yeah, that should is. Thank you for asking that. When Deputy Gordon returns, he generally gets that thing working. Sorry. Yes is the answer.
So while he's getting that on,
Your Honor, it's the same.
Okay, let me see. I'll work on that. I can do. What's on the screen now? Anything? Okay, I'll work on that while you get going.
so we're entering day 5, or we've gone into day 5 of proceedings. Now we're at a close. This is where the opportunity arises for both the state and the defense to come up before you and talk to you a little bit about the evidence that's been presented to you and the law that the judge is going to instruct you on. And that's going to be kind of my task on behalf of the state. I'm going to use this first opportunity that we have to kind of talk to you a little bit about the law and the legal principles that Judge McBurney is going to charge you on just before you have an opportunity to go back there and deliberate as it relates to the facts and evidence of this particular case. And so you and I will be talking a little bit about the charges that the defendants indicted for, the burden of proof, types of evidence, as well as the elements of the crimes that he's been charged with. And before I get into the details of those things, there's really 2 types of cases that prosecutors and defense attorneys try every time a case goes to trial. The first type of case is defendant essentially stating, yes, I did it, but there is a legal justification for why I did it. So it's, I did it, but there's something else that happened that allows me to do that. And so the defense in that particular type of case will be consent or self-defense. Yes, I have a reason to be where I'm at, or yes, I have permission to do this, or yes, I acted in self-defense. Yes, I did shoot the victim. Yes, I did kill the victim, but the victim put himself or herself in a position where I had reasonable justification. So that's case number one. But that obviously does not apply here. So case number two is the defendant essentially asserting the defense, I didn't do it, it wasn't me. And that's essentially what we have here, because the question presented to me, ladies and gentlemen, I assume that it is probably the biggest question that you all have when you go back there and deliberate, is did the state prove its case beyond a reasonable doubt that Kenneth Poole is the driver of the vehicle? Because I think it's a safe assumption to say that the driver of this vehicle committed all the charges that's presented to you before this night, right? The question isn't whether or not a crime was committed. The question that we have before us is who committed the crime. So the question is Kenneth Poole the driver beyond a reasonable doubt? Okay? So that's the standard that the state is burdened with, beyond a reasonable doubt. It's a phrase that all of us have likely heard throughout the course of our lives at least one point in time. They make TV shows about it. But a lot of people don't really know what that standard is when it comes to a courtroom and you're deliberating on a particular case. So what I always like to do is talk to you a little bit about what it's not. It's not proof beyond all doubt. Meaning you don't have to be 100% sure in order for a case to be proven beyond a reasonable doubt, which is why there's no mathematical number or percentage associated with reasonable doubt. It's not 100% sure, it's not 95% sure, it's not 90, 70%. It's not a very arbitrary doubt. It's not a doubt for the sake of having doubt. What it is and what it's legally defined as is a doubt of a fair-minded juror honestly seeking the truth. That is the legal definition. It is a juror looking at the facts and evidence and testimony presented to you throughout the course of this trial and looking at the truth as to what it all means. So if there is a doubt that you have, it has to be based on common sense and reason. Common sense is going to be something that we're going to harp on, both myself and Mr. Abadi, throughout the course of this trial. Because you can absolutely use that when you go back there and deliberate as it relates to the facts and evidence presented to you throughout the course of this trial to determine whether or not Kenneth Poole is the driver beyond a reasonable doubt. Right? And so another way I like to explain it is the difference between what is reasonable in a scenario and what is possible in a scenario. Because we've all heard the phrase, anything is possible, right? Throughout the course of our life, we've heard, anything is possible. That is not the standard in a criminal trial. The standard is what is reasonable. And so that's how we approach that when we look at this case. And so kind of a real life example I like to give jurors is something that we all probably do at some point in time throughout the course of our lives, which is go to the grocery store. So when I go to the grocery store, one of the aisles that I hit is the aisle where there's cereal. And so I go to my favorite cereals, Honey Bunches of Oats, but that's always what I typically get. And so when I go to the aisle, and I go specifically to that section where there's Honey Bunches of Oats, I pick up the box and I look at it, and on the box it says Honey Bunches of Oats. I don't actually get to see what's inside the box, right? It's just a box. It's labeled Honey Bunches of Oats, but I have to open it to see what's inside. So I take the box and I put it in my cart. And it's reasonable for me to assume that what's in the box, even though I didn't actually see what was in the box until I got home after I paid for it, that Honey Bunches of Oats were in there. Right? None of us go to the grocery store in that type of situation and open up every box where we can't clearly see what the contents are inside in order to make a determination that yes, that box does have Honey Bunches of Oats. And much like that, we know that even though we weren't inside that car, that Kenneth Poole is the driver, based on the evidence beyond a reasonable doubt. And based on the evidence presented to you throughout the course of this trial, that is the truth, that Kenneth Poole was the driver of this vehicle at the time that Trooper Clark initiated a traffic stop and the defendant responded by fleeing and eluding, ultimately killing two of his friends, Terrence Minor and Devin Jones. And in seeking the truth, when you go back there and deliberate, there are going to be things that you should and should not consider. All right? And so the things that you should not consider are things like disagreement with the law that Judge McBurney charges you on. Consequences, if any, on the defendant, which again is within the sole purview of Judge McBurney. Public opinion or dislike of police. Like for instance, if some of you don't like the fact that part of Georgia State Patrol's mandate is to initiate traffic stops and thereafter pursue the suspect if they flee, the question isn't whether or not we like that. The question whether or not the person who initiated the chase, i.e. the defendant in this case, did those acts. It's not a question of passion, sentiment in this particular trial, conjecture, prejudice, if any, or any sympathy that you might have on either party. The question is Kenneth Poole the driver beyond a reasonable doubt? And so the things that we do consider when answering that question is the law that Judge McBurney is in charge of, the elements of the crime, which we will talk about shortly, photos, documents, video that's been presented to you throughout the course of this trial, specifically the dash camera footage, the defendant's actions. We know what the defense is. The defense is it's not Kenneth Poole. And they've gone a step further and dragged the deceased individual under the bus by naming him the driver of the vehicle at the time that the pursuit happened, even though the physical evidence and the laws of physics don't agree with that sentiment. You've got the defendant's actions, his statements, both to Trooper Clark as well as before you, ladies and gentlemen, and most importantly, the demeanor in which he had, specifically when he was responding to Mr. Rabadi's questions. Because I didn't hear the same tone coming from him when he was answering Mr. Miller's questions. I'm sure he was just as nervous then, but we didn't see the smirks and making light of the situation as we did when he was being cross-examined by Mr. Rabadi. You look at the lay witness testimony and the expert testimony, which is going to be really important in this particular case, because Trooper Lee is absolutely able to tell you exactly what the laws of physics would do to the individuals inside the vehicle. And we actually saw a real-life demonstration from Dr. Henninger about what the laws of physics would have done on those paper clips when the paper hit his hand. They all moved front right. Those are things that you can consider. The credibility of those witnesses, the logical inferences, common sense, and most importantly, the evidence. The logical inferences and common sense, right? What makes the most sense in this particular case? Given the evidence that we know it to be at the time of the crash, as well as Dr. Henninger's testimony and Trooper Lee's testimony, as it relates to the question of who the driver was in that particular time of the pursuit. So when talking specifically about evidence, there's going to be two types of evidence that the law classifies. There's going to be direct evidence, things that we can see, hear, touch, smell. So for example, in this particular case, it's going to be the dash camera. It's going to be Trooper Clark's testimony about his response to the scene. It's going to be what we see here from the witnesses, as well as the documents and exhibits that has been before. Circumstantial evidence is taking a look at a bunch of direct evidence or a bunch of facts that have already been established, and then inferring a different fact or another fact based on those series of facts. So that's what circumstantial evidence is. And the way I describe circumstantial evidence to jurors is, again, something that we all probably do at one point in time in our life, if not more than once a month, which is to fill up gas. So at some point in time, we're going to look at our fuel gauge, and our fuel gauge is going to go closer to empty as we continue driving the vehicle. And if you're anything like me, you wait till that yellow light comes on before you start spending money on gas. And so in this scenario, you know, when you're in that position, the thing that you have to do is, of course, go to the gas station and fill up gas. So you stop at a pump, you get out of the car, you put your credit card at the station, you select which grade of fuel that you need for your particular car, you open up the tank, put the nozzle in, and you pull the lever. And you hear something go into your car. You see the number of gallons increasing, you see the price increasing even more. And even though you don't actually see it, you're able to take a set of facts and draw a logical inference from it. The fact that you are empty on fuel, the fact that you're at a gas station, the fact that you've done all the things associated with a person paying for gas and using gas. And even though you don't actually see the gas go into the car, you know that there's gas going into your car, right? And the way you know that is by taking out the lever when it's done, taking out the nozzle, pulling the lever down, putting it back in its place, getting in your car and driving off. And you see this fuel gauge going from empty to full. And even though you didn't actually see fuel go inside the car, you're able to drive the vehicle, which allows you to draw the inference based on all those facts that have come before, to make the assumption and inference that you have gas in your car. And so even though you didn't actually see it, you're able to look at the circumstances in that particular situation to make an inference that is reasonable. And what Judge McBurney is going to tell you is that there's no special weight placed on direct evidence versus circumstantial evidence. It actually weighs the same amount in the context of the law, meaning you get to look at circumstantial evidence just as good as you would direct evidence. It has the same value for your consideration when you go back there and deliver. And so the types of direct evidence, specifically as it relates to this particular case, is going to be Trooper Clark's dash camera footage, where we see the traffic violation from the Infiniti, his narration of the events that he's observing, when he turns on the lights, when you see the vehicle speed off, and when the vehicle ultimately crashes, Trooper Clark's response to the scene. That's all direct evidence. The fact that it's been established that the defendant's entire body was in the front of the vehicle, with his head sticking out the front passenger portion of the vehicle and his feet near the driver compartment. All consistent with someone moving front right, in the direction of the impact that the car sustained. Direct evidence shows that the damage to the vehicle was to the front passenger portion of the vehicle. And if that is the direction they would be moving in, as we saw from Dr. Henninger's demonstrative, and specifically Trooper Lee's testimony, the bodies inside that vehicle would be moving front right. The fact that Mr. Minor's entire body was in the rear portion of the vehicle. Not anywhere in the front, but in the rear. The fact that Trooper Clark's testimony that the defendant told Joe Connors, who then repeated to him that the defendant told him he was driving, or that he was the driver. That the defendant told Trooper Clark that he was the driver upon Trooper Clark's follow-up. That's direct evidence. Again, the laws of physics, which don't bend for anyone's will, which doesn't serve as an advocate for either side, all support the fact that they were moving front right in the direction of the front passenger impact. All show you the direct evidence points to one person, the defendant, as the driver at the time that the pursuit happened. Circumstantial evidence is taking all the reasonable inferences drawn from the series of facts. For instance, the fact that the defendant was found in the front passenger seat, the fact that it's his car, the fact that he told Trooper Lee and Joe Connors that he was the driver. And even though we weren't in the car with him, even though the dash camera footage doesn't actually show you what's inside that car, we know from a series of logical inferences, from a series of facts, that we can draw the logical, reasonable inference that the defendant was the driver. And so that's the evidence, amongst others, that's been presented to you and which you'll have to go back there and deliberate as it relates to whether or not the question has been answered as to Kenneth Poole being the driver beyond a reasonable doubt. And so you take a look at the types of evidence, specifically the witness testimony, as well as their credibility to testify to the things that they did, the photos, documents, and video, and the defendant's statements and actions to make your decision as it relates to whether or not there is a reasonable doubt as to whether or not Kenneth Poole was the driver. So credibility of the witness is important, and I think it's important specifically as it relates to Trooper Clark, right? Because from what I can gather and understand from the defendant's testimony, is that the statement didn't happen, period. For that to be believed, we have to accept that Trooper Clark just lied point blank on a report that a defendant, as well as an EMT, told him whether or not the EMT responded, or excuse me, whether or not the EMT remembered. We know he responded. As to whether or not he would lie on a report and then come sit before you, ladies and gentlemen, in this seat under oath and lie to your face that the defendant, who has an absolute motive to call Trooper Clark a liar, was in fact lying. Or is it not more reasonable that Trooper Clark admittedly probably should have recorded that statement, but that statement did in fact happen, and that the defendant did in fact give that statement? Not only did he give that statement, but he did so voluntarily. Because while the defendant might tell you that he doesn't recall, every person that evaluated the defendant from the time of the scene up until days after all said that he was conscious and alert and coherent. If you've been to the hospital, you know that if you're awake, these doctors will talk to you. And they're writing that because their responses to whatever questions or inquiries they have is letting them know the defendant is alert, conscious, and coherent. Coherent. Meaning he absolutely understood when Trooper Clark asked him the question, why did you run away from him, right? If any of you have been pulled over by Georgia State Patrol, which I will confess I have, you know that one of the first things that they do is, why did you do this? Why did you do that? Why were you driving 75 and 55? Any particular reason? So that's absolutely consistent with what Trooper Clark was trying to do. Why did you run away from him? I'm sure that was a question he had. And then the next question he asked, after the defendant responded, I don't know, was, is this your car? What did the defendant say? Yes, because that is in fact his car, showing that he understood the question being asked of him by Trooper Clark. And then the follow-up question is, were you the driver? And he said yes. Now, either that statement didn't happen, which would mean Trooper Clark lied. And again, what would be the motive for him to lie on a report and then come back here 3 years later and again lie to you about a statement? I mean, a point blank lie, making up a story. What would be the motive that Trooper Clark has? A man who has been hit 3 times in the line of duty and still continues to patrol the streets and the highways of Georgia. Lie to you. That's what they want you to come away with, even though there's no evidence that he lied. Just like when they pointed out that there's nothing in the medical records to show that Trooper Clark went to the hospital before he informed the defendant of the warrants. There's also nothing in the medical records to suggest anywhere remotely that his friends and family came to visit him at 8 o'clock that morning or in the days subsequent. But we know that they went there. Obviously, that's reasonable to presume. They told you that they did. But there's nothing in the medical records. Does that mean it didn't happen? No. Trooper Clark put that in his report because that's exactly what Joe Connors told him that night or that morning. And that's exactly what the defendant told him later on. And that's exactly what he testified to. And again, the testimony of a single witness, if believed, is sufficient to establish the fact. There's no legal requirement of corroboration of a witness, although in this particular case, because it's the defendant's statement, there is a slight corroboration requirement for the defendant's statement, and that corroboration is the fact that he's in the front seat. He's in the front part of the vehicle. And the laws of physics dictate that they were all moving front right in the direction of the passenger compartment, which explains why his feet are in the driver compartment and his head is sticking out the front passenger window. Intent is really not so much an issue in this particular case. I think we can all agree that the person driving the vehicle intended to commit the acts. It's not the intent to commit the violation of the law, it's the intent to commit those acts. It's the intent to drive in excess of 100 miles an hour. It's the intent to switch or change lanes without your proper turning signals. It's the intent to turn off your vehicle lights at 3 a.m. in the morning so that you don't become noticeable to the individuals pursuing. It's not the intent to violate the law, it's just simply the intent to commit the act, which is fairly clear on the dash camera footage. So now as we kind of wrap things up, I'll talk to you specifically about the charges in this particular case. So he's charged with 2 counts of felony murder. 2 counts because there are 2 individuals that lost their lives and were killed. Terrence Minor and Devin Jones. And so what felony murder requires is a person causing the death of another human being during a felonious act. So while you're committing a felony, a person dies as a result of that commission, and therefore you are guilty of felony murder. It's not the intent to cause death, meaning the predicate felony, which in this particular case is fleeing and attempting to elude Trooper Clark. The defendant does not have to have the intent of understanding that his actions may cause the death of another individual. It's just that a death occurred during the commission of that fleeing and attempting to elude, which is why he's charged with 2 counts of felony murder predicated on fleeing and attempting to elude, because that act resulted in the deaths of 2 people. And so the predicate felony, as I was discussing earlier, is fleeing and attempting to elude. So what is fleeing and attempting to elude within the confines of the law? It's It's failing to bring your vehicle to a stop after being given visual emergency lights. To stop, which, you know, any one of us on this side of the room would know that when you see police lights in the back, your job is to make way for them. Either you're the reason why the lights are on, or you're in the way of the reasons why the lights are on. And so our job is to move to the right and give them a safe space to pursue wherever it is they need to pursue. That's obviously not what happened here. And not only is that not what happened here, but the defendant drove his vehicle in excess of 20 miles over the posted speed limit, which in that particular area was 55 to 65. And we know that Trooper Clark saw the speed limit at 55, that particular area, at the intersection where 75 and 85 merge. And notice he was going 95 in the nature of movement. And pursued the individual, didn't actually start his lights, but when he did, the defendant started driving in speeds of excess of 100 miles per hour, topping out at 130 miles per hour, as we saw from the airbag control module. So the defendant, the driver, was absolutely fleeing and attempting to elude Trooper Clark. Which is why, upon the conclusion of that particular act, which resulted in that crash, 2 individuals died, and the defendant is charged with 2 counts of felony. Counts 3 and 4, homicide by vehicle in first degree. Counts 1 and 2 were felony murder. Count 5 is fleeing and attempting to elude, which is the predicate felony for counts 1 and 2. Now we have the last set of counts that we'll discuss. Counts 3 and 4, homicide by vehicle in the first degree. The elements of that are driving a vehicle with reckless disregard for the safety of people and property at the same time. And reckless disregard, as it's been indicted and charged in this particular indictment, is driving with speeds in excess of 100 miles per hour without exterior lights operating, without utilizing your turn signal when changing lanes, and disregarding a traffic control device, i.e. the red light that was testified to by Trooper Clark as he was getting off on the exit for Lennox Road. We know that he was driving in excess of speeds of 100 miles per hour because the airbag control module confirmed that 5 seconds prior to the crash, the defendant was operating the vehicle in excess at 130 miles an hour, in excess of 100 miles an hour. We saw on Trooper Clark's dash camera footage that the vehicle turned off its lights just before or shortly before getting off the exit ramp towards Lennox Road. And we saw the vehicle change lanes multiple times, weaving in and out, as Trooper Clark testified, from one lane to another without his turn signal. And of course, by failing to stop at the red light, he disobeyed a traffic device or traffic control device. And because 2 people died, that's why the defendant is charged with 2 counts of homicide by vehicle in the first degree. Because again, just like the felony murder counts, there are 2 deceased victims in this particular case as a result of the defendant's actions. And so all the evidence, when looking at it from a reasonable doubt standpoint, points to the most logical, reasonable conclusion that the defendant is the driver. And I'll leave you with this question that I've been trying to wrap my head around, that I'm sure some of you have also been trying to wrap your head. How does 2 grown adult men, one sitting in the front driver's seat, one in the rear, completely swap spots after the crash when those seats are no longer seats, but barriers and obstacles, just like every other part of that car. And how they just happened to miss each other, how they would have not hit each other, and how the backseat passenger could completely end up in the front portion of the vehicle, while the driver completely ends up in the rear. Is that reasonable? The answer is no. The answer is, it is the defendant who was driving the vehicle when Trooper Clark attempted to initiate a traffic stop. Because of the defendant's actions, we have 2 dead bodies at the scene. 2 dead victims. Darius Jones, Darius Minor, and Darius Jones. Appreciate your time. Thank you.
Thank you, Mr. Rao. Mr. Miller, when you're ready.
Ladies and gentlemen, I want to thank you for your time. I want to thank you for your attention. From the questions that you all were asking, I could tell that you all really had a lot of insight and that you all were really looking into the facts of this case, looking at the evidence as it was presented, and trying to figure out this case just as we have. You all have met me before. My name is Steve Miller, and I've been representing Mr. Poole. I've had that privilege for 3 years. For 3 years, we've been fighting. Now we're at the end. I would like to go over some of the law that you all are going to be presented with once this case gets back to you all in the deliberations as well. First, all right. Sympathy and prejudice. Your Honor is going to give you a number of instructions when you all go back to deliberation. Your verdict must be based solely upon your consideration of the evidence according to the laws given to you in this charge. It's your duty to consider the facts objectively without favor, affection, or sympathy for anyone. It is your duty. It is also your duty to report to your honor if you perceive that a juror is making decisions based on improper considerations of race, gender, religion, or sexual orientation. The only thing that you all have to make a decision on is the evidence that you all will get once you start deliberating. In addition to that evidence, your common sense, your experience, your own logic, and everything that comes with that. Mere presence. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of that crime, unless the evidence shows beyond a reasonable doubt that the defendant committed a crime, helped others to do so, or otherwise participated in the criminal activity. What do you have in this case? You have 3 individuals that were occupying a car, and you've heard from every loved one, with the exception of a few barbers from that barbershop, what they saw that night. And they all told you that the person that they saw driving when they left was Mr. Minor. They all told you in their own way that the person that got into the back seat and the person that was the last one to the car was Mr. Poole. They also told you that they were closer to Mr. Minor than they were to Mr. Poole, that they had worked with him longer. The simple fact that Mr. Poole is in that vehicle does not make him guilty beyond a reasonable doubt. Proof beyond a reasonable doubt. The judge is going to give you all an instruction on proof beyond a reasonable doubt. The defendant is presumed innocent. This presumption remains with him unless, I probably should have underlined that and put it in bold, because it is unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. As you all came in here, Mr. Poole was innocent. And the hurdle that they had to climb was to prove to you all beyond a reasonable doubt that he was the person behind the wheel of that car. And I submit to you that they have not done that they have not met this burden at all, that there is no evidence that shows that Mr. Poole is the actual driver of that vehicle. We can talk about physics all we like, but I don't remember anybody coming to that stand that had any type of degree in physics. That didn't happen. They could have called somebody that had a degree in physics that could explain this, but they chose not to. The state must prove beyond a reasonable doubt every material allegation of the indictment, every element of each crime. There is no burden of proof upon the defendant, and that burden never shifts to him. If the defense is raised by the evidence, which we did in this case, the burden is on the state to disprove the defense beyond a reasonable doubt. And you got a lot of doubt in this case, a whole lot of doubt. The main evidence that we presented to you were the other barbers. And there was not a shred of evidence that they presented to show that any person that worked at that barbershop was not credible. Not a one. In fact, their cross-examination was simply, it was my direct. It was the exact same thing that I said on direct. They just repeated it for me. I appreciate it, but there was nothing that showed anything contrary to the stories that each one of them had lived that day. And they all remembered it, not because they wrote a report that had all type of faulty facts in it, but because they had lived it. They had the trauma. They actually broke down on the stand. People cried. We had to be offered tissue. They lived this trauma. There were some things they needed to be reminded of, exact times, because who remembers exactly what time anything was done? But because of, thanks to Instagram, thanks to these photos that they took, thanks to the video that they took to memorialize that what was supposed to be a good time, thanks for them for memorializing that time, we know some of the times that things were going on. We know some of the times that were lined up. We know when Mr. Poole was cutting hair. We know when Mr. Minor was taking a video inside the restaurant. We know these things because of those videos, because of those times, and because of those things that they did to remember that trauma for them. Plenty of doubt in this case, and as I stated, not a single one of them can be shown as not credible. Corroboration is one of my favorite things. When I was on the other side, what I would do is I would have you say something, and then I would corroborate it with some evidence. I would have something else. This was made, and then I would corroborate that with some evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction. Even if you believe and that should have been bolded, unsupported statement, there is no specific amount of supporting evidence necessary. You must determine whether other evidence, proven beyond a reasonable doubt, sufficiently supports the defendant's alleged statement to justify a conviction. There is not a single piece of evidence that supports any statement that they allege Mr. Poole made. Not one. You've seen Trooper Clark up on the stand. As disinterested as he seemed, as well as the rest of the GSP that testified, he had to admit, I don't have audio, I don't have video, I don't have a statement from Mr. Poole that says that he said this. I don't have anything, nothing to show that that statement was made. So how are we going to even say this statement even happened? EMT, Joe Connor said, I don't even remember this incident. And not only do I not remember it, I can't testify to that. I cannot testify that I told him that I said this. You know what corroborating evidence would have been? EMT Joe Connor, you told me this on such and such date at such and such time. Can you write this statement saying that you said this? Sure. Because 3-4 years later, or if y'all decide to charge the wrong person with something, I might need this. It wasn't done. No corroboration, nothing to show that that happened. So yes, I'm calling Trooper Clark a liar. Statement of the defendant. There's been a statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, or fear of injury. The burden of proof is upon the state to establish that that statement was voluntary. If you do not find that the statement was voluntary, you may not consider it for any purpose. A person that has just been in an accident where he hit a wall going 78 miles per hour, and the first thing you want to do is talk to this person about what happened. This person is in and out of consciousness, and you'll see it on the video, and we are going to rely on him saying something. This person cannot see anything, and you're going to claim that he was alert, conscious, able to have a great conversation. It's not a voluntary statement. At that point, He honestly could have sold him the Brooklyn Bridge. And you know what Trooper Clark would have came up here and said? I asked him if he wanted to buy the Brooklyn Bridge. He said, yes. I asked him if he knew it was me that was selling him the Brooklyn Bridge. He said, yes. I asked him, do you know if it's me that's giving you the Brooklyn Bridge? And he said, yes. That's what Trooper Clark would have said. Expert witnesses. You heard from expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert like that of all witnesses should be given only the weight and credit you believe it should receive. The experts that we had was Dr. Henninger. That was the first one. Dr. Henninger is an expert in pathology. He is an expert. He is a medical examiner. He is not a physicist, the person that does physics. That's not him. He said, for that, you gotta talk to my son. He would be the person in the best position to tell you any of this. So everything that I'm giving you I'm giving it all I got. I can't give you any more. They tried to have Corporal Lee as their expert. He said the same thing, I'm not an expert in this. But somehow he knows that bones can break in different ways, even though he's not a doctor. He's never went to any medical school. Let's use our experts for what they're experts for. Stay in your lane. Dr. Conley stayed in his lane. I work as a chiropractor, but I own several businesses dealing with the brain. I have several qualifications, several board certifications, a lot of education, a lot of hours in TBI, in traumatic brain injury. I look at other records and I follow the AMA guidelines to make an opinion based upon those records. And a lot of times I'm able to find things that the treating physician did not find. He did not come up here and tell you the direction that people go inside of cars when they're inside them. He did not tell you how accidents work. He did not tell you any of that. Based off his experience, he told you what his expertise is. And it is, I see patients that are in motor vehicular accidents quite often. I've seen over 200,000. Trauma being mostly vehicular accidents. This is what I do and have done for 26 years. That is your expert. And the credibility that he should be given is the credibility in his expertise. Poole suffered from a traumatic brain injury. He couldn't sign a will. He could not drive a car. Why on earth would an officer be trying to talk to him? I forgot one thing about corroboration. When we talk about stacking, when we talk about that evidence and that evidence actually making sense, I told you all how you get one fact, you get some support to it. Give another fact, you give some support to it. Listen for the supporting corroboration. Because everyone at the barbershop, their details were different, but they matched. The corroboration was there. And that's why there was nothing that they could say besides what I already said regarding their statements, regarding what happened that night. Evidence, where does your evidence come from? In this case, you all have several exhibits. You got pictures, you got videos. and you got testimony. Testimony is evidence. Where did that testimony come from? It came from Trooper Clark, who came up here and lied to you. It came from gas. It came from Corporal Lee. It came from Trooper Buffington. It came from EMT Barry, Dr. Henninger. It came from Tate. And it came from Ms. Martin. That's the testimonial evidence that you all have. But that's not where it ends. Because the further evidence and testimony that we have is that from Mr. Williams, from Ms. Jefferson, from Dr. Conley, from Mr. Harrington, from Ms. Lewis, from Ms. Poole, from Mr. Phipps, and from Mr. Poole. That's the rest of the evidence. That's the counter. It's not typical that you see a list of witnesses equal to, if not greater than, the list that they provide. But when you do a half-butt job at investigating an accident, and you only investigate what happens, I'm not even gonna say investigate, when you only start the story at the crash, and you do nothing further to talk to anybody, to speak with anybody, then the only picture you get is the one that was rushed to by Trooper Clark. Ms. Martin, I honestly did not have any questions for Ms. Martin before she came up here and testified. I was not going to ask her a single thing. But Ms. Martin, you all heard it. She said that Mr. Minor was in the car when they left Memphis. That's what she said. That's what he asked her, who was in the car? She said, I called, and it was KP in the car, and Mr. Minor was in the car too. All of a sudden, when I asked her a question, I'm putting words in her mouth. But that was her testimony. Why lie when the truth is enough? If the truth is enough, then why do you need to lie? Mr. Tate, he said that this was my cousin and that we were close. He hadn't spoke to him in a while, but out of nowhere, he calls him at 3 a.m. in the morning to talk. No corroboration, no phone record showing that they spoke. He tells you that he interrupted a live video, but in order for it to be a live video, it has to be uploaded, and so it's a story. He doesn't even know where that video came from. No clue where it came from. And what does the video show you? That at some point, Mr. Poole was driving a car? We already knew that. What else did we need? Why lie when the truth is enough? Why say Mr. Minor was sitting in the back seat when we don't see him in the back seat of that car? Why lie when the truth is enough? Trooper Buffington came and he testified that Mr. Minor was crunched in the back seat of the car. If you remember, Trooper Clark testified that Mr. Minor was laying in the back seat. What are we talking about a back seat? They're on the roof of a car. There's no such thing as a back seat on the roof of a car. I'll tell you our theory of how they ended up in the positions, but I'll also tell you this. This crash can happen 1,000 times, and the state would expect everybody to end up in the same place every single time. That's not how logic works. Where is his dash cam? Where is his view of the scene? Because he was there. He stated he was there to help put out the fire. Where's his dash cam? Where is Gas's dash cam? All of these officers responded to the scene, yet the only dash cam footage that they gave you was Lion Trooper Clark. That's the only one. Why? Why is all of this evidence not being shown to you? Gas reported that or testified that he conducted CPR on Mr. Jones. And again, no dash cam. He had somebody in his car. He was on a DUI. He got there minutes later. Still, no dash cam. And why not? Why don't we have other views? Why can't we see the other views of the car? EMT Connors, do you remember his actual testimony? What we mostly learned of him was his background. 17 years as a paramedic. He was a Marine. He said, I do not have any independent recollection of these events. I cannot testify that I told Trooper Clark anything. That's what his testimony was. I can't say that I said that. He said, I do not recall telling Trooper Clark that. Those were his recollections. I don't recall telling him that. It's in the report. We'll go through the report a little bit later. But that's what Connors is telling you. I don't know any of this. EMT Baird says he responded to the crash, was dispatched at 3:08. They did not arrive on scene until 3:25 a.m. So prior to 3:25 a.m., EMT Barry has no clue what was going on. He says that Mr. Poole was talking to the fire and that he was alert. The video does not show Mr. Poole talking to fire. The video does not show when fire is on the scene. Much of any discussion. And for the sake of time, I'll only show you portions.
And like,
This is fire on the scene. What we do see is them. What we do see is them trying to get Mr. Poole out of the car. What we do not see is.
STE11 and right from.
What we do not see is, or hear, is any discussion between Mr. Poole. Is any discussion between Mr. Poole and fire? None.
I found disconnected.
He also said that this scene was substantial. That he's seen a lot, but this was a bad one. A bad wreck. He admitted that he did stay 15 feet away from fire while fire attempted extrication. He said, I encountered him from a distance because I let fire extricate him from the video. What you're also not going to see from the video is any extrication. You're not going to see Mr. Poole leave the car. You're not going to see Mr. Minor leave the car. He said the damage to the vehicle was to the front and to the side. They're making arguments as if this car just hit the side and that everything just went to the right. This car had front end damage. Not just side, front and side. He stated that Mr. Poole was laying on his back on the roof of the vehicle. And then he stated, if you are the driver, you would expect to see injuries. If you are in the back seat, you would expect to see less injury. I would argue, if you were the driver of that car, if you're in the front seat of that car, you're not only going to see some injuries, but you're going to see some really, really bad injuries. And that you're more than likely not going to come out alive. And that you're in the back seat. Once you'll see the actual back seat of the car, those less injuries, the fact that you're in the back seat, that you have duffel bags and book bags and everything else back there with you, you're going to see less injury. And you might be able to walk away. He said while he's in the back of the EMT, the back of the ambulance, his primary focus is on keeping the person alive. He said the report states he was alert. I cannot say from memory if he was alert. He said, I am simply going off what the report says. He said he kept the mask on Mr. Poole, that same mask that fire had him on during the ride to the hospital. And you all will see, or you all saw, that when his cousin came to the hospital, this same exact mask was still on him hours later. When Trooper Clark stated, I was having this coherent conversation with him. Same mask is there. He said that a Glasgow coma scale going from 15 to 11 is a huge cause of concern. Huge cause. And we had that level of concern because the medical records show that as soon as he got to the hospital, that 15 that EMT Barry said that he had decreased to an 11. And so in that state, you're not going to expect to get any kind of communication, let alone a statement from anybody. Again, his recollection about anything being alert was coming from his memory. And as we saw from Dr. Conley, there were things in his report that he missed. He said there was no complaints of back injury, yet the medical report said that he had fractures in his back. Dr. Henninger. I'll show those pictures and then I'll get back to this. We know that Mr. Jones slid after he was ejected from the concrete. And I wish that I could explain this part some other way than I can. I haven't, I've tried. But we know from his injuries, and this is, you all know these, we used to call them strawberries. This is from concrete sliding and him sliding. We know that it wasn't a situation where he got out of the car or was ejected from the car and landed flat. There was some movement of his body against that bridge. Dr. Henninger stated that there were contusions, abrasions here, in this direction, right here, and on the abdomen, right here. What does this and this look like? It's the outline of an airbag. You'll have it with you, but it looks just like an airbag. It's right here. And when you all get back there, you'll be able to look at it for yourself and say, it is an airbag. Look at it, it's right there. What he said, I don't know what causes this. You know what could cause that? If you're in the driver's seat, what's to the right of you? The center console. So after you're hit with this airbag, after you're hit in the head by the airbag, once you go flying to the back of the car, you're gonna have to rub up against something, and that center console is right there to create this injury right here. He noted that the rib fractures were consistent with the airbag. We wait on the PowerPoint to catch up. The injuries that he reported, contusions on the chest, which you all saw from the airbag, those from the other picture, the injuries to the chest right here. Abrasions on the right abdomen, that was down here where you all saw where it helped to make a circle, which is the airbag. Internally, contusion on the lungs, where are your lungs located? Right here. Laceration on the liver. Horizontal laceration on the hilum. He said the gallbladder ruptures. Gallbladder is located right here. I said that's something that could be caused by an airbag. Yes, that is something that could be caused by an airbag. The right ribs, 4 through 9 were fractured. 1, 2, 3, 4, 5, 6, 7, 8, and 9. All the fractures. All fractures of these ribs, all of these ribs, the fractures could be caused by an airbag or a steering wheel. The steering wheel is more likely And that according to the testimony of Dr. Henninger, Dr. Conley, as well as EMT Berry. And I'll submit to you that the airbags did nothing in this case. Nothing for anybody in this accident. He said that there was hemorrhaging on the left side, I mean, there's some bleeding over here, but that they weren't fractured. And then the pubic symphysis was slain. That's at the bottom. And then the right upper extremity humerus fracture was right here. All of these injuries are consistent with somebody hitting the steering wheel, somebody driving a car, somebody being in that front. Right humerus fracture consistent with airbags, the passenger chair. I'm gonna show y'all what that passenger chair looks like in a moment. Because they didn't show it to you. The contusions are similar for both front seat passengers. You see some of the same stuff right here. What's that? That's the side of the door. Right here on Mr. Jones. Mr. Minor has a burn mark on the right side. Mr. Jones has a similar on his lower right side where that door is. And one of the most important things that Dr. Henninger said was, I can't put anyone in any position for sure. He can't definitively put anybody anywhere. That's why he uses the police report, which they gave him, which already had stated that Mr. Poole was the driver because there was no investigation. And he stated he didn't even see the video until the prosecutor showed him the video before court. Only thing for sure is the passenger. And why is the passenger the only one for sure? Because we know that the passenger was ejected in the car. Then he stated that ribs are hard to break. It's not easy to break these ribs. But the force of a person going 78 miles per hour into a steering wheel certainly makes it a lot easier. And remember, Mr. Poole doesn't have any fractures in his ribs. Nothing in his torso is fractured. The car was going 78 miles per hour into a wall. Lion Trooper Clark, who did this horrible investigation from the beginning. He admitted on the stand that he did not even follow his own policy and procedures for Georgia State Patrol. I asked Trooper Clark about documentation. Georgia State Patrol policy manual says that everything should be properly documented. He admitted, yes, this is important to document everything. So much importance is on documenting that he said when the chase first started, I turned my camera on manually because had I waited to turn the blue lights on, it goes back 2 seconds, and then you all would not be able to hear any of the dialogue. So that is very important. Yet, there's no documentation at all by Trooper Clark. The policies and procedures say that when you're conducting interviews or interrogations, and if those interviews are likely to elicit incriminating statements, they should be recorded. They should be documented properly. This is your corroboration. He did not document it at all. He says, yeah, I have an iPhone. I'm not gonna record it on there. We didn't discuss the state issued phone if he had one. He didn't go back and try to get any type of recording. He has nothing to corroborate his statement. The smallest thing that corroborated would be the hospital saying he was here and we made a note of it. Now, the reason why they documented the second time he came, after he had secured the warrant on the 17th and the 18th, was because there was an actual physical response to Trooper Clark being there. His blood pressure increased. His heart rate increased. These are things that you cannot fake. He had an actual physical response to the officer being there. But that was on the 18th. And that was when he told Mr. Poole, I have warrants for your arrest. And rightfully so, Mr. Poole, confused, because he doesn't have any clue what's going on, had elevated heart rate. His blood pressure increased. He had a physical response to it. Nothing in the report, the medical report, shows that that interaction ever happened. And yes, I am calling Trooper Clark a liar. Because as far as this goes, he has nothing to show that he went that day. He couldn't tell y'all the time. He couldn't tell you the date. He couldn't tell you if it was dark outside, if it was light outside. He can't tell you if anybody else was in the room. He can't tell you if there was a nurse there, if there was a doctor. He can't tell you what medicine he was under the influence of, what drugs he had just taken. He cannot tell you anything about that interaction. He did say that he was alert, conscious, and able to have a good conversation, but yet the only words coming out of his mouth allegedly are yes, no, I don't know. But he's having this coherent, alert conversation. What logically makes sense? What's actually making sense? He stated he first noticed the vehicle on 85 North just before the split. He admits, I did not know who was driving. I could not see inside the car. He said, I did not receive any information regarding the driver, but he started to narrate as soon as he saw the vehicle. Important to document, important to get those narrations, although he did not do it. In his report, where it is so important to document, it's so important to write down everything. He did not put the position of anyone in that car, anyone in the vehicle, where they were extricated from, where they came out. That's nowhere in his report. And had it been in his report, he would have said it. But I asked him, did you put that in there? You got him out the front seat? No, it's not in there. He said, I do not have dash cam footage to show where anyone was. No dash cam, no body cam footage, nothing to show the positions of the bodies inside of that car. He said he went to the hospital shortly after Mr. Poole was taken and then had a conversation with him. But you all saw the picture of Mr. Poole. No one here can say that that person was capable of having a conversation with anyone at that time of the morning, during that time, after running into a wall at 78 miles per hour, unaware of the medicine, said he was conscious breathing, able to talk, and as I stated, doesn't remember anything or anyone being in the hospital. This was Mr. Poole shortly after. This was the conscious, alert individual that he had this conversation with. That's the person right there. That's what we see. Only record of GSP at the hospital was on 4/18. You saw the pictures. You know what Glasgow is. It fluctuated from 15 to 11 to 14. He was all over the place, which is signs of a brain injury and signs of concern. He was under the influence of ketamine, which causes hallucinations. He was under the effects of oxycodone, which does the same. All of these pain meds. Yet, without any corroborating evidence, he wants you all to just accept that that happened. And as I say, the judge is going to tell you what the law is on corroboration. He jumped to conclusions.
Battery 100%. Connected to STV11 and IOL yarn.
All he had to do was stop. That's what he said immediately after this. All he had to do was stop. There's only one he, and that's Mr. Poole. It wasn't Mr. Jones. It wasn't Mr. Minor. All he had to do was stop with who he was putting this on without any investigation. He said it more than once. All he had to do was stop. That is not an investigation. That is putting blame before you have all the evidence. That is jumping to a conclusion. The narrative wasn't entered, so I'm gonna give you an example of what I was talking about when I said his narrative was all over the place. He said narrative, April 9th, white affinity, and these aren't his words, this is what I wrote for argument and purposes. He said the driver of the vehicle did not stop. He wrote 2 paragraphs, he had another paragraph. He had all of this material, all of these details of what happened in an accident, all of this stuff. And then he says, no, SCRT 03821, skirt securing warrants and charges. And I asked him, you've got all of this stuff on here and then you put this note. And he was like, yeah, that's when they had it on there. And then he said, it was actually supposed to be 037. He made a mistake and put 038. So this isn't even the right case. This is a whole nother case. Things are important. We have 2 lives lost. Details matter. So he put 038-21. Then it says, no, I spoke to Mr. Poole at Grady Hospital. And then he wrote, I asked him this, he responded this, I asked him this, he responded this way, I asked him this, and then he responded this way. That's how the note reads. And then it says another note. Mr. Joe Connors, an EMT, advised me that. That's the statement from Joe Connors. If he advised you, why is it not with the narrative? Why is it not with the body of your police report? Why is it up here? And how is it that your note for Joe Connors comes after this note from Grady Hospital? Then it says warrants were secured on April 16, 2021. His own police report is all over the place. It's that bad. It's so bad that they didn't even want to enter into evidence.
Objection.
It's so
Stop.
bad.
Stop.
Mischaracterization, one, of the law and a misstatement of the law as well.
Right. Disregard the comment about not wanting to enter something in evidence that in fact can't be entered into evidence. Back to you, Mr. Miller.
It's that bad. His testimony at the previous hearing, he said, I walked up and I saw someone crawling out of the passenger side. That was his previous testimony. Mr. Abate got up and said, well, you said wiggle, crawl, is it semantic? Oh, yeah, that's it, semantics. Words mean things. And what you said was, you saw somebody crawling initially. And then he gets in front of you all and changes that to something totally different. He says, I immediately saw one suspect in the front and one in the back. And you all will see the video. When he initially, and I paused because I thought I had took that part out, but you'll see it in the video. When he gets on the scene, he sees one person, and there are questions from all the officers. Is there anybody else? Does anybody see anyone? Do we got anything? And before they even find Mr. Minor, they find Mr. Jones outside of the car. But when he told you all, I immediately saw one person in the front, one person in the back. And again, there is no front, there is no back. There's a roof, and there are two people laying on that roof. He says that he was on the scene during extrication. If that is the case, if he was on the scene during extrication, why don't you all have a video of it? Why don't you all have something showing this is what happened during extrication? The video just cuts off abruptly, I might add. And we don't see where Mr. Poole came from. We don't see where Mr. Minor came from. Investigating a traffic stop is not the same as investigating a homicide. It's not. And the things you have to do to actually prove is more substantial. And Trooper Clark did not do any of those things. He didn't do the smallest thing. And then this is that nursing note. 2300, 11 p.m., Georgia State Police entered patient room to discuss criminal charges. Patient became emotional, heart rate elevated, no chest pain, no dizziness, no other symptoms noted. Officer exit room as he noticed patient's response. Patient requested a phone call to his mother. Mom called with no response. That corroborates Mr. Poole's testimony. He said, I remember him coming one time. And when he came, I didn't have any clue what he was there for. I had no clue why he was there, what he wanted. I didn't know what I was being charged with. Then he says, I called my mom. The very next thing that I did was call my mom. Because they're saying I got warrants, and I have no clue why I would have any warrants. That EMS, that trooper conversation. Remember, Joe Connors never testified that he made any statement to Clark. In fact, he testified, I do not recall making those statements. And like I showed you before, that note, Connor's statement was not noted on his report until after warrants were secured. Testimony was that he received the statements at the scene. Why isn't it in the narrative? Why isn't it with your narrative portion of the police report? Which one is it? This is that car. Again, it's not just side damage. It's the front impact. There is no front to this car. It is the front impact. The people in the front of this car are not going to be in the same position as anyone that is in that backseat. You will see the evidence of their injuries on those two front people. You're going to see internal damage. You're going to see ribs cracked. You're going to see gallbladders ruptured. Why are we saying that this car was hitting from the right side? Like, it may have tried to turn, but ladies and gentlemen, this is front end impact. It hit the front. The extrication of Mr. Poole, I'll submit to you all that Mr. Minor was not fully in that back seat. Because had he been fully in that back seat or the back part of the roof, why'd they take the driver door off? Why wouldn't they take the back door off? If this is where he is, why is this door still here? This is the other side. Look, there's no front to this car. There's no front to this car. It's a front impact, and the person that they're claiming was in the back seat was removed somehow from the front. You got a door right here. You got a door right here. Mr. Minor was pulled out by the front seat, by the front doors. And if he was in the condition that he was in, how would it make sense to pull somebody out through the front? This isn't that two-seater that Mr. Poole had. He's got 4 seats. It's easier for me to get my kids out of the back seat of this car than it is with the two-seater. Why are we pulling people out the front if they're in the back? Remember that logic. Let's think about this. Let's make this make sense. Corporal Lee said he used marking paint for the scene, took pics and video. Force caused this vehicle to flip. You don't know how many times this vehicle flipped, but we do know that this was an impactful, significant crash. You all don't see the front of this car at all. He says that it was a violent crash. And then we talk about the laws of physics. Corporal Lee told you that this crash happened in milliseconds. Milliseconds. And then when I was asked, was there any inventory done of the vehicle? That's not on me. That's on Trooper Clark. This is what your inventory would show. You got a book bag right here. You got more duffel bags and stuff that are laying back there. You got all this stuff back here inside of the car. You don't know who it's belonging to. We don't even know who the owner of that weapon was. None of this was done. This was the investigation that they gave y'all and want you all to make a decision based upon that. when nobody does their job, the crash happened in milliseconds, not my responsibility to do inventory. That's on Trooper Clark. What did Trooper Clark tell you? That's not on me, that's on the skirt team. Everybody's placing blame. No, you do this, you do this, you do this. And then Corporal Lee said, I instructed gas to do a hold on the vehicle. Well, we know there's no hold on the vehicle because a week later, Mr. Poole's family went to the car and actually signed for the car to get scrapped. They actually signed for the car to get scrapped. This car that was involved in a collision that caused the death of 2 people, there was no hold on it. There was no inventory taken of any of the stuff inside of the car. It was just given to the tow yard and a signature for the car to be scrapped was good enough. No one did their job. If they had, we would know whose blood this is. You see it's ripped off. As I said, these airbags did nothing in this crash. Absolutely nothing. You see the blood right here, you see more blood right here. You see you literally see blood drops on the speedometer of this car. If you want to prove something beyond a reasonable doubt, let's find out whose blood this is, because that might help us decide where people actually were. That could help. But we don't have that. We don't know whose blood that is. I submit to you that it's Mr. Minor's. I submit that this blood right here is the same blood that you see coming out of his nose in the medical examiner's pictures. That's what the evidence shows. And it's not the fact, I can see if we got some smoke, we got some fire, we got some other stuff. This airbag is white, completely white. No sign of smoke, no sign of fire over here. Why wasn't this tested? Why do we not have this? Because they did a poor job of investigating and assumed everything that Trooper Clark said was correct. It's gotta be. Let's just make it make sense. But there's too many variables. There's too many ways for people to be in an accident and for their bodies to go. Right here, we know that the accident occurred in a way where the car hit this bridge and then flipped several times. We see that Mr. Jones had impacts here and that he slid down here. Now, your Honor tried to suggest that it's on a bridge, maybe there's a slope, and that was actually the blood running that way. But ladies and gentlemen, if that was the case, why is the blood, we got holes here. Why is the blood not continuous? What this is the initial impact of the body, and this is the final resting place of the body. Now, why is this significant? Because we're talking about physics. That's what they were talking about. We're talking about logically making sense. And if the ejection was on initial impact to the bridge, the body would continue going that way, towards the bridge. Instead, what you have is a car that hits the bridge here. Remember, impact is back here, and then a car that's flipped several times this way. Now, if the car flipping was enough to make a body come out during the flips, why are we expecting anybody to be in the same position they were in? Why do we expect anyone to be in the same position? We were told that the airbags are designed to keep people in. This doesn't look like in. The airbags failed. They did not work, and that's why you have those impressions caused by the steering wheel fracturing ribs, because the airbags did absolutely nothing. It takes a lot to get a person ejected out of a windshield. It wasn't the initial impact. everything else that happened afterwards is what caused this ejection. What makes sense? What logically makes sense? And it would make sense that the initial impact happened, but nothing about this crash makes sense. Nothing about this crash is logical. They told you that this was a significant crash. You don't see these all the time. It's not cars going 78 miles per hour into a wall, overturning, flipping, doing every single thing that it did after that crash. Look at this car. Look at this car. You see there's a hole here, so there's an ejection that happened there. How is this happening? The car's flipping. How is any of this happening? And why do you think anybody sitting in the front would survive? Here's that seat I was telling you about. We don't know what position these seats are in, but we know that they weren't touching the roof. Look at this huge indentation right here on the passenger side seat. These seats are all bent, contorted in different ways. And what could make that indentation? Ribs 4, 5, 6, 7, 8, 9 could. The burn mark on the side of the hip could help make that. This is your impact. Whether it be second, third, I don't know. Could it be the airbags? I don't know. But neither do they. And that's why they cannot take beyond a reasonable doubt where Mr. Poole was sitting. They cannot prove that he's the driver, especially when the person that everybody is saying was the driver has these ribs fractured, which could be caused by the steering wheel, or the fact that this driver's seat is bent and contorted in this way, showing that there was an impact. Look at all the evidence. You don't just say, I saw somebody crawling out the passenger side, he's a driver. Look at all the evidence. Talk to people. Investigate. This debris field is wide. This goes more to my theory that this car flipped more than once. You all see debris everywhere. If it was just a simple hit the car, slam, it would be similar to like a plane crash where the debris is all right there. This debris is everywhere. The car is flipping and stuff is flying. Pieces of the car going every single place. And yet they expect people that are not wearing their seatbelt to be in the same position that they were in. Look at this. If the car hits here, which is what I was trying to explain earlier, the car hits here and then flips over coming this way. Mr. Jones eventually comes out the car coming at that direction at that speed. You all have that picture to look at. It doesn't make any sense. This is a bad crash. And to think that there's only one way for bodies to land and for bodies to be contorted while they're in a car going 78 miles per hour into a wall is crazy. It's crazy. And as I say, it was a head-on collision. It resulted in the car flipping multiple times. People are going all over the car. We don't know how it flipped. We know that it was a violent crash and that it happened in milliseconds. This was the markings that Corporal Lee did. And it shows you, it shows you the path that the car went. And he says you can kind of barely see it, but there is the brake lights, and because they're ABS brakes and lock, that there's going to be light, but that the car is going straight on into here. But he told you it's also trying to turn. Well, ladies and gentlemen, back to that logic, and let's make sense. If the car is coming straight here, but it's trying to turn, then you don't have one set of tires. You don't have the two tires here that are perfectly in line, and you have the two tires here having in line. Instead, if the car is coming this way, then what you would have are the marks that the front tires are making and the marks that the back tires are making. This car went straight into this wall. It was a head-on collision, and then it went up, hit this sidewalk, that put it in the air, hit this, that continued to make it flip, and that's the result of it. That's what happened. This car wasn't turning. Make it make sense. If it's turning, why do you only have one set of tire marks? There would be 4 because the car is going this way. It's sliding. It's a head-on collision. Airbags are designed to keep you in the car, but we all know that the airbags didn't work in this case. They failed. He told you that with the longitudinal changes, 15 to 17 equals serious injury. If above 24 equals serious death. And in this case, it was over 50. And what was the result? The people in the front of the car lost their lives. Dr. Conley's exam was conducted in April of this year. He stated that there are going to be times where the EMS report is wrong. So that part of his job is to find things that may have been missed, which includes brain injuries, which includes what the hospital found, which was fractures in his back, despite the EMS report saying that there was no complaints. Said he needs to continue with treatment, but unaware of any health insurance that he has to continue with that health insurance. What Dr. Conley told you all was that Mr. Poole was not in a state where he could talk. That the medication that he had, it's really simple. He was up here for hours, but it's really simple. He was not in a state where he could talk. There was a lot of things that were missed by the medical providers. That there was no indication on Mr. Poole. He told you the diagnosis. There was no indication of any torso injuries other than a bruised lung. This is a violent crash. And remember, the car went 78 miles per hour into a wall. The airbags are non-existent. You see them ripped away in the other picture. And so you expect something to be on his torso, something to be there, but there's nothing. This was the crash.
Medical care. STD 11 ILLR.
I'm gonna back it up some. I'm sorry about the seatbelt. From the time that the car crashed until the time that Dr. Conley, Trooper Clark, actually comes upon the car, it's about 17 seconds. Remember, the crash happened in milliseconds. And so there were 17 seconds for Mr. Poole to try to get out of this car the best that he could. Count with me. Cars crashed at this point. He doesn't report the crash until he gets to the top of that hill. Yet he's told you all that I could see better than the camera was, but he's supposed to be narrating this. But the crash, you don't hear anything until he gets to the top of that hill where the bridge is. You just say getting off on legs. Car hits the wall, 17 seconds. Now he's reporting. Seventeen seconds. And again, we have no clue what anybody did prior to him arriving. We have no clue what those bodies did in that car. And like I said, to submit to you, I, looking at this, do not believe Mr. Minor was fully in that back seat. What actually makes sense and why the extrication was from the front seat is because part of him was there and the other part of him was in the front. Here goes the en route from Dr. Conley testifies. When they arrived at the hospital, the GCS score is right here. It shows a GCS of 11. And it's signed by Todd Clark. That's the information that we have based off of Grady, who had time to actually evaluate and see everything that was going on, more time than the EMS did. The testimony that we heard from all of the barbers, from Randy Jefferson, from Mr. Williams, from Mr. Harrington, from Mr. Patrick, from Mr. Poole, that they shared everything. The barbershop was a family. Everything that they did was together. That they were literally together for pretty much 24 hours out of the day, 7 days of the week. The barbershop was always open. Mr. Williams, it wasn't out of the ordinary for anyone to be driving anybody else's car. Like I said, they shared everything. Mr. Williams drove Mr. Patrick's truck. He drove it from the bar to when they went to continue their night. And then he drove it from the hospital to Memphis. That was corroborated by Brady, who said, I don't know how House was able to drive. We were all in the car just crying. I don't know how he could drive. It's corroborated by Mr. Patrick. House then drove the truck to Memphis. Leaving the bar is corroborated by Mr. Patrick. I was in the passenger side. House had went to go get my car. And we rode back to handle some more things that night. And then we finally went back to the house. This is corroboration. This is that stacking that I was talking about of evidence. How you know that something is a fact. This is how you put more weight on it. Instead, Mr. Minor would drive, Mr. Poole would be there. Everybody said that. And let me not go that far, because that's not everyone. Mr. Harrington said, I walked out with Mr. Minor, and I walked out with Mr. Jones, and that we were walking to the car, and that I was about to get into the backseat, but there was so much stuff in there that I ended up getting into the car with House. That's what the testimony was. What is that corroborated by? Mr. Poole, we had all our luggage and stuff still in there. I hadn't been to the Airbnb where we were gonna stop at. So my duffel bags, my book bags, all of that stuff was still in that back seat of the car. Mr. Phipps stated, I walked out and Mr. Jones was walking out. And I was just joking around with him. I know that Mr. Minor had the keys. And so me being the old head, I was like, y'all be careful. Y'all need to be careful. I know I can't tell them too much because they're, I'm older and they don't gonna listen to so much, but I told them, be careful driving. They told me that they were fine. He did what he could do, and then he left. He didn't say that he saw Mr. Poole get into the back seat, because he couldn't say that. What he said was, I saw them going, and I saw them walking in the direction of the car. Miss Jefferson said the same thing. She said, I was outside with Mr. Poole and with Mr. Patrick. Mr. Patrick kept on eating Mr. Poole's wings. We were all playing around. There were some ladies or something over there that Mr. Minor and Mr. Jones were walking with as they were going to the car. I can't tell you where Mr. Poole got into the car. All I know is that the three of us were out there playing around and we were all eating those wings. And I know that the other two had left and it was just the three of us there because they had left to go get the car. But she's not going the extra mile. She's not saying, oh yeah, I saw him get into the backseat. That's not what she saw. Corroboration for that. It's all corroborated. Mr. Harrington, we talked about. Mr. Williams said, I left out and Devo, Mr. Jones, and DT, Mr. Minor left out with me. I went to go get the car. I went to go get the truck, Scooby's truck, because he's driving Scooby's truck. Scooby's inside eating, basically doing the same thing that Mr. Poole was doing. DT was going to get Mr. Poole's car. What other corroboration do you have? They pulled up. I saw Mr. Poole get into the back seat of the car. We went down the street about a block. We stopped. I rolled down the window. What y'all about to do? DT, driving the car, said, we're about to make a stop. Don't know where that stop is. Mr. Poole knew that they were going to make a stop, but he doesn't know where that stop is. Mr. Patrick said, he rolled down the window. I'm in the passenger side. I look out. DT is right there. Mr. Patrick said the exact same thing. And Mr. Patrick is the cousin of Mr. Minor. Mr. Patrick is the mentor for Mr. Minor. Mr. Patrick basically raised Mr. Minor. Mr. Patrick is the reason why Mr. Minor is cutting hair. I like to think that I had a good influence on Mr. Minor's life. That's what he went up here and told you all. This is his actual family member. Everybody else calls himself family and blood, but this is his actual blood. And he's saying, my cousin was driving that car when we left. He was in the driver's side. And that was the last time I saw him. That's his cousin. He couldn't even authenticate and go further when I had to show him a picture. He was broken up. He was hurt. He told you that was the hardest haircut I ever had to do, was to cut my cousin's head. after he was deceased. He told you that there were marks on his forehead, that there was indentations on his forehead when he was cutting his hair. Mr. Abate tried to talk about the medical examiner, but what did Mr. Poole, Mr. Patrick tell you? They have a cut behind the ear. He wasn't talking about the cut behind the ear. He was talking about his forehead and what was on his forehead. That was his cousin's testimony. And if anyone was going to say something contrary, it would be his actual blood cousin, the one that he mentored, the whole reason why he cuts hair, the one that he basically raised. That was his testimony. Like I said, they shared everything. Everyone in the barbershop was driving somebody else's car. They were family. You saw the video of Mr. Minor at the club with Mr. Poole's phone. That is sharing at the utmost. What you don't see is people so close that I'm going to take a video on your phone, upload it to your Instagram, and then tag everybody when I do it. That's what we call sharing. I wouldn't do that with my own family, but they were so close that they were at that level where I could give you my phone, have you on my Instagram, upload a video, tag all our friends in it, all our family in it, and it's nothing. We went through this. What is missing from this? The dash cam footage from all the rest of those GSP. And I'm wrapping up. I see you all shifted. The dash cam footage, the DNA evidence, that's your best evidence. You literally got blood on the dashboard. You literally have blood on the airbags of the steering wheel. Why wasn't that blood identified? Who owns that gun? Why is there a gun there? And who was the owner of it? The videos of the extrication. If you really want to tell us that he was in the back seat, show us a video of y'all getting him out the back seat. Why are the doors of the front seat gone? And you have doors on the back seat still intact. He was in a bad condition. The easiest way to get him out is the back seat. Why is the doors on the front, both sides gone? The actual statement. If Joe Connors had made the statement, why isn't it memorialized? Why didn't he get him on dash cam? There's no dash cam evidence of this statement. Nothing. And if it was at the scene, that means you got your mic on you. So we would have heard it in the video, but we don't. Nowhere in the video is that statement. The statement of Mr. Poole, we've gone through that. No, not audio, not video, nothing recording, nothing showing objectively that that even happened. The evidence showing the positions of the bodies. Again, there is no dash cam video that shows the actual positions and where they were. And as I submitted to you, I really believe that it is Mr. Minor halfway in the front and halfway in the back. And that's why that second door was off on the driver's side of the vehicle. You will see people going and looking inside the car from the back. And so I'm not gonna try to hide that and say that they weren't looking in the back. We do see people looking in the back. But you don't see how the bodies are positioned, how they are in the car, and regardless, doesn't matter. The car hit a wall going 78 miles per hour and flipped God knows how many times. Nobody was wearing a seatbelt. Does it really matter? And what else don't you have? All the pictures from this Watch this trooper right here. He's looking on the driver's side, inside the car. Takes a step back, takes a picture of it. Where's that picture? Why don't we have that picture? Why did that trooper take a picture of something on the driver's side? What was there? All the concentration is here on this side of the car where you saw Mr. Poole hanging out. This is from the dash cam. What's that guy doing? Who is he taking a picture of? You need everything, all the evidence that they have, so that you can make an informed decision. And they did not submit all that to you all. You also see blue lights right here. That's another car. That's another dash cam. Where is that dash cam? Mr. Minor was transported by ambulance. That means that somebody was in the ambulance with him. That means somebody did a report. Where is that report? Why don't we have that report? And what could that report say about the position of Mr. Minor's body? You don't have everything. And they want you to make a decision based off a small window of time. And you just can't do that. This is Phipps Place. Now, you all heard the testimony from Ms. Jefferson. I went to go pick up Mr. Minor from Phipps Place. This is where the accident occurred. This is Georgia 400 and Lenox Road. The person most familiar with the city of Atlanta was Mr. Minor. He had already been here for months. Mr. Poole was tired. He had been up all day. That's the testimony they had. He'd been cutting hair at 12:30, drove 5.5 to 6 hours from Memphis to Atlanta, cut 2 more hairs, 2 more heads, went to another location, cut 2 more people's heads, went to an after party, a listening party for an artist, left there, went to the Airbnb, left there, finally got something to eat at a bar and grill. And it's 2 something in the morning at this point. And you know they were there longer than 15, 20 minutes, because Brady said, I took a picture with Scooby about 2:20, 2:25, somewhere around there. I got a picture with me and Scooby at the bar and grill. Mr. Minor was headed home. To get what? I don't know. I don't have any clue. But Atlanta is big. It's not that big, but what makes sense and what is logical is that he got off the exit for his house. Police were chasing him. And you'll see from the video, it looks like he's trying to go right, but there's a car that literally stopped there. And so he can't turn right. There's the exit. Getting off the exit. There's that car. Right there. You see him trying to go right. So he can get to his apartment. He can't go right because that car is right there. What's familiar to him? Getting back to the apartment. Lenox Road exit. In that right lane, trying to go right. The car's right there. They're not going to move. Has to go this way. What's that car? Where are they parked at? Right there where you would go right at. That's where he was trying to go. He was trying to get back to the apartments. Because what are you going to do once he gets back to the apartments? I can run to my room, and what are you going to do? Knock on everybody's door at 3 a.m. to see where I am? The car is not in my name. That's where he was going, was home, to the apartments where he was staying at. The logical, what makes sense? The apartments, exit, less than a mile away from each other. Full investigation would have revealed this, but that wasn't done. Here are the theories that we have. Mr. Minor landed on top of Mr. Poole. There was no switching of positions. He landed on top of him when he flew to the back. Mr. Poole tried to get out the car, easiest way he could. Adrenaline is going. Remember, he has no recollection of this, no clue what happened. Mr. Poole landed his head on duffel bags and book bags in the back seat. That would have caused that cushion. That's his barrier between his head and the door. Suitcases, luggage, book bags, all those book bags that you all saw overturned in the car when it was upside down, that his sister went to go get, that was a cushion. That is what saved his life. Besides being in the back seat of a car going 78 miles per hour into a wall, the fact that he never dropped off all of that luggage, all of the suitcase, all of those bags, that is what saved him. And remember what Dr. Conley said, safest seat in the car is in the back seat. And you all saw that car. There's no such thing as a front seat. There's no such thing as a front of that car. There is only the back. That is the only part of that car that survived.
You've got about 10 minutes.
Really? I'm sorry. I've been talking. So we'll leave it at this. You can run the scenario 1,000 times. You can run this scenario 100 times. You can run this scenario 50. You can run it 10, you can run it 2. And you will not get the same result in this crash. You just can't. There's too many variables. There's too much that could happen. There is not only one way to do this. And they expect that there's only one way. But you can run it twice and it will be a different result in this crash. And then there's the question, why would he run? There's no evidence that he was wanted. There's no evidence that he had no insurance, no evidence that he was on probation. There's no evidence he was the driver of this car. Why? I got family, I have kids, I cut hair for a living. Why am I running from the police? No indication of anything. None at all. You all have heard that I've been with Mr. Poole and his family since 2021. It has been 3 years that we have been fighting for his innocence in this case. 3 years. And now I'm leaving it up to you all. And what I need for you all to do is just follow this evidence, look at this evidence and make a decision off of it that logically makes sense. In order for that to happen, I'm going to need some doctors. I'm going to need some people involved in IT. I'm going to need everybody from Alpharetta. I'm going to need some people that run 5Ks. I'm going to need some librarians. I'm going to need some members of the D9. I'm going to need some graduates of UGA. I need you all to fight for Mr. Poole the way that I've been fighting for him for these 3 years. There's no evidence to suggest that he is guilty of this. Positions in cars do not mean anything when the car is going 78 miles per hour into a wall. Thank you.
Ladies and gentlemen, we're going to take a quick break so you can stretch and move and breathe and use the restroom before the state comes up for its rebuttal. Please don't talk about the case or do any outside research during the break. We'll get you back in here shortly. Thank you.
All right, observe.
Mr. Abate, anything before we break?
No, Your Honor.
Mr. Miller?
No, Your Honor.
All right, let's be back in 5 or 6 minutes. Can you collect all the note cards that are there? And Mr. Miller, if you grab your speaker off the shelf, please. You ready? Don't get them yet. Mr. Abate, you ready?
Yes, Your Honor.
We need Mr. Poole. Do you happen to recall, we had that guy who said, oh, that's my brother, and we got we were trying to figure out whose fingerprints matched whom. I'll get you the details. Yeah, because Judge Carnesale had kicked the case to us, saying, look, you've got this case with him. And he said, no, that other case was my brother. And I looked at the pictures and it didn't look like the same guy. Do you ever remember what the results were of? No, okay. That's all right. I'll send you the info again. Oh, he's back. All right. Let's bring the jurors in if they're ready. You have a different indictment number in there.
All right, the jurors. Judge, the president, count for.
Thank you, Deputy Gordon. Everyone else should be seated. Two things left. We've got the state's rebuttal and then the charge that I have to give you, and then the case will be yours. Mr. Abate, when you're ready.
Thank you, Judge. There's a word in the law that we have when the facts, the eyewitnesses, and the experts all agree, and that's guilty. This defendant is guilty of all charges and the indictment that you heard about and the judge read to you before the start of this trial, of this case. And he remains, or he is guilty now, the close of evidence. After all the evidence has been put before you, ladies and gentlemen, the jury between the state and the defense, all of the evidence shows you beyond a reasonable doubt that this defendant was the driver of his car on April 9th of 2021. That's what the facts, that's what the evidence, that's what the testimony all show. Now, what the evidence does show is that, like we talked at the beginning of this case, that the defendant made deliberate decisions and consciously disregarded the traffic laws of the state, the drivers that were on the road, and his two passengers sat in the backseat of his car. He was speeding on I-75, going 95 at 55 mile an hour zone. Trooper Clark on his radar picked it up and went to follow. Trooper Clark initiated the traffic stop. The traffic stop that when we talked during the beginning, when we were asking questions, that the majority of the people are in the jury pool, and the majority of you sitting before all of us then and here today had experienced. And when a cop, a trooper, any sort of law enforcement pulls behind you, you have two decisions. They light the blue lights up, they turn the sirens on, you have decision to stop and see why they're blue lighting you, why they're attempting to stop you, or do what this defendant did. And what this defendant did on April 9th, 2021, in the early morning hours around 3 o'clock, did not stop his car. He flees from Trooper Clark. He turns off the lights of his vehicle and then begins to maneuver down Georgia 400 northbound until he gets to the Lennox Road exit. When he gets to that exit, he's going approximately 130 miles an hour. How do we know that? How is the speed on the video corroborated? What I'll call the little black box inside of his vehicle. That days later, Corporal Lee was able to download and extract the information. He almost collides with the white box van, which you can see on the video. And as Trooper Clark is approaching the intersection, he sees the car is on fire. Seconds later, Trooper Clark, you can see on his dash cam, literally seconds later, not 17 seconds later, 5 seconds later, he pulls up on the collision, the crash, and you see the defendant pinned in the front compartment of the vehicle, on his back, head out the passenger side of the vehicle, feet towards the driver's side of the vehicle or the car, later described by eyewitnesses who saw his feet in the driver compartment, in the steering wheel area of the vehicle. And we know that motor collision, the defendant, high speed, unable to make the turn, caused the death of his 2 friends, Devin Jones and Darius Minor. And again, you see on the dash cam, Trooper Clark attempting to aid with his other troopers who show up seconds after he does. And they all tell you the defendant is pinned on his back with his head out what used to be the passenger area of the front of the car, and his feet at the driver's compartment steering area of the vehicle. And ladies and gentlemen, if you were to flip this car over, flip it back over right side up, the defendant would fall directly into the driver's seat. He would seesaw, as it was described by Corporal Lee. He'd seesaw back into the driver's seat, because that is the area where his feet were found. And the only reason you see his head out the compartment of the passenger side of the vehicle is because it's gone. All the damage to the car is to the front passenger side of the vehicle. You can't change that evidence. You cannot change the area of impact that Corporal Lee described. There's photographs of it. You'll see about 100 when you go back to Deliberation. And you will see that all the photographs show the area of impact just as described by all of the eyewitnesses. It's uncontroverted. Cannot be changed. That is the area of impact. The area of impact matches the science. It matches the injuries and it matches the eyewitness testimony. Now, how do we know that Kenneth Poole is driving the car? And I know you guys have been hearing us all talk at you for the last 2 hours. I'm gonna try to pick it up and speed up because it's obvious that Kenneth Poole is the driver of his own white Q50S Infiniti on April 9th of 2021. It's his car. He drove that car all the time. He drove it the entire point of that weekend. That's uncontroverted. He said it, everybody else said it. At any point, April 8th going into April 9th, he was driving that vehicle up until it became convenient, up until he killed both of his friends, Devin and Darius. You heard from Ms. Martin, you heard from Mr. Tate, both said that the defendant was driving the car. He was driving the car when he picked up Devin in Memphis, and he was driving the car in the Facebook Live video. Now, defense wants to discredit or say that Jadrian Tate didn't call Devin Jones. But Jadrian Tate from that video that you saw was able to identify the defendant driving, which he admits, and his cousin in the passenger seat. Nothing he said or questioned Mr. Tate about at all shook his credibility, gave you reason to doubt him. What he said he saw is actually what he saw. The defendant driving, his cousin in the passenger seat. And he told you he heard The defendant, while the defendant was driving, and on the phone with his cousin telling the defendant to slow down. Now, how do we know his cousin was telling the defendant to slow down? Because you see it in the Facebook Live video. Corroboration, as defense counsel wanted to put it. Corroboration that Devin Jones was telling Kenneth Poole to slow down at the time that video was filmed in Atlanta, the night that both Notorious Minor and Devin Jones were killed. Because you see the defendant in the driver's seat. The defendant knew that car better than anyone. It's his car. He knew how it handled, he knew how fast he could go. And I'm embarrassed to say, I don't even know how to turn my lights on and off when my car is actually driving. Because all of our cars have automatic lights now. All of the cars, as we drive them here today, the lights are automatic. You have to actually go and find the switch to turn it off. As I sit here and talk before all of you, I have no idea how to do that. And I submit to you, ladies and gentlemen, the reason he was so quickly in that split second as he traveled down Georgia 400 and was able to turn those lights off, because it's his car. He was familiar with it. Again, he knew how fast it could go. He knew how it handled. Now the physical evidence. The area of impact was at the front passenger side of the car. The defendant was found lying on his back across the driver's compartment of the vehicle. Feet towards the driver's side, head coming out of the hole, which was now the passenger side. You heard that from Trooper Clark, Sergeant Gass, Trooper Buffington, Paramedic Larry, now Michael Larry. All of them told you what they witnessed with their own eyes, what they saw, how they watched the extraction for, I think, around 45 minutes. The defendant was pinned in his own vehicle, and he could not get out. You can see in that video when Sergeant Gass and Trooper Clark are shining their flashlights, and you can see Sergeant Gass literally kneel at the back passenger window of the vehicle and find Minor. It says, there's another person in the back seat. You literally see that on the video. That is eyewitness testimony that was testified to, as you ladies and gentlemen watch and listen as he testified from that stand. What's interesting is that if the defendant was in the back seat, he's the only one with motor oil found on his body. There was no testimony that Devin Jones had motor oil. There was no testimony that Notorious Minor had any motor oil on his body, any burns from it, anything about that at all. And that question was asked to Dr. Henniger as it relates to Mr. Minor. It was asked by defense counsel if he had any burns, and he didn't. The uncontroverted testimony is that Mr. Minor had no burns on his body, that there was no burns from motor oil, he had no airbag burns. That is evidence that he was in the back seat of the vehicle, and evidence that the defendant was in the front. Because what's in the front seat, what's in the front compartment of every vehicle, unless it's an electric one, is the motor, is the engine, the oil. And I submit to you, ladies and gentlemen, the reason the defendant is the only one with airbag burns and the only one who suffered from burns from motor oil and had motor oil on his body is because he was the driver. He was in the front seat. Use your common sense. Now, we've heard a lot about physics, the laws of physics. I'm thankful I'm not a physics major and I never was, to be perfectly honest with you. But I think Dr. Henniger, he said it pretty matter of fact and simply. And he said the science, the physics that we were talking about was like high school physics. And that's because it was about objects in motion and velocity, and objects go in the direction in which they're in motion and the velocity was. And that was literally the car hits the point of impact at almost 80 miles an hour, the front passenger area of the car. When it hits that wall, as you heard from Corporal Lee, as well as Dr. Henniger, that the objects inside the car, the people inside the car continue to travel in the same direction as the motion, as the velocity. That just because the wall stops or interrupts that motion, the people inside of it, the objects inside of it continue to travel in the same direction. Which, as Corporal Lee said, that's exactly why, and it's consistent with the defendant being the driver and why his right femur was broken. Because all of his body weight was going towards the front passenger compartment of the vehicle. He described to you, he kind of seesawed as it hit the wall and continued to turn in motion, and it snapped. That's what he described to you. And he said it snapped because of the force of the entire vehicle and the speed in which the vehicle was traveling. And that's why it snapped. That's why the strongest bone in Mr. Poole's body snapped. Because all the motion and all the velocity was all going towards the front passenger compartment of the vehicle. He also, as described by Corporal Lee, that force, that motion was interrupted by not only the wall, but he hit the middle console. There was a whole body, Devin Jones, in front of him as they were hitting the wall. All barriers or obstacles, as described by my co-counsel, as it relates to why Kenneth Poole was found in the position in which he was found. The simplest and shows how intelligent and smart Dr. Henniger was. He's an interesting individual, I can tell you that. And he has a real educational, what I'll say, way to keep you engaged, as well as kind of explain and make things to where you and I were able to understand. And when he sat there with his demonstration, with a simple piece of paper on a manila envelope and paper clips, and he did the demonstration for each one of you. In that demonstration, every position that you were able to put people in or in the paper clips, the outcome was exactly the same. It literally was exactly the same. Everyone moved literally to the right passenger side of the vehicle. There was no way to change that. And you could do it as he did 6, 7, 8 times, 1,000 times. The reason is because the constants in that equation is the direction of travel, the force, the velocity, the motion of the objects. If that doesn't change, everything goes the same way, which is exactly what you saw. You saw a simplistic version of what happened on April 9th, 2021. Mr. Poole's injuries, as we talked about, he had a broken right femur. He had broken bones in his legs, his fibula, and his tibia. He had oil in his eyes and burns from the oil on his arms and his eyes, and he had airbag burns on his face. Then you had the injuries to Mr. Minor. And I want to talk a little bit about the injuries that Mr. Minor had. Now you heard from Sergeant Gass and Trooper Clark in Buffington about where they saw Terry's Minor, that they saw his head on the back passenger side of the vehicle. They saw his feet on the other end towards the driver's side in the back of the vehicle. And Sergeant Gass kind of described it as if he was crunched in the back seat. And when he described crunch, he used hand motions pushing the back passenger side of the vehicle kind of in, which is exactly where the impact, or I guess closer to the area of impact was when the car collided with the wall in the front part of the passenger part of the vehicle.
Battery 100%. Connected to SQP 11 and ILLR.
At least we're at 100%. It's gonna work. Now, what was described through the injuries by Dr. Henniger is that there was obviously a head injury, that he had injuries to his head, but what was described and what was not described is what I'll say. There was no indentation on his forehead. There was nothing related to a fracture on the front of his forehead. That is nothing about what Dr. Henniger described. What Dr. Henniger described, as Mr. Rao questioned him, is that after there's the external review or procedures done on the body as he takes his notes and determines what the injuries are that he can determine from looking at the external outside of the body. He talked about the internal examination. He talked about how the organs, the brain is removed. And to remove the brain is literally the skull is taken off, the brain is taken out. So any indentation that Mr. Patrick may or may not have seen is a result of the autopsy. Because the autopsy happened, the funeral happened after the autopsy. Whether it be a week, 2 weeks later, Mr. Patrick couldn't recall. Now, what's important about the injuries as it relates to Mr. Minor and what Dr. Henniger was able to see and determine, he talked about the rib displacements on the right side, hitting the back. What I would describe as from hitting the back of the front passenger seat. Now, defense counsel showed you this photograph. And if we're seated in the car, ladies and gentlemen, this is your front driver seat. This, ladies and gentlemen, is your front passenger seat. Mr. Minor's head was at this end, his feet were at this end behind the driver's seat. When that car, all the force, the velocity, and the speed in which he was driving hit the front passenger side of that vehicle, his body hit that chair just like that. That's the reason for the indentation. That's the reason for the broken ribs on the right side of his body. That's the reason there's a bruise on his hip the way it was, because of the way he was laying. The physical evidence matches the injuries that Mr. Minor sustained. He also, as you can see, the car is crunched in from the passenger back compartment of the vehicle, where the impact occurred on the passenger side of the car, which, as Sergeant Yass described, was like he was crunched in from the passenger side, which would explain why Mr. Minor had head injuries and injuries to his back as well as his ribs. But what he didn't have injuries to, and I can't take credit for the question, was one of you, ladies and gentlemen, who asked the question to Dr. Henniger when you wrote on the card about the injuries to his lower extremities, to his, I think you actually, whoever wrote the note actually used the word tibia and fibula. I'm assuming, I know you can't answer, it's probably the doctor. But what I would say is, the answer to that question was he had no injuries to his lower extremities, to his legs. And that's because he wasn't impacted there. He was impacted from head down, which is why his injuries go from head down. Both Mr. Jones and Mr. Minor didn't survive because they were both seated on the side of the car where the area of the impact occurred, the passenger side. Those are the facts. You can't change those facts. They're not theories, they're facts. Now, I just want to reiterate some of the impact to the car, because I think there was some confusion. This side is the passenger side of the vehicle. Not the driver's side, it's the passenger side. You flip the car over, you got the driver's side on the right side, and the passenger side where it's supposed to be. But this door is open. And as pointed out by defense counsel on that video, all of the activity, all of the attention was on this side of the car. Because this was where the defendant, Mr. Poole, was extracted from, where you can see him in the dash cam video at all times, pinned on this side of the car. And this, ladies and gentlemen, is the side of the car or where or how Mr. Minor was extracted, which is why the door is open. And if you can see inside of that window, there's what looks like to be a shark. And I know each one of you were paying attention. That book bag was the one that you can see Mr. Minor wearing in the video where they're getting ready to go out. And more importantly, it matches the tattoo that's on the stomach. I won't show it to you because there's no need to, traumatize everyone in the courtroom to look at Mr. Minor's body again. But it matches the book bag. It's the same book bag he had on. It's the same emblem he had tattooed to his stomach. And where is it? It's in the backseat, where he was. Where he was laying when the defendant fled from Trooper Clark and killed him and his friend, Devin Jones. Now let's talk a little bit about the defendant's statement. Defense counsel wants you to believe that Trooper Clark, as he put it, is a liar. He's nothing more than a liar. But what you heard from Trooper Clark, that he's been doing this since 2000, I believe he said 11 or 13, he began as a dispatcher, and that he had been a trooper for the last 6 years. And part of being a trooper is swearing to protect and serve. And nothing that night did you see was contrary to him protecting and serving. He initiated a traffic stop. He attempted to stop a vehicle. As soon as the vehicle collided with the wall, you saw him on the dash cam immediately get out his fire extinguisher and begin to try to save lives. The only life he was able to save was the defendant, the driver, that evening. But nothing you saw from Trooper Clark on that dash cam video or during his testimony indicated that he was a liar, that he wasn't doing his job, and he wasn't trying to protect and serve the citizens of this county and the occupants, all the occupants of that car on April 9th. Now, what you heard that Trooper Clark asked when you went to Grady Hospital was 4 questions. Why did you run? Did you have good reason for running? I don't know, no. Was it your car? Yes, defendant. And were you the driver? Yes. You heard from Trooper Clark that while on scene, he also was approached by paramedic Joe Connors, who said that the defendant told him he was also driving. And you heard from Joe Connors that he was the only Joe Connors who worked for Grady EMT or as a Grady paramedic. He also told you he had gone to over 9,000 calls in his 3.5 years of service with the Grady EMT team. He told you that 6,000 of those calls were after April 9th, 2021. And he told you what he said was he had no reason to doubt that he made the statement. He just didn't have an independent recollection of even being at the scene. That's what he said. That's what he said, ladies and gentlemen. Not that he didn't say it, not that he doubted he said it. He just said he had no independent recollection of even being there. The physical evidence corroborates Trooper Clark. Where the defendant was found, his injuries on his body, again, the oil, corroborates the fact that he was able to make a statement and to speak. Is every single doctor at Grady that came in contact, every single medical professional the defendant came in contact at Grady Hospital that night, found the defendant was alert, oriented with time and place and things of that nature. He was coherent, had no neural deficits, and was able to speak clearly. All throughout those 2,200 and some odd pages of medical records, all indicate those things. All of them. And you know what corroborates that? The EMT's report that you saw, done by paramedic Larry Michael Barry. He found the defendant also to be alert, oriented, and coherent, and able to speak clearly. And what's interesting, at the time the defendant made the statement that he was a driver, he told you, as he sat at the witness stand earlier today, that on that early morning, he didn't know the fate of his friends. He didn't know that his friends didn't make it. He didn't know that his friends weren't going to be able to tell Trooper Clark and all the other individuals involved that he was the driver. Or wasn't the driver, excuse me. He had no idea that they were dead. I see you, ladies and gentlemen. He told the truth because he believed they were still alive, as he told you as he sat there. And you were gonna have both Mr. Jones and Mr. Minor tell the truth based on all the physical evidence, as you know it and sit here today, that the defendant was driving his own car when he fled from the police, when he admitted to you, when he was drunk or had been drinking, and high. Just as all of his friends from the barber shop in Memphis told you that he and everyone else included was drinking and had been smoking marijuana all evening long. Again, this is further corroborating evidence. The statement happened that Trooper Clark was doing his job and protecting and serving. Did he do it perfectly? Absolutely not. But you've got at 3:48 a.m., his GCS or Glasgow Coma Scale was 15. At 4 o'clock when he arrived to the hospital, again, his GCS or Glasgow Coma Scale was 15. You have the narrative from Larry Michael Berry's report that the unrestrained driver was laid on his back or supine across the front seat, head out the passenger door, feet at the steering wheel. Patient was conscious and alert and pinned in the wreckage, requiring a lengthy extraction by AFD or the Atlanta Fire Department. You further have one of the first notes in the Grady medical records. The patient was alert and speaking. Patient was responding to pain. And you saw during the testimony, I believe, of Dr. Connolly, that there were areas in the medical record that said that the patient, the defendant, Kenneth Poole, was under something as a good judgment or his judgment was intact, and his insight at the time was also intact, in addition to him being able to clearly speak and being coherent. Then you got the science that we've already talked a little bit about, the demonstration again by Dr. Henniger, where in all situations, in all scenarios, the paper clips went the exact same way. You've got Corporal Lee, who was an expert and are part of the skirt team of the specialized collision reconstruction team that he specializes and he is an expert in collision reconstruction, which is exactly what you heard that he did when he testified as an expert to just that. He talked about what stuck with me was that he said the two most important things to car manufacturing companies is one, user experience, and two, keeping your butt is what he said in the seat. Keeping your butt in the seat you originated in. That's what he said. And at no point during his testimony was his expertise challenged or controverted by the defense. And I said this earlier, but I want to make it clear that the defense counsel says that you could do this 10, 20, 1,000 times over, that the result wouldn't be the same. But that's not true. That's not correct based on the laws of physics and the science and what you've heard from the experts. And if the constants remain the same, the speed, the velocity, the direction of motion, and the impact or the area of impact is the same, you get the exact same result. You get the exact same result as it relates to positions of where each individual was in the car. Then, as Mr. Rao touched on a little bit, not only do you have the laws of physics, but then you've got physical barriers and obstacles that are made by the manufacturer in an attempt to keep everyone in the seat in which they originated when they got in the car. And as it relates to that, the size of the car, you saw it, it's a compact sedan. There's nothing unusual or not ordinary about it. And you heard Corporal Lee, you weren't calling Captain, I apologize. Corporal Lee talk about how hard and remind everyone of their life experience, which I'm sure they've either observed or done once in their life, to try as an adult to climb from the front to the back to the front of the vehicle, especially a vehicle like a compact sedan, the difficulty that is. What the defense wants you to believe, and what's not reasonable, is that two grown men with the velocity going in a separate direction to where they could meet and climb all of those obstacles and switch seats, literally switch seats. That's not reasonable. That's not what the facts, that's not what the evidence, that's not what the eyewitness testimony was. The other obstacles are the seats again, the headrest, the airbags, the roof, the center console. And as it relates to the roof and the headrest, as you saw, they end up meeting as a result of it, making it virtually impossible for anyone to go over the headrest because there's no space anymore between the roof and the seats. It's not reasonable. And then, like I said, to all of the barriers and obstacles that are built into the vehicle, then you add 2 grown men into the scenario. And how somehow, some way, they can do these gymnastics that defy the law of physics, and they completely switch spots. There's a picture of the seat rest as a result of the headrest, as a result of the collision and the roof of the car. They're touching. How, from looking at this photograph, can the driver of a vehicle go back with the roof of the car touching the top of the seat? There's no space. Not there was a whole lot to begin with, but there's no space anymore. It's not reasonable. Defense touched on this a little bit, but I characterize it as a left turn versus a right turn. Unfamiliar with the area, left turn, familiar with the area, the right turn. Kenneth Poole versus Deliberation Minor. He wants, from looking at the video, wants you to believe or infer that Deliberation Minor was driving the car and he attempted to make that right instead of the left, but there was a car there. 1, there's several ways to make that right, several lanes. 2, it doesn't match the evidence. It doesn't match the facts, and it doesn't match the testimony of the expert witness, Corporal Lee, who showed you in the photographs, in the video from the scene, which are both evidence, the direction in which the car turned. Never once did he testify or does the evidence show that there was an attempt to make a right towards the area in which Mr. Minor allegedly lived. Match the photograph of what we just talked about in the direction of travel. Last I want to talk to you about flight. In the defendant's flight, when Trooper Clark blue lighted, went sirens behind his vehicle after he was speeding and had committed traffic violations. Flight, at the time he should have turned himself in on discharge. It was told you, which he told you, that Trooper Clark told him on April 17th after he got the warrants that he had them and to turn himself in. But he fled. He went home to the barbershop instead of being arrested, and was arrested by marshals, the U.S. Marshals Task Force. And he's still fleeing today, ladies and gentlemen. He's fleeing from any sort of responsibility for his actions on April 9th of 2021, as he sits before you here today. Now, I recently went to the Georgia Aquarium with my 2 nephews. One is just turned 2, and another one actually just turned 5. And I took both of them to the Georgia Aquarium and learned a lot. It was kind of interesting to watch my youngest nephew kind of experience everything for the first time, and the difference between him experiencing it and the 5-year-old who we take it 1,000 times because there's a season pass. And as I was watching my youngest nephew, Lucas, kind of experience all of the things that he was looking and watching. One of the exhibits they were talking about a squid and what a squid does when it's under attack or it feels like it's about to be, and its defense mechanism and what it does. And what I learned is that when it feels like it's about to be attacked, it sprays ink all in the water, making it so it can escape. The water's no longer clear, it's murky, it's black, and whatever is attempting to attack that squid, or the reason the squid feels like it's under attack, he's able to escape. He's able to deflect and distract and deny any danger that they were in. It's exactly what the defendant is doing with all of these, as he put, when he spoke to you, his theories. That's exactly what he's doing. He's trying to distract, deflect, and deny each and every one of you from searching for the truth, wherever you're from. I don't remember where everybody is from the county, but you're all citizens of this county, of Fulton County. And he's trying to deflect you from searching for the truth, seeing the facts and the evidence, and as the eyewitness testimony and the expert testimony unfolded for each and every one. And he's doing that with things like only saw DT in the driver's seat from the individuals who had been in the lounge in which nobody can remember the name. Because several people said that the address was sent to them, but still can't remember the name. But one thing that's consistent from each and every one of them is no one knows anywhere where that vehicle went after it left the lounge. Not a single person could testify where that vehicle went after it left the lounge. And when it left the lounge, it ranged from 2 a.m. to 2:45 a.m., somewhere in between. But everyone was consistent except for the defendant, that they stayed 10 to 15 minutes because of the ticket situation that Mr. Williams detected while they were at the lounge. I want to talk to you about Dr. Connolly. Now, Dr. Connolly is a chiropractor. What he testified to is that he clearly didn't get a full history of the defendant's medical history and as it relates to motor vehicle accidents. He said he looked at everything medical as it relates to the defendant's stay at Grady Hospital starting on April 9th, 2021. But when asked, he didn't look at the CT scan, any images or x-rays, which as he, during his own testimony, said was an important one of the factors of the 5 that he listed. And what was clear that he didn't know necessarily how to express it after it was, became apparent, but he said the EMS report has mistakes in it, that the EMS report as it relates to the back injuries has a mistake and that was missed by the EMT or the paramedic, Larry Berry, despite the fact in the narrative, it clearly wasn't, because Larry Berry was detailed in his narrative and said that he was unable to actually do any evaluation on the back because of the backboard that the defendant was in a neck brace, and made clear that the defendant said he wasn't complaining of any pain as it relates to the back, but was unable to assess his back because of those things. But Dr. Connolly's entire conclusion, based on the 5 factors, because none of the other ones existed, was on one thing. The EMS alleged reporting that the GCS or the Glasgow scale was 11. And you saw in Larry Berry's report that at all times when the EMT was evaluating and recording the things that they were to evaluate, that the defendant was a 15 on that scale range. And that the only thing I challenge, if you choose to look through all 2,200 pages of medical records, there is reference to one on page 8 that the defendant had a Glasgow scale of 11 to 13 and then 11 in one spot, but it said ambulance en route form. It was by an individual who was reporting information who, based on that page in the report, had never even seen the patient, the defendant, because he hadn't arrived yet. Had not arrived yet. It was reported by Tom Clark as something as pre-vital before the defendant arrived at 3:48. He later arrives a little after 4. And what the medical records show, in every point, that every medical professional, doctor, nurse, whoever it may be, who did any sort of evaluation as it relates to the defendant's GCS score during his entire stay at Grady Hospital, fluctuated at best 15, at most a 14, making normal. We talked about Joe Connors and the number of calls that he had responded during his tenure at Grady. Defense counsel said no one can say he was able to make a statement. I would challenge that the uncontroverted evidence is everybody said he was able to make a statement. The EMTs, the troopers, the doctors, the nurses, everyone said the defendant was able to make a statement, speak clearly, was coherent and oriented to time, place, and things of that nature. The bench showed you a report that was not even in evidence and was not even the actual full report during their closing as it relates to Trooper Clark. Showed you snippets of it and hid the rest of it. Indentation on Mr. Minor's head, we talked about that distraction. But let's talk about the defendant's testimony and what we didn't hear. We didn't hear anything from the defendant about his cousin visiting him the next morning. We didn't hear anything from the defendant about his aunt coming to the hospital as the days unfolded after he was admitted. And we heard nothing from the defendant as it relates to his friends down the road coming to the hospital. Now, because he didn't say that and they're not recorded in the medical records, did it not happen? I ask you, did it not happen? They told you it did, but the defendant didn't. And if the defendant didn't tell you, according to the defense, it didn't happen. But I ask you to use your common sense. Of course it happened. Of course they came. They all visited him at the hospital. He just chose not to tell you about it because it didn't correlate with his narrative. It didn't correlate with him being able to respond and talk to people as the medical records and the EMTs, the unbiased people, were reported after this accident. And the defense counsel told you that there was no front of the car, that the front of the car wasn't there, didn't exist. It did, and it did afterwards. The part that didn't exist was the front passenger side. That's the part that no longer existed. That's the area of impact, the point of impact, the reason that both Mr. Minor and Mr. Jones are dead and not here with us today. That's why. Now, ladies and gentlemen, you're about to get to review all of the evidence and all recollect all the facts and the testimonies that unfolded back in the deliberation with each one of each other. And with a guilty verdict, you won't be telling the defendant anything he doesn't already know. The physical evidence, the eyewitnesses, and the expert testimony all prove that he's guilty. He's operating under an old saying that I heard in a movie, but it's originally said by Benjamin Franklin, that 3 people can keep a secret if 2 are dead. 3 can keep a secret if 2 are dead. Well, those 2, Mr. Minor and Mr. Jones, are screaming the secret to you. They are yelling the secret that the defendant was the driver through the physical evidence, through the eyewitness testimony, and through the expert testimony. That's what they're doing. That's what the evidence showed. Follow the evidence and return a verdict that speaks the truth. The only verdict that speaks the truth. And that's that this defendant was driving his own car on April 9th of 2021, fled from Trooper Clark, and as a result of that, killed both of his friends, Mr. Devin Jones and Mr. Terry Minor. Thank you.
Thank you, Mr. Abate. All right, let me get my PowerPoint. Just stretch a little bit because I'm going to read to you stuff that's much less dynamic than what you've been hearing in terms of what the evidence may have been in the course of this trial. But it's important that you focus on this. Couple comments about the jury charge before I begin. Number one, this document from which I will be reading, you'll have with you during your deliberations. So you're welcome to take notes, but don't panic if there are series of legalistic terms that don't click with you. You'll be able to reread this as much as you want during your deliberations. Number two, as I just mentioned, there may be some jargon in here. I am required by the appellate courts to describe certain legal concepts in certain ways. My goal is to make this as accessible to you and me as possible. But sometimes when you're looking at medical records, doctors need to say the anterior cruciate ligament as opposed to saying the thing in your knee. And I need to describe certain things in certain ways, but the goal is to make this as comprehensible as possible. What I'm reading to you will also be on the screen. So if you're a visual person, each paragraph I'm reading from this document or parts of it will be on both those screens as well. Let's begin. A grand jury has indicted the defendant for felony murder, homicide by vehicle, and fleeing and attempting to elude. The defendant has entered a plea of not guilty to these charges. And you'll have that indictment right here with a not guilty plea with you during your deliberations. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. I'll be giving you those elements in just a little bit. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged, or merely raises speculation about the defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. You are bound by those instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law that I'm giving you now to the facts you find. You must decide this case based only on the evidence presented here during trial. And that evidence consists of testimony, what witnesses have said under oath, and the exhibits. Evidence does not include the indictment or plea of not guilty, does not include anything I've said or anything the lawyers have said, to include their opening and closing remarks. And finally, evidence does not include any questions posed. And I flag that because sometimes there were some questions to which objections were lodged. And if I sustain the objection, then whatever was being asked isn't anything you should consider. You may have written a question down that wasn't asked. That is evidence of nothing. It's a procedural fact, I guess you could call it, that your question was somehow not legally permissible. Now, the evidence you have received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I was there, I saw that the light was red when the car went through the red light. Not this case, but maybe in a different case. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. If we had three people walk in right now with umbrellas and their hair was wet and they were shaking water off, that's circumstantial evidence that it's raining out. We can't tell because this courtroom doesn't have any windows that would show you what's happening outside. But you might find the umbrellas, the being wet, as circumstantial proof of the fact that it's raining outside. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make decisions, make deductions, and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses who appeared before you. In deciding this, you may consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, and the probability or improbability of their testimony, their bias for or against a party, and their interest or lack of interest in the outcome of this case. The credibility of a witness may be attacked by disproving facts to which the witness testified. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from several expert witnesses in this case. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. The testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is generally not required, provided you find the witness's testimony to be sufficient. A statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given, and without coercion, duress, threats, use of violence, or fear of injury. The burden of proof is upon the state to establish that the statement was voluntary. If you do not find that the statement was voluntary, you may not consider it for any purpose. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. There is no specific amount of supporting evidence necessary. You must determine whether other evidence, proven beyond a reasonable doubt, sufficiently supports the defendant's alleged statement to justify a conviction. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that happens to be illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows beyond a reasonable doubt that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. Criminal cases must be tried in the county in which the crimes were committed. This question of what we call venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Counts 1 and 2 charge felony murder. For felony murder, the state must prove that the defendant, number 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with what we call malice, which here means the unlawful intent to kill, in order to prove felony murder. And fleeing and attempting to elude, that's count 5, as it's charged here, is a felony. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of fleeing and attempting to elude, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Counts 3 and 4 charge the defendant with homicide by vehicle or vehicular homicide. We use those terms interchangeably. For homicide by vehicle, the state must prove that the defendant, number 1, caused the death of another person, 2, by driving a vehicle, 3, in reckless disregard for the safety of persons or property. The state does not have to prove that the defendant intended to cause the death of the other person. And finally, count 5 charges the defendant with fleeing or attempting to elude a police officer. For fleeing or attempting to elude, the state must prove that the defendant, number 1, was driving a vehicle, and 2, when given a visual or audible signal to stop from an officer whose uniform prominently displayed his badge and whose police vehicle was appropriately marked as an official police vehicle, 3, did not stop, but instead fled. The state must further prove that while fleeing, the defendant did at least one of the following: drove in excess of 20 miles an hour above the posted speed limit, or fled in traffic conditions which place the general public at risk of receiving serious injuries, or drove in reckless disregard for the safety of other persons and property. Ladies and gentlemen, you should consider each count in this indictment individually. The defendant may be found guilty of some, all, or none of these charges. If, after considering the evidence, together with the charge I'm giving you, you should unanimously find beyond a reasonable doubt that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty, and you would check that option on the verdict form for that offense. I'm holding the verdict form now. All 5 counts are listed, and for each of them, it says, we find the defendant, colon, and then there's the word guilty with a blank next to it, and the phrase not guilty with a blank next to it. If you unanimously find that the defendant is guilty of one of those offenses, you check the guilty line. If you unanimously find the defendant is not guilty, as I'll talk about in a moment, you would check not guilty. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, signed by your foreperson and dated. And the second page of the verdict form has a place for the foreperson to date and sign the verdict. By no ruling or comment that I have made during this trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence, according to the laws I'm giving you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon an improper consideration of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is the role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. That rule remains. You have all the evidence in this case, and it would be improper to supplement it with any outside information. To assist you in complying with this instruction, Deputy Gordon will be collecting all your electronic devices, which we will hold while you deliberate. If you don't finish today, we'll give them back. But while you're deliberating, computers, phones, Apple Watches, anything that can talk to the outside world is back in chambers. Going forward, should you need to communicate with me for any reason, it must be in writing. And upon your receipt of your question or note, I will confer with the parties and share with you whatever response I am allowed by law to give. And that qualifying phrase is there for a reason, allowed by law. You may have a great question, but I may have to say, you have to figure that out on your own. Because for whatever reason, I can't wade into that. That would be leaning on the scales or whatever it is you're doing. In particular, if your question is, hey, could you remind us what witness X said about X? I'll be telling you, you have to rely on your collective recollection. We don't replay testimony. Couple things. You'll see in the jury room, there's a big TV on the wall. That has a computer attached to it, and we'll be putting on that computer all the videos that were admitted, the ones the state admitted, the ones the defense admitted, so that you can review those as you see fit. You don't need to come out here and have us press play. You can pause and discuss those videos as you are replaying them. So everything you're remembering about a video, it'll be not on a thumb drive, but actually on the desktop of the computer screen there. And that's all that's on there are those videos and the means of playing those videos. It is a little after 4. We will go as late as you can go as a group. If you all, one or more of you has to end at 5, that's when we have to stop. There's no partial deliberations. All 12 of you need to be in that room deliberating. So you'll let Deputy Gordon know after you get together back there how late you're going to go tonight. We have a cap of about 7-ish, I think, because that's when the last shuttle runs to get you to the parking lots. And if you don't finish tonight, we will start tomorrow at whatever time works for you. If you say 8, it's 8. If you say 10, that's when we'll get together again to start your deliberations tomorrow. Any logistical questions about any of that? All right. I said 12 of you because one of you, Ms. Lampa, you need to stay right here while the other 12 go into the jury room. And I'm going to talk to you individually, okay? So the rest of you go in the jury room. Please don't start your deliberations until we get you the evidence, the verdict form, the charge, and the indictment.
Hold on to the jury.
It's okay. Ms. Lampa, you are our alternate juror. We actually had 2 alternate jurors, but as you learned on day 1, we had to excuse someone. You are alternate only by random numbers, not because of anything else. It's not like, we qualify people differently, but the juror with the highest number, originally, you were number 35. You and one other of the jurors were our alternates. That changed partway through when we had to excuse what we call a non-alternate juror, invisible to you all. But it was important that you heard the same evidence as everyone else because we might need to release another juror, in which case you would join the group of 12 It would then be 11 and you'd make number 12. They would restart their deliberations from the beginning and you would be part of that discussion. I'm going to have you stay here today as long as the group deliberates. If they don't finish today, we'll talk about whether you need to come back tomorrow or just be on call tomorrow. But until they finish, whatever their conclusion is, you actually remain part of the case and need to stay in that information bubble. So no outside research, no talking with people about it. That'll be easy today because you'll stay here. You can keep your electronic devices and you're welcome to use them. We're going to put you in that other jury room over there. Just don't do any research about the case because you may well be pressed into duty as a deliberating juror. Okay? So in a moment, I'm going to have you get all your stuff, whatever you might have back there in the jury room, and Deputy Gordon will get you posted up in the other jury room. I promise we won't forget about you. So if this group says, hey, it's 5 o'clock, we have to stop, we'll get you out here as well and excuse you for the day along with the other 12. Okay? Thank you. Mr. Abate, anything from the state? Mr. Miller?
Nothing from the fence, Your Honor.
Okay, I need two things from you all. One, I need you to go through the exhibits to see that everything's in there. And if there's a dispute about whether something should go out, we'll have that discussion. And then I also need a phone number, one for each side that we can call just in case you happen to have stepped out and there's a question from the jury. Oh, and then finally, I think you had put all the state's videos onto one thumb drive. I need that. And then Mr. Miller, I think all yours are on 19. And so I can just pull them straight off of 19. Thank you. Can you write a good phone number to use somewhere on that card, please? Thank you. All right, so we will be on hold while the jury's doing what it's doing. They can't start till we get them all the exhibits. So if you guys will work on that, we'll get these, start getting the videos uploaded to the device in there.
He believe that, but he do, he still, his clothing line done went up. Oh, he got all the ventures that he done had, that dude, you surprised, he don't take your deal, bro.
I know the first time they went in, they was standing, they were like, oh.
Oh, I think different. That's what he wanted, he did, oh, yeah, that. Oh, that. Yeah, he
I
done.
heard that.
Heard passport, I ain't heard
They
of no
say,
state.
this is go home, man. Why we?
Well, you know what I'm saying? Yeah, I don't take that. Now, get on, they trying to push things, get on the land.
I don't know, they said, go home.
Just go home, you know, we don't say we're gonna go home there.
Why they need help?
What else, I already did it all night. Time with that, time service. No, I think it's time, but you know, they gotta say some kind of way, so I think it is you want home. But it's something they won't, probably like, he said he probably wanna get on stage and say something, he didn't know what to do that. My bad.
What's up?
I got a light on, so.
The lights on? Okay, I think Gordon was checking with them. I just got to mute something here. We can't talk officially yet. We're waiting on Mr. Miller. I just wanted to be efficient with your time. And if you're all in here, then as soon as he walks in, I can excuse you for the day. But rather than wait, you're all ready, so everyone can be seated, and we'll hopefully see Mr. Miller shortly. Do you want to get their electronic devices while we're waiting? Just use the time. Thank you. Or you put the electronic devices? Okay. I can call him again. I talked to him about 10 minutes ago. Okay. Have you all already talked about when you want to be back? Don't tell me yet. I mean, Mr. Miller in here, but you've already sorted out the plan for tomorrow. Good. All right. It'll be a quick conversation. All right, let's get on the record, please. Ladies and gentlemen, Deputy Gordon tells me that you are calling it a day, that you have engaged in deliberations, but you're not at a point yet where you've reached any final conclusions. So we're going to stop for the day. I need you all back tomorrow. What time do you want to be back so I can make sure the lawyers are here plenty in advance of your arrival? 9 a.m. You know exactly how to do that. It's important that all 12 of you be in place before you begin your deliberations. So even though it may be 11 and someone's running just a few minutes late, you can't deliberate unless all 12 people are in the room. I should have said that. You're free to take breaks anytime you want, but if someone steps out just to walk down the hall, go get a soda or whatnot, it's a timeout on deliberations until number 12 comes back in. And you take breaks whenever you want to take breaks. Just have all 12 in the room when you reconvene. And then we'll just be sort of on hold. Ironically, I have jury duty tomorrow. So I have to go check in on the 7th floor, and then they're gracious and let me go back and do work. But hopefully I'm not summoned by a judge to be in another courtroom. They'll have to excuse me from that courtroom if you have questions or you have a verdict, because that takes precedence over jury selection. Never had that happen before, but I may be sitting in a room sort of like you did early last week. Our alternate, ma'am, how long does it take you to get here from work or home, wherever you might be tomorrow? Okay, then I'm going to need you to come in as well, because if we need to release a juror, I don't want to make the other 11 wait for the hour 10, hour 15 it might take to find you and then get you down here. So bring whatever you want to do that might enable you to do work or sleep or whatever worked in that space over there. And then you're just going to be that person who slides in to replace someone if we have to release a juror. All 13 of you, same rules apply, even though you've begun your deliberations, even more so because you're in the midst of your deliberations. If there was some point of disagreement this afternoon, don't go online tonight to resolve it, only to come back tomorrow saying, hey, I looked it up, or I talked to my boyfriend, girlfriend, pet, whatever it is. You solve what you can solve if you're able to solve things. And it's not appropriate to import into your discussions tomorrow something you learned this evening because you talked with someone else or you did any online research. Now, you may sleep on it, pray on it, and think about it and come back tomorrow saying, I got to share with you this insight that I developed. But that needs to be something you did internally and not through discussions with someone who's not a member of your group. We'll start up as soon as all 12 of you are here. We're actually going to take the evidence out of the jury room and we'll bring it back in once the 12 of you are here and you've handed over your electronic devices. Don't bring extra ones tomorrow. Obviously, everyone wants a phone and a way to stay connected. But if you're someone who brought a backpack full of electronics, you won't need all of them tomorrow. You'll want to be able to communicate with folks, but otherwise you'll be deliberating until you reach that point where you're done. Any logistical questions? No? Thank you for your time. We'll see everyone as close to 9 as we can. And really all 13 of you can report to the jury room. Once everyone's here, we'll pop you, ma'am, into your backup jury room. Okay? All right. Thank you, everyone.
All rise with jurors.
All right, Mr. Abate, anything before we break for the night?
Nothing to say, Your Honor.
Mr. Miller?
That's fun.
All right, tomorrow, I need you guys to be closer to the courtroom unless we're on a lunch break, so that when there's a question or a need to interact with you all, we get everyone in the courtroom sooner. Have a good night.